Good morning, everyone. I would like to convene our public hearing for the Government Administration and Elections Committee. We have many bills on our agenda today, and many people signed up to testify, and we may be starting with the best. So with that, I'd like to call on our first person to testify at our public hearing, who is joining us remotely, Jacqueline Glick. Jacqueline?
Hi.
Welcome.
Good morning. To the members of the Government Administration and Elections Committee, thank you for letting me testify. Hello, my name is Jacqueline Glick. I am here in support of Bill HB 6822. As you may know, along with my teacher and classmates, I have been trying to make lollipops the state candy of Connecticut for 3 years. Since I was in 3rd grade, I have been trying to make this official. My first reason why the lollipop should be the state candy of Connecticut is lollipops were invented in Connecticut. In 1908, George Smith invented the lollipop in New Haven, Connecticut. They were named after a racehorse named Lollipop. My next reason why the lollipop should be the state candy of Connecticut is the lollipop is part of our state heritage. My teacher, Mrs. Barbiero, told me, where you live affects how you live because of the place's history. The invention of the lollipop is part of Connecticut's history. You should celebrate this fun aspect of our heritage. My third reason why the lollipop should be the state candy of Connecticut is that most people with allergies can eat them. I have a friend named Emma. She is allergic to avocados, most nuts, latex, and eggs. Lollipops are one thing she's always been able to eat. Some of the most common allergies are milk, eggs, nuts, and shellfish. Lollipops have none of the above. My final reason why the lollipop should be the state candy of Connecticut is most states have a state food or treat. There are about 110 official state foods in the United States. Connecticut doesn't have any. There are state treats like Maine's whoopie pie, state desserts like Missouri's ice cream cone, and state pies, including Vermont's apple pie. Connecticut is ready to claim the lollipop. In conclusion, please vote for Bill HB 6822. No matter what flavor you choose, the lollipop is a sweet choice for the state of Connecticut. Thank you.
Thank you, Jacqueline. Thank you very much for your testimony and your continued advocacy on this issue. And Jacqueline, you may not be able to appreciate this, but I am thrilled that there are other young people here in the room today who got to just watch you make your case for your bill. So thank you very much for your continued advocacy. And I hope that was a bright point for the young folks that are in the room today. Are there any questions or comments from members of the committee? Representative Blumenthal.
Thank you, Madam Chair, through you. Thank you, Jacqueline, for your testimony before us today. I wanted to convey from your representatives on this committee and otherwise, Representative Kristen McCarthy-Vahey and the rest of the Fairfield delegation are very thankful for your testimony and sorry that they can't be here today to tell you that themselves. She's in another hearing, chairing it herself. And I guess I just have one question for you, which is you've been working on this bill for 3 years. Yeah. It's not uncommon for us to be working on a bill for multiple sessions. But my question for you would be, what have you learned through this process?
I've learned so much. I've learned how the government works. I've learned that the government can listen to you if you have an idea or a problem that you want to solve. I just think I've learned so much. This has changed my life practically. And it takes time. And yeah, I've learned that it takes so much time to do it. And yeah.
Well, thank you very much for working on this issue and for working with us more generally. We love to see young people getting involved, and we hope, regardless of what we do on this bill, which hopefully we will move forward. We hope you'll continue to advocate in the General Assembly and in public life more generally. Thank you.
Thank you, Representative. Senator Sampson.
Thank you very much, Madam Chairman. Jacqueline, thank you very much for being with us today.
Thank
I'm just a
you.
little concerned I might have to choose between pizza and candy at some point. But I am also a candy advocate, so I am completely with you on the subject. And I wanted to thank you for being here. Just
Thank
curious
you.
if you have plans for a celebration or something like that, if we can manage to get this bill over the finish line and turn it into law.
Yeah, so we've been wanting to do this since third grade. If this does pass, we want to come for the signing of the bill.
That's excellent. I will look forward to seeing you there. Thank you very much, Madam Chairman.
Thank you, Senator. Any other questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Thank you, Jacqueline, for testifying today. It is such a wonderful experience, and I would encourage all students to take an opportunity to pick out something that you're passionate about and come forward and try to present some legislation to see what we can do to help you. It's a great experience. I'm sure you've learned a lot. I'm really curious, though, what your favorite lollipop is.
So I think I told you this last year, but I make lollipops. So I love the root beer one. I love the lime one. I love strawberry lollipops. But if it's like if I had a bowl of lollipops out and I had to choose one flavor, I'd definitely choose strawberry.
Thank you. Well, I could tell you that my favorite Tootsie Pop is the lemon one, and you can't find them anymore. So there's an activity for you to find me a lemon to make some lemon lollipops, because they are really good, and you can't find them anymore. But anyway, thanks so much for your testimony. I appreciate it, and I'm really proud that the students are getting involved in this process. I think it's so important for today and for your future and for future generations to see what the process is. Thank you very much. Thank you, Madam Chair.
Thank you.
Thank you, Representative. Are there any other questions or comments from members of the committee? Well, seeing none, thank you again, Jacqueline, for your advocacy over the years. And we look forward to working on this bill with you. And frankly, I hope that in 8 years, the lollipop bill will be the law and you will be sitting here in this committee. Thank you, Jacqueline. All right, next, who has a tough act to follow is Casey Lewis, who will be followed by Peter Lewandowski. Welcome, Casey. The floor is yours.
Hi, good morning, co-chairs, vice chairs, and distinguished members of the GAE committee. My name is Casey Lewis, and I am a resident of New Haven. I'm here to communicate my strong support for HB 5702, an act allowing incarcerated individuals to vote. We restore the right to vote for incarcerated individuals, and this bill would do that by providing voting rights for an estimated 10,000 individuals. Through enfranchising prisoners, Connecticut can reduce disparities in the criminal justice system, promote civic engagement, and increase participation in elections. It will also provide these prisoners with a sense of belonging in the community and help set many on the right path once released from prison. Studies show that denying the vote to one person has a ripple effect, dramatically decreasing the political power of urban and minority communities. Connecticut's current laws that don't allow prisoners to vote predominantly impact the Black and Latino communities in the state. When given their constitutional right, many incarcerated people become immersed back in society by engaging in civics. In a 2004 article published in the New Haven Register, researchers found that incarcerated youth in New Haven who voted in a mock election felt more connected to their communities and were more likely to participate in civic activities upon their release. By giving prisoners voting privileges, they would be able to experience the rights guaranteed to them by the Constitution. Connecticut currently has the opportunity to give this back to thousands of people. It's important to lift the voices of minorities, as it will help to reinforce social cohesion, democracy, and equity throughout Connecticut. Before the Maryland legislature, a member of the National Black Police said that voting promotes the successful reintegration of formerly incarcerated people, preventing further crime and making our neighborhoods safer. It's important to regenerate people into society, as it has been found to increase public safety and reduce prisoners' chance of returning to prison. According to data by the U.S. Department of Justice, within 5 years of being released, 82.1% of released property offenders were rearrested, like 76.9% of drug offenders, 73.6% of public order offenders, and 71.3% of violent offenders. As reintegration is successful in lowering these numbers, public safety will see an increase as fewer crimes are committed. Additionally, U.S. News World Report states Connecticut comes in 49th for equality in jailing practices. Voting will give incarcerated people electoral influence and the opportunity to create change in Connecticut prisons. Multiple states, such as Maine and Vermont, have already beat Connecticut to doing this, as they allow incarcerated people to vote. In conclusion, I urge you to give incarcerated people the opportunity to vote. Connecticut promises Connecticut will promise to Connecticut will promote civic engagement for those incarcerated. Will encourage these individuals to become more engaged in political practices. It will also give them a sense of dignity and purposes. Connecticut has a rare opportunity to become a model for attempting to improve prison conditions and offenders' ability to reintegrate into society, allowing minority communities to be transformed. Thank you for your time and consideration.
Thank you. Thank you very much for your testimony this morning. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will welcome Peter Lewandowski, who will be followed by Secretary of the State Stephanie Thomas, who will be followed by Attorney General William Tong. Welcome, Peter. The floor is yours.
Good morning, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished committee members. My name is Peter Lewandowski. I'm the Executive Director of the Office of State Ethics. Thank you for this opportunity to provide testimony in support of 3 raised bills that contain legislative proposals presented by the Office of State Ethics. I've submitted written testimony on these 3 bills, and I'll summarize it here. First, I would like to say a few words about Senate Bill 1151, an act concerning revisions to the state codes of ethics. This bill makes necessary revisions concerning certain definitions under the Code of Ethics for Public Officials and requires provision of certain information in client lobbyist registration under the Code of Ethics for Lobbyists. The bill refers the definitions of quasi-public agency in the codes of ethics to the main statutory definition housed in Chapter 12 of the general statutes that deals specifically with quasi-publics. This change will prevent inadvertent omissions in including or excluding quasi-public agencies in the codes of ethics. This bill also amends definitions of public official under the codes of ethics to include officers elect. This amendment will close a loophole where currently statewide elected officers technically are not subject to the Code of Ethics during a brief period between their election and the date they assume state office. Presently, the Office of State Ethics recommends that they abide by the spirit of the law during such period. Finally, the proposed language requires registered lobbyists to provide the name and contact information for authorized filers under registration filing who are responsible for client lobbyist filings and who could be other than an in-house communicator lobbyist. This will assist the Office of State Ethics in contacting appropriate individuals at the client lobbyist should the office have any questions regarding their filings. The second bill that I would like to bring to your attention is Senate Bill 1152, an act concerning contracting with quasi-public agencies under the State Code of Ethics. This bill extends the open and public process requirements to contracts with quasi-publics. Currently, no public official or state employee or a member of their immediate family or business with which such official or employee is associated may enter into a contract valued at $100 or more with an executive branch state agency, unless the contract has been awarded through an open and public process. The same requirement presently does not apply to contracts with quasi-public agencies, despite the fact that the quasi-public agencies engage in extensive contracting with substantial impact on the state. The added transparency to contracts with quasi-public agencies whenever public officials or state employees are involved will benefit members of the public and private contractors alike, as they will no longer have to second guess whether the contracting process is above board whenever a contract is awarded by a quasi-public agency to a public official or state employee. Finally, the third bill that I'd like to highlight is House Bill 6828, an act concerning conflicts of interest due to an employer other than the state under the State Code of Ethics. The purpose of this bill is to make necessary revisions to the Code of Ethics for public officials by adding a public officials or state employees, other or private employer, and the private employer of such officials or employees' spouse to the conflicts of interest provisions under General Statutes 1-85, which deals with direct and substantial conflicts, and 1-86, which addresses potential conflicts. Currently, under 1-85, a public official or state employee may take official action that provides a direct financial benefit to his or her private employer. The proposed amendment extends substantive conflicts of interest to situations where a public official or state employee takes official action for the benefit of their private employer or the employer of their spouse. It is important to know that under this bill, a public official or a state employee does not have a conflict and may take official action if any benefit or detriment accrues to no greater extent to other similarly situated individuals, members of large groups, profession, industry, or occupation. Under this bill, an elected official who is faced with such conflict involving their employer or the employer of their spouse has to can abstain or prepare a written statement and describe the matter requiring action, the nature of the conflict, and why they can act despite the conflict. The purpose of this requirement is to provide increased transparency. I should note, and this is an important point, that this change will rarely affect members of the General Assembly and only in a situation where the member is dealing with a bill that is exclusive to their employer. Most bills that go through this body apply to an entire industry, to a large group of employers, and very rarely are there bills that are singular to a specific entity. Finally, the restriction on taking official action with respect to public officials' private employer would also be extended to potential conflicts under 1-86. This bill, again, offers a longstanding opportunity to strengthen critical conflicts of interest provisions under the state code of ethics, and I encourage the committee to support it. Again, thank you for your consideration, and I look forward to working with you, and I'll be happy to answer any questions you may have.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Representative Blumenthal. Oh, Representative Mastro Francesco.
Thank you for being here today, Mr. Lewandowski. Appreciate all your work. I had a question on the third bill you were talking about on conflicts of interest, House Bill 6828. And that has to do with, I'm assuming that the kind of prototypical example of a conflict of interest that you'd be imagining for an employer would be some sort of grant or appropriation to the employer.
Correct, and then that's usually that's the case. There has to be some kind of a particular matter that we're dealing with. Yes.
Okay, and so as I'm sure you know, the budget is generally a single bill that gets voted on once, and so I guess could you explain to us how you imagine a legislator who has an employer who's receiving some sort of appropriation in the budget handling that situation under this bill?
Sure, absolutely. So, and this is, thank you for this question. There's a specific provision under agency regulations, the Office of State Ethics Regulation, that exempts a legislator from these conflict provisions in a situation where you have a conflicted matter incorporated into a budget bill, and in that scenario, a legislator may still vote on the omnibus bill, on the overall budget package. However, they have to abstain from debating or making comments on the conflicted matter on the floor. So, for example, legislators may debate the overall budget bill. They may debate other provisions of the budget bill, but in those situations, they just simply have to abstain from commenting on the conflicted matter.
Thank you very much. Thank you, Madam Chair.
Thank you, Representative. Representative Mastro Francesco.
Thank you, Madam Chair. Thank you, Peter, so much for your testimony. I was following along with you online, and I had just a follow-up question to Representative Blumenthal's. When it comes to, so are you saying, so when it comes to grants, so obviously in the budget or the implementer, there's a lot of earmarks that go to certain organizations, and should a legislator be a member of that organization? Are you saying that it's okay for them to vote on the whole package, but they would not be able to speak to that particular earmark? Is that? Well,
if assuming that organization, that outside employer you're faced with a conflict. So if you have a bill that is particular to that organization. If, for example, you have appropriation to an entire, let's say, appropriation, let's use education, for example. You have grants to schools, and all schools receive funding, obviously proportional to what their district that is, proportional to their size and so on. It affects the entire educational system of the state. In that case, you don't have a conflict because it's applied to a large group. There has to be a matter that is singular, that is specific or exclusive to your outside employer, where you, and in that situation, you simply would have to, if that matter is incorporated into a large bill, you have a line item on that budget bill, you simply cannot comment. And that's actually currently in the regs. You cannot comment on that conflicted matter. You may comment on the overall budget package.
Thank you. And through you, Madam Chair. So the same would apply for, let's just say, I'm a coach on a baseball team, and the certain baseball team in town is getting a specific grant or an earmark that's in the budget. The same would apply. Is that correct?
Well, if assuming that coaching is an outside employment for you, if you are a volunteer, you can take official action. Okay. So only if we're dealing with an outside employer, okay. But any a volunteer activity is exempted.
Okay.
Yeah.
And then one more quick question. I know there's some legislators here that they also serve for their local towns. They're on their town council, their board of ed, or whatever. And if a town is getting a specific grant or a bond through the state, would that apply to them as well? And because they are technically employed by the town as well. Some towns do pay their town council members and so forth a stipend. How would that work?
Well, in that case, again, we're looking at, is this bill specific to, for example, fund positions in the town, and it will affect the financial, will provide financial benefit to the official. Then yes, you have a conflict. If it's, however, generic grant that, grants for specific purpose, let's say, again, to fund certain projects in town, then no, it all depends. How is that, is there a conflict for the public official with respect to their position that they hold in the town, in the town? So I would say that a grant that funds certain positions in town, including a public official. If it's a small group of individuals, affected individuals, then yes, you have a conflict.
Gotcha. Okay. Thank you so much. I always try to stay on the safe side when in doubt, question to call you to find out if something is within the scope or inappropriate or not. And you've been really good about that. So I appreciate it. But thank you so much for your testimony.
Thank you. And as a public service announcement, we are your resource. So
yes, you are.
That's
Thank you. Thank you, Madam Chair.
Thank you, Representative. Senator Sampson.
Thank you very much, Madam Chairman. And Peter, good to see you. Thank you for being here. Always appreciate your agency and the great work that you do over there. Just to follow up on this conversation, since we started talking about 6828. And something you mentioned, and I'm reading the language in the bill. You mentioned that if there was a conflict in a larger bill, like the budget or something like that, you could not, as a lawmaker, you cannot get up and talk about that section of the bill. My understanding is that you would still have to make some sort of statement to indicate that conflict exists. Is it? I'm reading language in the bill that leads me to believe you've got to put a written statement together. As a matter of fact, is that true, or is it simple enough to just get up and say I have a conflict with Section 35? I'm not going to speak to that today in my remarks. Through you, Madam Chairman.
Well, very good question. Thank you, Senator Sampson. Just to distinguish, again, using that example of an omnibus budget bill, there would be no requirement because we already have an existing regulation that exempts legislators from conflicts rules. They can vote on the omnibus bill. They just cannot comment on the conflicted matter. Here in the proposal we have, if you have a bill that is exclusive to your outside employer, okay, you would have to prepare a written statement and state on the record why, despite this conflict, you can act in public's interest. So that's the distinction. If, again, only in those situations where you do indeed have a conflict. Conflict does not exist if, again, the bill applies to a large group, an industry, and so on, and also in those situations involving omnibus bills, like bonding package or budget.
Thank you very much. I appreciate that clarification. And thank you, Madam Chairman.
Thank you, Senator. Any other questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you.
Next, we will hear from Secretary of the State, Stephanie Thomas, who will be followed by Attorney General Tong, who will be followed by Colin Kaplan. Welcome, Secretary Thomas. The floor is yours.
Good morning, Madam Chair, Mr. Chair, ranking members. Always a pleasure to be here with GAE. I know you have a full day ahead of you and a lot of bills on the agenda, so I'm going to focus my testimony on some of the bills put forth by our office, but I'm happy to answer questions. First, I'd like to address SB 1150 about risk limiting audits. As many of you are familiar, in 2021, this committee passed unanimously and the legislature adopted the authorization of a task force to look at Connecticut instituting risk limiting audits. That report was finalized last year, and now our office would like to move forward with the adoption of risk limiting audits. We do request one change in section 12 regarding the pilot. We ask that that date be moved from 2023 to 2025 so that we hopefully by that point have the new tabulators on hand, which will be necessary for the implementation. I'm also here to speak on HB 6825. This replaces language in statute that requires election officials to adhere blank stickers to ballots to cover the name of a candidate who has withdrawn from the election after the ballots have already been printed. Just by way of background, that language comes from the days when we used the lever voting machines. And since 2010, the secretary had interpreted the statute so that we could use it with the then new tabulator machines so that election workers could black out the name with a marker instead of putting a sticker on, simply because with a sticker, it can't run through the optical scanners. Even if we have new equipment, none of the new machines allow stickers on the ballots. It can jam the machine, etc. So the only alternative to that, if we didn't change how that ruling read, would be to hand count all the ballots in those races. So this language seeks to codify what we've been doing since 2010, and it changes the language from affix a blank sticker over the name to obscure the name. Next, HB 6824. This would require any election-related challenge under Title IX of the Connecticut statutes to be brought in a Hartford Superior Court. Our office is the administrator of elections, so therefore we're often the defendant in a legal challenge under Title IX. Most people don't realize our elections division, we only have 2.5 attorneys on staff. So this can create a problem. Like last year in 2022, there was a primary, a post-election primary challenge, and the court case ran on for 2 weeks. And one of our attorneys had to be there for those 2 weeks. And as we were going from the primary to the general, that is one of the most time-intensive, labor-intensive times in our office. So we were down a staff attorney. So we feel that it would be a win-win solution all around if all of these cases could be centralized. One, any judges ruling over these cases would have the opportunity to gain more experience in election law, which is some of these courts, the judge has never dealt with an election case. So we're hoping that we can build up more comfort and more expertise in this area. It would also allow our attorneys to handle the cases, but also not let the day-to-day work of the office slip. And because of the size of Connecticut, we also don't feel that it would disenfranchise voters or individuals with a claim if they had to travel to Hartford, which is something we as residents of Connecticut often have to do for other types of paperwork. Also, SJ 35, this proposed constitutional amendment would allow 16-year-olds to pre-register to vote so that when they turn 18, they're automatically registered. And this is basically what happens with 17-year-olds now. If we make this constitutional amendment, we would join 15 states and Washington, D.C., who currently allow 16-year-olds to pre-register. Most studies, any study I have seen, have shown that the younger people get engaged with our civic process, the more likely they are to become lifelong voters. So I'm sure that is a goal this committee shares with our office, and I think all of Connecticut would share. So I urge passage of that bill. And lastly, there are two bills with technical changes to Title IX, SB 1156. This would align the language to reflect our procedures that we've had at the Secretary's office since 2016, following a federal district court ruling, Libertarian Party v. Merrill, regarding who is eligible to circulate a nominating and primary petition. So the language change includes expanding eligibility to adult U.S. citizens who are not residents of the state, and some other technical language changes that resulted from that court decision. And lastly, HB 6823, this language change reflects what's required by the federal government, given the recent passage of the Electoral Count Reform Act of 2022. I urge favorable passage of all of these bills, and I thank you for your time. Happy to answer questions.
Thank you. Thank you for your testimony, and nice to see you today, Secretary Thomas. This is the first time I've had the opportunity to see you here as our new Secretary of the State, our most frequent testifier. So I did want to just give a special welcome to you. Thank you for being here today. Are there questions or comments from members of the committee? Representative Mastro Francesco.
Thank you, Madam Chair. Very nice to see you again, Madam Secretary. I had a question for you on your testimony for SJ 35 for pre-registering 16-year-olds to vote. So are you suggesting that they're pre-registered, they voluntarily do this to pre-register when they're 16, and then when they're 18, it becomes effective?
Yes. Part of the reason states have lowered that age to 16, a lot of students are a lot of young people are getting their learner's permits. So much like the motor voter program, it's a good time when they are interacting with an agency. So it would actually be opt out once they're interacting with the agency, just because that is the current regulation.
So you're suggesting, through you, Madam Chair, is that when they go for their learner's permit, they are automatically registered?
Unless they opt out. Pre-registered.
So is there paperwork that they would be filling out to pre-register? You're just saying it's automatic?
When they automatic in the sense that it's an opt-out system. So much like if you or I went to get our license, they would be getting a learner's permit. Unless you opt out, you are automatically registered or pre-registered in this case.
So, through you, Madam Chair. So if someone was undocumented and they were to go get their learner's permit, how would you check that?
I don't have the form in front of me, but much like if I were getting a license for the first time and I was 30 years old, 60 years old, there is a box, as I recall, attesting that you are a citizen of the United States.
And they're automatically registered.
And,
So,
and we can look into that and confirm for you.
thank you. And through you, Madam Chair, just a follow-up question. I know, a lot of students at 16, they go off to college and they don't come back. And so you're saying if they're automatically registered here in the state of Connecticut at the age of 16, when they're 18, it'll take effect. They no longer live here in the state because they went off to college and maybe they decided to stay there. What do we do about that?
Again, no different than any other resident. You could register at 18 and then go away to college where you vote. It wouldn't change those rules, and how we confirm where people reside also wouldn't change.
So they would have to be a permanent resident of another state. So they're off to college, maybe 16 or 17. Maybe they decide that they don't want to go to college anymore. Now they're a permanent resident of another state. How is that information, that data, filtered back to the state of Connecticut to say that they are no longer registered here?
The exact same way it would for any other citizen.
And which is?
It depends. We are part of the ERIC consortium, and we often receive data that way about change of address. If people register somewhere else, if they notify their town that they have moved, again, it's no different than any other individual.
Okay, thank you. And then one more quick question, because you had mentioned the ERIC. I know lately there has been a lot of controversy about ERIC, the ERIC system. With other states that they don't really have a corporate office. Have you experienced anything like that with the ERIC system? Any data or any controversy at all? How does that really work with the state of Connecticut?
I haven't heard any controversy. As I mentioned when I was here last time, I just left a couple of weeks ago a convening of all the secretaries of the state. And the conversation that's being had has more to do with one of the requirements in ERIC, which is to, as part of the data, states are informed about voters who are eligible to vote but not yet registered to vote. And there is a part of being part of ERIC that requests that states send mailers to those people apprising them that they are eligible to vote. And some states want to do it, some states don't want to do it. And the reasons are myriad. States with automatic voter registration have found that it creates some complications just in paperwork. Other states just don't feel it's their mandate to inform people of their eligibility. So I don't know if it's a controversy related to data, but just process.
Thank you. And I only brought that up because I just recently read an article about, I can't remember what state it was. Maybe it was Alabama or something, where I think it was Alabama, where the Secretary of State down there, or Attorney General, they actually went down there and they had no office. There was supposed to be an office of the actual building, and they were just working virtually. So there was really no staff there at all. So I was just wondering if we had any insight into the ERIC system on that. But I guess that could be a conversation for another time. I'll have to do a little bit more research just to find out where the information I'm looking on that. But the part with the automatically, automatically registering a 16-year-old to vote is very, very concerning to me, because you shouldn't have to opt out of anything. You should always have to opt in. And I get very concerned about anything that's automatic. We've seen other bills and coming forward this year concerning the motor vehicle that you're automatically registered. You shouldn't have to opt out of anything. And I get concerned that these students are away to college. They're not coming back. They're staying there, but yet their residents will now be in another state and they're still in the system. Because people don't really, I'm living in another state. I'm not going to notify the state of Connecticut that I'm no longer in there. So it's really important that those voter rolls are cleaned up. But probably another conversation that we can have down the road. Thank you, Madam Secretary. I appreciate your testimony today.
No, thank you.
Thank you, Madam Chair.
Thank you, Representative. Are there any other questions or comments from members of the committee? Representative Haddad.
Thank you. Thank you, Madam Secretary. We appreciate your time here today. Just on the matter of college students, I have a lot of college students who live in my district. And I just wanted to be clear about something. When you register to vote at 16 or 17, as 17 now, 16, and you move away to college students can continue to vote in Connecticut by absentee ballot. Is that not correct?
That is correct, but I always like to refer to lawyers on all matters of the law. So if one of my colleagues has any.
I'm pretty sure that so long as they have not moved away and they intend to return to Connecticut, I guess that's the question. It was one of intent, but generally speaking, college students are almost always allowed to vote in their hometown where their parents are, so long as they intend to return to the state of Connecticut. I certainly understand the concerns that were raised about having a clean voter file, but there's no reason to believe that college students moving out of state are any different than anybody else moving out of state. But I just want to be, for college students, they're living and residing at the University of Pennsylvania, or God forbid, Duke. They can still vote here. Right, they can still vote.
Absolutely. And please, if there's anything legally that I'm not, and please introduce yourself for the record.
My name is Aida Karini. I'm a staff attorney with the Secretary of the State's office. And you are correct, Representative Haddad, that with the intent to return, a college student does retain the right to vote within both the municipality and the state of Connecticut and federally.
Thank you. It's just to be clear. So if you register as early as 16, then even if you move away for college, there's a period of time for about 6 years after your registered vote where you can legally vote in Connecticut. And I don't know why I'm having this conversation just because I'm very sensitive to the idea of having college students. We want to make sure that they are encouraged to vote, and they're no different than anybody else who moves out of state for any particular reason. So thank you very much for your answers. I appreciate it.
Thank you.
Representative Blumenthal.
Thank you, Madam Chair, and thank you, Madam Secretary. It's great to see you again here back in the GAE committee. I had a quick question about HB 6824, which is the bill that would specify the Hartford Superior Court as the sole jurisdiction for election cases, essentially. And I guess it sounds to me as if the justification from your point of view for the bill is that it would ease the administrative burden and make these cases more convenient for the operations of your office.
Thank you, Mr. Chair. That sounds like it's solely for our convenience, and I disagree with that, in that there are situations where, imagine if there happened to be 3 cases happening at the same time, we couldn't staff it. If on election day, for example, several challenges came up, we couldn't staff it. So convenience, yes, but also protection for people bringing up these challenges. But I think the other point that I raised is equally as important. Like we saw after the primary challenge last November, a lot of the judges just don't have the experience in dealing with these types of cases to know all the ins and outs of what type of remedy could actually work. So we think it would be a great service to the residents of Connecticut if one court could build capacity and specialization in that skill. And please, if there's anything else, feel free to add, but yeah.
So I appreciate that answer, and you're expanding on it. I guess my question would be, obviously there's a trade-off here. It's difficult for your lawyers to go elsewhere in the state, and if witnesses or municipal employees or whomever have to come here, it becomes difficult for them. So I was just wondering, how should we think about that trade-off? And in the context of this bill?
It's a good thought. And we did think of it, of course. In my opinion, most of these cases require a very fast decision. The situation last November dragged on for 2 weeks. And I think some of that was the complexity of the case and getting information, but also the lack of experience. And I know I couldn't cite the cases offhand, but I feel like there have been situations where the leaning of a judgment extended the length of the case longer than it should have. So, it could be that although there is the inconvenience for people to travel, it's a faster adjudication because the judge would have more experience and they could cut through all the parameters more quickly. Of course, that's anecdotal. I have no evidence, but we did consider the trade-off.
Well, I appreciate your answers. Thanks as always for being with us, and thank you, Madam Chair.
Thank you.
Thank you, Representative. Are there any other questions for the second time, Representative Mastro Francesco?
I'm so sorry, Madam Chair. I was, we have these conversations and things just pop into my head, and this is the only opportunity I have to talk to the Secretary of State. In your testimony, I'm looking online, you had sent some information in on ranked choice voting. And you in here, you put in some sample ballots. So my question for you on ranked choice voting is that I'm just looking at, I don't know, one of the sample ballots that you put in, and it just happened to be Leora Levy, Richard Blumenthal and then Richard Blumenthal again on there on the independent party line. Understanding this correctly is this people would make a first, second, third, and fourth choice. So if a candidate is on the ballot twice because they're endorsed by maybe the independent party or Working Families Party, they would put their first choice, if that was that person, as their first choice. And because that same person is on another line, they could put that as their second choice. So that candidate is in fact getting 2 votes. Through you, Madam Chair.
I am not a ranked choice voting expert. So the ballot we put in was to illustrate how long the ballot would be in that given race. I would assume, actually, I have no idea. I'm not an expert.
Okay, I saw
But,
it in your packet, so I was assuming that you were
the ballot design was for purposes of illustrating what I see as one of the challenges, which is getting voters to move through a multi-page ballot.
Thank you. It was, and I'm sure we'll have people here testifying.
I was going to say there will be a lot.
And then there'll be a lot of
people who
testimony,
can
but it's
answer.
interesting that you have a candidate on the ballot twice. They can technically from the same person get the same vote because that could be their first choice. And then they're on another line, that could be their second choice or their third choice. And that was my question, but I'm sure we'll get clarification on that today. Thank you, Madam Chair. Thank you.
Thank you, Representative.
Madam Chair,
Yes.
would I be able to speak to that quickly?
Oh, sure. Thank you.
My name is Matt Frame. I work for the Office of Legislative Research. So for ranked choice voting, how it works is that candidates are given the option to obviously rank multiple candidates. And if a candidate receives the first choice vote, their ballot would only be counted for that first choice. And then as the process goes on, if there are candidates who are considered that for whatever reason are at the bottom of the number of vote getters of the first choice ballots, then those certain candidates get eliminated. So if I as a voter vote for candidate A and candidate A is eliminated, then we then go to my second ranked candidates. So in this case, because the candidates you've mentioned is listed there twice for 2 different parties, they've still been eliminated. So my vote no longer counts. My second choice has been eliminated. Then we would move to my third choice. So you're not voting for one candidate 2 times. We are instead looking at what was your first choice. That candidate now has been eliminated. We go to your second choice. If it's the exact same candidate because they're the same person just listed for 2 different parties, they've also been eliminated. And therefore we move to your third choice. Does that help clarify?
you do have an expert here on ranked choice.
Who's on first?
Thank you.
Thank you very much.
Thank you. Seeing no further questions or comments for Secretary Thomas, thank you very much for your time and your testimony this morning.
Thank you all.
Next is Attorney General William Tong, who will be followed by Colin Kaplan, who will be followed by John Garagosian and Clark Chapin, our auditors. Welcome, Attorney General Tong. The floor is yours.
Thank you, Chairwoman Flexer and Chairman Blumenthal, Ranking Member Sampson, and Ranking Member Master Francesco. Thank you for hosting us here this morning in the Government Administration and Elections Committee. I'm joined this morning by my Chief of Staff, Kara Passero, and also Greg O'Connell, who is the Chief of our Government Fraud Section. And we're here to testify in support of House Bill number 6826, which would expand Connecticut's False Claims Act. Right now, we, like many states, have a False Claims Act that enables the Office of the Attorney General to investigate and prosecute fraud, waste, and abuse in the use of state government funds. However, unlike many of our sister states in the region, including Massachusetts, New York, Rhode Island, New Jersey, Vermont, our False Claims Act is limited only to health and human services spending. And so we can only focus, Greg's group can only focus on waste, fraud, and abuse in health and human services, mostly Medicaid fraud. And since 2009, we've recovered over $181 million in that area alone. But unlike other states, we can't investigate and prosecute waste, fraud, and abuse in other contexts. I should also note that the federal government, acting through the United States Attorney, has a very broad False Claims Act for waste, fraud, and abuse of federal dollars. They exercise that authority here in Connecticut. We don't have that authority with respect to state dollars other than health and human services spending. So what does that really mean to the people of the state? Well, when I get up in the morning, I think people expect that at the Office of the Attorney General, that we have a full range of power and authority to protect Connecticut families and Connecticut residents. And so most of your constituents know that they can call the Office of the Attorney General if they're a victim of a scam, for example, or if they've been mistreated as consumers by a business here in Connecticut or frankly outside of Connecticut. And they can look to the Office of the Attorney General and the Department of Consumer Protection to protect them. If they receive a robocall and they feel like they're targeted again by scammers, they can call the Office of the Attorney General. If they're a family that's been impacted by the opioid and addiction crisis, they know and expect that the Office of the Attorney General will use all of our power and authority to go after bad actors in the opioid and addiction industry and hold them accountable. They also expect that when they hear of and see waste, fraud, and abuse involving state dollars, that the Office of the Attorney General and that I can take strong corrective action to protect the public fisc and make sure that public dollars are spent effectively and lawfully. But unfortunately, our ability in this area is quite limited. So, for example, we saw issues with respect to the spending of federal CARES Act dollars in West Haven. And people called upon the Office of the Attorney General to take action. We were very limited in our ability there because of lack of authority under the False Claims Act. People expect that we could step forward and take action with respect to school construction issues that came to light in the last couple of years. And they were disappointed to hear that the Office of the Attorney General did not have authority to engage on that issue. Also, with respect to the Port Authority and issues related to the Port Authority, although we did conduct an investigation there, and there's also an FBI investigation occurring there. That only occurred because of a whistleblower complaint that was referred to the Office of the Public Auditor, and the public auditors referred it to us. That's the only way that we had a way to investigate misconduct, potential misconduct in that area, and we didn't have broad false claims authority to investigate there. And I know that that's not just disappointing, but very frustrating to the people of this state. And so we believe, as I'm sure many of you believe, that every public dollar is entitled to protection from waste, fraud, and abuse. Every public dollar, not just public dollars related to health and human services, but every public dollar, including the spending of state, including the spending of state funds on local projects, for example, in West Haven or in New London, or with respect to school construction dollars. Let me just note a couple of more points here. The current law covers just 9 agencies out of more than 100 agencies, offices, and quasi-public agencies that spend billions of Connecticut tax dollars. And it's important to note that you will hear a couple of objections to this proposal, principally by representatives of the construction industry. And from what I can glean from their testimony and their opposition, is that they simply don't want to see any accountability in their industry, that their answer is that a few bad apples shouldn't spoil the bunch. And just because there are instances of misconduct and fraud, waste, and abuse, that should not invite the Attorney General to enforce the law and to promote and ensure accountability in the use and spending of state dollars. No accountability is no answer at all, right? That would be the same thing as saying, well, because we have robocall scammers in the telecommunications industry, that we shouldn't have authority to go after telecommunications companies. Or it's like saying, just because there's Purdue Pharma in the opioid and addiction industry doesn't mean we shouldn't have broad authority to go after pharmaceutical companies and distributors that have contributed to the opioid and addiction crisis. That's absurd on its face. And so we're here today to ask this committee and the legislature to do what I think everybody in this state expects us to do, which is to hold bad actors accountable, to make sure that every public dollar is protected from waste, fraud, and abuse, and that we hold bad actors accountable, and that we protect the people of the state from the misuse of public money. And with that, Madam Chair, I'm happy to answer any questions.
Thank you. Thank you, Attorney General Tom.
Thank
Thank
you.
you for your testimony. Are there questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Nice to see you. Thank you so
Nice to
much.
see you.
Thank you for your testimony. I had a question for you on the COVID relief money. And in your testimony, you said that you were limited in scope as to any investigation that you can do. And I'll just use the West Haven incident
Sure.
for an example. Can you elaborate on that? What was your scope? What were you limited on doing?
So I can't speak directly as to West Haven because there's a pending investigation and prosecution there. However, I will say generally that to the extent that there is that there's use of public money. Now, in this case, we're talking about federal money, but to the extent that there's a federal pass through the state, or the state takes federal money and then spends it, we wouldn't have the authority on its face to investigate misconduct involving the use of that state money unless it related to health and human services spending. So I'm very limited in my ability to investigate misconduct related to the use of state funds unless it relates only to health and human services spending.
And that would be with COVID relief money. So if there was a suspicion of fraud and abuse for the COVID relief money that related to health and human services, that is an area that you can fully investigate, or because it's federal money, you are kind of limited in scope.
If that COVID relief money went through a state agency and touched the state government in some way, and then was dispersed to either a municipal or public agency, or maybe a nonprofit, if that money made its way through state government, then yes, I would have the authority, but only in health and human services spending.
Okay, so if it was sent directly from the government to that,
Right,
then
so-
obviously that there's nothing
Right.
that you can do about that. what is the process right now for Health and Human Services? Is somebody suspected fraud and abuse? Does it have to be like a whistleblower or an
It doesn't
employee
have to be a whistleblower. They can, if it's a false claims, a false claims law violation, and I receive a complaint, I can take action. If I read about it in the newspaper, I can take action.
And what do you mean by false claim?
So claims broadly are basically claims on state money, use of state money that in some way is not compliant with state law. And so it can be fraud, it can be waste, it can be abuse, it can be improper billing, improper accounting. There's a wide range of misconduct that qualifies as a false claim.
Okay, and I apologize. When you mentioned false claim, I was more thinking that the person brought a false claim and then there was maybe they found out that you investigated, said it's no longer, it's not a fault, it is a false claim. And now that person who brought that claim forward has to pay retribution or a fee or fine or so forth.
The way to think of it, the way I think of it is you're a state contractor and you use Medicaid dollars, or you can bill the state under the state's Medicaid program. And you come to the state and you make a claim. I'm owed $20 for the services I provide under the Medicaid program. And the claim you make is false or fraudulent, or something about the way you've accounted for your time or the people that you used in providing those services, that there's something wrong with what you did in making that claim to the state.
Okay, thank you. And just one follow-up, and I know there's a lot of talk I've heard over the past year about a lot of COVID relief money going to towns.
Yep.
And I often hear that we should have an audit. So are you saying that because maybe money went to a town, so there were COVID relief, and maybe passed through here, but it didn't go through Health and Human Services, maybe it went to a different department, and maybe it went to a town, there's no action that you can take if you suspected any fraud or abuse?
Under the false claims law, there's no action I could take. It's hard for me to say that there's absolutely no action I could take depending on the circumstances, because it depends on what the misconduct is and how it hits us. That's sort of my lawyerly caveat there. But in general, yes, Representative, that's true. There would not be a point of entry for me to enforce the law using the False Claims Act.
Got it. Okay. Thank you for the clarification. I appreciate your testimony. Thank you. Thank you, Madam Chair.
Thank you, Representative. Are there other questions or comments from members of the committee? Senator Sampson.
Thank you, Madam Chairman. Mr. Attorney General, good to see you. Thank you for coming before the committee. Just a couple of follow-up questions on your testimony. I'm trying to understand the kind of dividing line between what you can and cannot do and how it might be affected by this legislation. My understanding is that your office actually has the ability to prosecute anything to do with a state contract. Are you limited from state contracts dealing with the construction industry, or as you described, anything outside of Health and Human Services? And this is the goal to fix that, or can you pursue an action against somebody for violation of a state contract across state government through you, Madam President? Or Madam Chairman.
With respect, Senator, I don't think that's accurate. So number one, as a general matter, the Office of the Attorney General does not exercise criminal authority. And so when I say prosecute, I mean civilly. I don't mean criminally. And in general terms, except for home improvement contractors, we don't have criminal authority. That's the state's attorney. With respect to state contracts, sure, I can sue someone for breach. So if somebody doesn't perform under a contract because they're in breach of that contract, I can sue them, like any party to a contract can sue another party to a contract. But no, I don't generally have authority to take action against state contractors unless they violated some other law that gives me express authority. I don't generally have the ability to take action against state contractors for misconduct. Except in the Health and Human Services area. And let me just expand on that for a second. The federal government can, right? Our sister states can. but I can't. And I should note a number of the contractors who are objecting to this legislation today and don't want to see accountability here in Connecticut. They also operate in our neighboring states, in Massachusetts, Rhode Island, and New York, and they're subject to a false claims law in those states. The ceiling has not caved in on them there, and yet they don't want accountability here in Connecticut.
Thank you very much for that answer. Just for clarification, I didn't make a statement in my first comment. It was a question, and it was a legitimate question. I wasn't trying to pinhole your answer or anything at all. I just wanted to ask you a tough question and get a real response. That's all.
Yeah.
Just to follow up, you said in your testimony that, you know, these contractors don't want any accountability. I think that's kind of an overstatement, because I'm reading the testimony. I know that this bill has been before the legislature before, and quite a few people. I mean, I think that the vote I have in front of me from 2022 was 24-14 in judice and 33-17 in appropriations. I don't think there are that many lawmakers that don't want any accountability for a specific industry. So I would like to just get on the record. I don't think that's a clear, a very fair statement. They do cite concerns about sensitive proprietary information, due process. I'm just asking for the record, Mr. Attorney General, do they have any concerns? Are they not legitimate concerns? How do you look at what they have to say? Through you, Madam President.
Let me say two things.
Madam Chairman, I keep doing that.
Number
Maybe
one,
predicting the future.
Madam President, may I answer?
Keep saying it. I like it. Go ahead.
Governor, may I answer? Number one, the Connecticut False Claims Act with respect to Health and Human Services has been in effect for 13 years. It was signed by Governor Rell, and it applies to virtually every Connecticut medical provider. And I don't think I've ever heard any of them say that there's been an increase in meritless lawsuits, in inappropriate or overly aggressive prosecutions, and there's no calls for repeal with respect to health and human services providers. And the Office of the Attorney General always respects due process. And in our civil prosecution of cases, we're bound by the rules of professional responsibility and by the rules of court, and by statutes passed by this legislature to make sure that we respect everybody that we engage with, not just as to due process, but as to confidentiality, particularly in consumer protection cases. There are stringent confidentiality provisions that we adhere to every single day.
Well, thank you very much. I appreciate those answers. I'm really on the fence on this bill. To be totally honest with you, I'd like to keep our conversations moving on it. Obviously, I don't want to see any party, regardless of where they come from or what their role is in their connection with our state government, engaging in fraud or abuse that costs taxpayer money. So I'm certainly with you in that respect. I also do feel like I have an obligation to look out for the the rights of my constituents and people that do business in the state. And I certainly don't want to create an environment that might seem hostile to investing or participating in industry in Connecticut. So that's a delicate balance, and we've got to find the right solution. But law and order is important to me as well, Mr. Attorney General, and I certainly respect why you're here today to discuss this. I just look forward to maybe learning more and making sure I have a good understanding of the bill. So thank you for being here today, and thank you, Madam Chairman.
Thank you, Senator. Are there other questions or comments from members of the committee? Representative Blumenthal.
Thank you, Madam Chair, and it's great to see you here, Mr. Attorney General. Thank you for bringing this proposal to us again, and thank you for your testimony and answering all my colleagues' questions. I had a couple myself. There's been looking through some of the testimony on this bill. In opposition to it, there have been statements to the effect that the history of the False Claims Act, I guess the state or federal, has been subject to a history rife with abuse. I was wondering if you could speak to whether you've seen any evidence that that's the case, and what the experience of our sister states and neighboring states has been.
Not only am I not aware of any cases of fraud and abuse in the prosecution of cases under the false claims law. What I do see is an enforcement gap where we could do so much more. And I see how effective we've been in recovering more than $180 million in the Medicaid and Health and Human Services space, and how much more could be done. And I highlighted 3 examples where very public examples where people, the public, the media have been very frustrated about the lack of action, and I'm frustrated by it too. And so I think those are missed opportunities to vindicate the state and its rights to make sure that public money is spent effectively and lawfully. And I look to other states like Massachusetts, for example, that has held contractors, for example, in the Big Dig accountable for misconduct in that huge project. I see the federal government taking action here in Connecticut on cases, small business contracts, for example, where we might have a claim that isn't related to Health and Human Services, but we can't take action while our sister United States Attorney's Office can. So what I see is not a history of fraud and abuse, but of missed opportunity. I guess I would challenge the opponents of this bill to show us a record of fraud and abuse over 13 years of enforcing the false claims law. What we have is a record of $180 million worth of fraud that we've recovered back for the people of this state because of misconduct. Unfortunately, it happens all the time, particularly in the Medicaid space. Greg's section, and we have a number of lawyers and staff who are part of that section here today. They're much busier than they should be, to be honest. And we see a lot of fraud and misconduct in just one area of the use of public dollars, and we need more enforcement powers to hold people accountable.
Well, thank you for that answer. I appreciate it. And I'm certainly sympathetic to it. You know, I see some concern in the testimony about the idea of contractors in particular who make a good faith mistake getting caught up in this law. And just looking at the text of the statute, the knowledge, the scienter or mens rea requirement to be pursued under it is a knowing or knowingly standard, which is a very high standard. And so to me, I would be surprised if the false claims law in our state or in other states would be subject to abuse by their state attorney general or whoever is prosecuting cases under it. Another question we hear sometimes in this space is, you know, the state's attorney has authority, or, you know, the Department of Labor may have authority to look at some of these situations. Why is it important that the attorney general have authority to look at them as well?
So there are cases in which a state attorney, a state's attorney somewhere in the state may have authority. Their authority is criminal only in nature. And so there has to be a criminal violation that's provable beyond a reasonable doubt. And that, as you know, Representative, and many people know, is a very high legal standard. And if you're not confident as a prosecutor that you can make a claim that will pass that legal standard, it's often likely that you won't bring your case because you can't prove your case. But that's only in the criminal context. DOL may have some authority, but that's only limited to their authority over labor issues, as spelled out in the statutes that govern that department. The Attorney General's office, unlike any other office in state government, has a full set of tools, investigative tools, and the staff and the resources and the muscle to hold people accountable. And that's the way state government was designed, to give the Attorney General's office the resources and the authority to hold people accountable and to protect Connecticut families and residents. And so in that way, we're really different than everybody else. And I think people look to us every single day to exercise that authority judiciously, thoughtfully. You know, as I said before, we're regulated by and subject to the rules of professional responsibility and the rules of court. We have to prove our claims too. And so we don't bring cases that we don't feel strongly about, that we don't have evidence to prove. We don't frankly bring cases that we think we're going to lose because we can't prove them. We only bring cases when we feel confident that we've collected the evidence, the information necessary to sustain our claims. And that's why in this state, as frankly in most states, people shouldn't be afraid of meritless claims or frivolous claims because we can't bring those claims.
Well, thank you for that answer. Certainly appreciate it, as well as the work that the office does every day.
Thank you.
Showing how competent it is in handling all these issues. My last question would be, it strikes me that one of the primary purposes of false claims laws generally, and this one in particular, is not just recovering funds that have already been fraudulently obtained from the state, but the treble damages provision provides a measure of deterrence.
Yes.
People who are contemplating defrauding the state look at this provision and say, well, if I get caught, I'm gonna have to pay 3 times back. And so it's not gonna profit me. I'm gonna lose money. So I was wondering if you could speak a bit to the potential deterrence effect of the False Claims Act as it is, or as they are across the country, and also what it means to that deterrence that your office is currently limited in that it can't pursue actions in any area other than the healthcare setting.
Thank you for that question, and I want to thank Senator Sampson for raising the concept of law and order, and a core value and component of any legal, criminal, regulatory regime is deterrence, and the value of making sure that we send a message to bad actors that there are consequences to their actions and their misconduct and their fraud, in order to forestall future bad actors from doing the same thing. And not only is it an important value in House Bill 6826, but the lack of an effective remedy is an anti-deterrent, right? Right now, you have large swaths of the spending of public dollars, large areas in which public resources are used, in which there isn't any effective accountability, at least as far as false claims and the Attorney General's office is concerned. And so while it may be possible that there's some criminal exposure if that can be proved, but right now people can engage in misconduct knowing that there isn't an effective way for me and the Office of the Attorney General to go after them unless it's in the health and human services space. And I have to say that works against deterrence and may embolden or enable misconduct.
Well, thank you for all your answers to those questions. Do we have any other questions from the committee?
Mr. Chairman, if I may, with your indulgence, I do want to say that, and I neglected to do this in my opening testimony, that I also support raised bill number 1157. This is a bill that we've talked about for a couple of years here in this committee, concerning revisions to the Freedom of Information Act concerning employees of public agencies. And I should note that, as we discussed last year, this adds an employee of the Office of the Attorney General, my lawyers and staff, to the list of people whose home addresses and information is exempt from disclosure under FOIA. This is a really important law for all the reasons we've discussed here before. I should note that this is a real life issue for people in my office. There are assistant attorneys general who work in my office right now who have been targeted online on websites. Pictures of the assistant attorney general and his family have been shown. They've been targeted with death threats. And this is on top of the threats that I receive personally. And while I, as an elected official, I guess I accept some level of public scrutiny, I don't think I sign up for threats of violence, but I expect some measure of attention. But I can assure you the law enforcement officials in my office, the assistant attorneys general and staff, they work extraordinarily hard. They take on really tough issues. People get really angry when they're the subject of an enforcement action, and sometimes they retaliate and they threaten people in my office with violence. And it's really important to protect assistant attorneys general and staff
from the threat of violence.
Thank you very much for
Thank
adding
you.
that testimony. Seeing no further questions, I'll end just with a statement about the False Claims Act in particular, which is that I thank you again for bringing it to us. I think it's long overdue that we pass this expansion of it. And it's especially important given the fact that thanks to the federal bipartisan infrastructure law, we're going to see billions and billions of dollars coming into our state for long overdue projects. And we want to make sure that they're spent judiciously with oversight and accountability. So I hope we'll be giving your office the authority to do that. Thank you very much. Next up is Colin Kaplan, followed by John Garagosian and Clark Chapin from the Auditors of Public Accounts, followed by Mirzet Muminovic. Mr. Kaplan, you may begin when your testimony when ready. If you could just make sure your microphone is on so you're in the record, and make sure you state your name.
Yes, my name is Colin Kaplan, and thank you, Mr. Chair and GAE Committee and Madam Chair who will be here. I'm here for pizza. I'm actually here to support SB 390, an act designating pizza as the state food. I'm not only a pizza eater, I am the author of this bill. I really encourage the legislators to support this. I'm a promoter of this bill. I'm also an operator of tourism in this state. And I stand firmly behind the importance, validity, and collective benefits of the pizza bill, as it's been dubbed. This bill has all the ingredients to help boost an already established pizza-based tourism and give more attention to the many pizzerias that produce a high level of culinary artistry. The great state of Connecticut holds a legacy and connection to pizza that no other state can boast. So you may ask, why pizza? Why here? Some of the oldest and highest rated pizzerias in the country are right here in Connecticut. Frank Pepe Pizzeria Napolitana from 1925, Sally's Beats from 1938, Modern Beats from 1934, Zupardi's Beats from 1934, Colony Grill from 1935, Roseland Beats from 1935, Little Rendezvous from 1938. I'm going to keep going, by the way. Mike's Beats from 1942, Rose Restaurant from 1949, Jenny's Pizza from 1935, Salerno's Beats from 1947, the Windmill Tavern from 1935, and Dominic and Vinny's Pizza from 1949. Those are all just pizzerias still in existence prior to 1950, which I've studied. Diversely, owner-operated pizzerias like African-American owned Dough Girls Pizza out of Greenwich, Albanian Italian-American owned pizzeria Zanelli Pizzeria in New Haven, African-American owned Bros Dough in Hartford, and Turkish-American owned Pizza at the Brick Oven in New Haven, to name a few. Very successful pizzerias. We have a documentary on pizza about Connecticut. We have a book about pizza on Connecticut, tours and classes and pizza festivals. And we're part of an over $8 billion annual industry in this state. 160,000 workers in Connecticut's restaurant industry are represented a lot by pizzerias and restaurants that make pizza. There are over 75 cities in this state, in this country, that have New Haven style pizza, which we could also call Connecticut style pizza as a greater determination. And with this bill, the pizza bill, I would like to see Connecticut become the pizza state, and New Haven, which is now dubbed the pizza capital, to continue that resource. And again, this is not just about fun and pizza. This is about economic stimulus and tourism. And I think that would bring us all together. Yes, I hear the bell. And I thank you for allowing my testimony today.
Thank you very much for your testimony. Do we have any questions from the committee? Senator Sampson.
Thank you, Mr. Chairman, and thank you for being here today. You're making me hungry. And I appreciate the testimony very much. I just want to give a shout out to some folks in my district who make some excellent New Haven style pizza. Also, some fabulous places. There are too many to list, but we have great pizza in the state. And I talked to a lot of people who are concerned about Connecticut's economy and a lot of different things. So I'm glad you mentioned that pizza is a viable economic entity in Connecticut. And I can see that. I think there are people that are staying here. Maybe that's one of the last reasons why they haven't left Connecticut, is that the pizza is worth sticking around for. So thank you very much for your testimony. I appreciate it.
My pleasure. It's been fun doing this. I also just want to make a note that I did not submit a written testimony. Is there a way to submit this presently?
Yes, if you want to talk with our clerk, you can submit that testimony after the fact.
Thank you.
Are there any other questions from the committee? I have one question. Why didn't you mention Colleen Grill in Stanford? I'm just kidding. No, you're listed as a pizza guru. I was wondering, is that an official distinction, or is it self-appointed, or is it, you know?
Well, you get to be a guru when you're a teacher. So I've written a book on it. This is my book. And but no, I've self-appointed my name Pizza Guru, but my new name now that I'm into lobbying is Pizza Evangelist.
Well, hopefully we'll all see the light on this bill.
Yes.
I appreciate you being here with us today to support this bill. I agree with all of your sentiments, and I'm hopeful we can add this as more ammunition for us in the pizza wars. I think we've got the best pizza out there, so people should know about it.
I agree. Statewide, 100%.
Appreciate it. Thank you.
Thank you very much.
Next up is John Garagosian and Clark Chapin from the Auditors of Public Accounts, followed by Mirzet Mubinovich and John Fanfara. Just make sure your microphone is on.
Representative Blumenthal, Senator Sampson, Representative Master Francesco, it's great to see you again in person. It's been a few years, and I want to thank this committee for its past support of this particular this bill, or our recommendations in the past. We've had 39 of our recommendations become law since 2014. We're here to testify in favor of Senate Bill 1154, an act implementing the recommendations of the Auditors of Public Account. This bill is nearly identical to Senate Bill 438 from last year, which passed nearly unanimously in this committee and unanimously in the Senate, and did not pass in the House. Regarding Section 1, currently the Freedom of Information statutes exempt records of an investigation and the identity of a complainant in a whistleblower complaint. Now, a recent Freedom of Information case sought the public release of a whistleblower complaint, arguing that it is not a record of an investigation. In May of 2022, the commission dismissed the matter, finding that the whistleblower complaint was not releasable. However, the commission did not extend its ruling to all future cases. I understand that the commission submitted testimony against this bill today. What that testimony doesn't say is in its initial final ruling, it ruled completely in our favor, saying that the complaint was a record of investigation, and it cited a 2002 Attorney General opinion, which said that. And what happened in this case is the commission rejected that final decision, remanded to the hearings officer, and this was basically a compromise, I think, that they came up with. The confidentiality of whistleblowers has been upheld by the General Assembly, by court cases, and the Freedom Information Commission itself. This section is not making the whistleblower process secret. It already is. It already has been. Currently, whistleblowers can publicly reveal their complaints, and they often do. More often, complainants fear retribution. This section is to protect the identity of whistleblowers and the reputations of innocent parties. Section 4-61 DDG is the only statute referencing the public reporting of whistleblower information. It requires our office to annually submit a report to the General Assembly in September, highlighting all the cases that we received and how we disposed of them. Our office also reports on whistleblowers in our annual report each year in February. The annual report includes a listing of all whistleblower complaints received during the preceding year, a general description of each complaint, and whether and when our office reported it to the Office of the Attorney General. The annual report also contains a a general information on the disposition of all complaints. We have a provision where we're allowed to reject whistleblower complaints, and it talks about the ones that we rejected and why we rejected them. And under this provision, nothing would change. We would still file those reports with the General Assembly and the public. I have to say, we take our responsibility to review these whistleblowers seriously, as does the Attorney General's office, and we work hand in hand with Greg O'Connell from the Attorney General's office. Last year, we spent about 7,500 hours reviewing whistleblower complaints. And these hours don't include the hours that we spend on whistleblowers that end up in our audit reports. And I note that one of them is going to end up in our audit report of the Department of Transportation, which will be released shortly. We also report to other agencies, the Office of State Ethics, criminal agencies, and other agencies. We believe releasing these complaints would have a chilling effect on the process. It would hamper our ability to conduct a thorough and discreet review, and may give wrongdoers a heads up that they may be under scrutiny. It certainly jeopardizes the identity of complainants. They're often fearful that their identities will be revealed. Even a redacted complaint might give a indication of who they are. It could lead to fewer complaints and more anonymous complaints. And in the case of anonymous complaints, we don't always have the information we need to conduct a thorough review. Our last concern is that publicly releasing whistleblower complaints will have would lead to malicious filings, such as the case with elections enforcement complaints in your world. The current whistleblower process, which treats the complaint as a confidential record of investigation, allows our office to discreetly conduct its review and determine the validity of the complaint. We report all of our results to the Office of the Attorney General. And if you were going to make changes to the process that would make it more open, we look at the entire process, and we wouldn't be adverse to it, but we couldn't just do this one piece of it without considering all the implications. In the meantime, this change just simply clarifies and protects the current process. Section 2 deals with giving the Department of Motor Vehicles the ability in certain cases to conduct background checks beyond the initial background check. And I know Representative Master-Francesco had some concerns last year. And I just want to say our intent was just in limited cases. It was not to review every single bus driver all the time, but if it came to the attention of the Department of Motor Vehicles that a bus driver had engaged in criminal activity, they should have the ability to do that subsequent check. And obviously, this could be done through the regulation process also, and it doesn't have to be in this bill. It was just to give you an indication it was of importance to us. And Section 3 deals with tangentially with the issue in West Haven. The city's 2020 audit report included a finding and recommendation related to its approved vendor list. The city's auditor found that it allowed purchases without first approving vendors. The auditor found that this could increase the risk of fictitious vendors, limit the ability to obtain the best price, and create unintentional conflicts of interest. We just recommend that the local legislative body have a public hearing to discuss adverse audit findings and potential solutions. And we think this is a potential way to shed some light on the issues. Sections 4 to 8 deal with a change in the name of what was the comprehensive annual financial report, what it is now, which is the annual comprehensive financial report. And it just makes those changes throughout the statute. And the other technical change in this bill has to do when we refer to other agencies. In the case of whistleblowers, the current statute only references state agencies. This allows us to conform to what practices that we can refer it to another federal, state, local, or other appropriate agency, which is what we often do. We refer it to other state agencies, law enforcement, federal authorities, and the like. I'm joined by Clark Chapin, the other state auditor. And Clark, if there's anything you want to add, feel free.
No, I think John did a good job summarizing it, and some of you have heard similar testimony from the prior year as well. So thank you very much for your time.
Thank you very much for your testimony. Are there questions from the committee? Representative Master-Francesco.
Thank you. Thank you so much for your testimony. You know, as you're going through this testimony, you're talking about the bill last year, and I'm going through my head, why did I oppose this bill in committee? And as soon as you said that, it clicked. Is that provision the same this year in this particular bill? Could you elaborate a little bit more on the background checks? It was just random background checks that concerned me last time.
We did a performance audit and a follow-up performance audit regarding this issue. We found that the Department of Motor Vehicles has the authority initially, or these background checks are conducted initially, but they don't have the authority to do it subsequent to the initial licensing. So in certain cases where they're aware of criminal activity or potential criminal activity, we think it was proper that, you know, to protect children across the state, that they'd have the authority. Now, obviously, it could be as narrow or broad as you deem it to be fit. I don't know if it's changed. It seemed like the language just moved a little bit, but we're willing to work with you. And I know the industry submitted some testimony there of concern to them. And I mean, it just is, we were looking for just narrow authority, not broad-based, not every bus driver every year. It was just more in the cases where something came to their attention. They don't have the authority to do that subsequent check.
Right. And I think that's what my concern was last time, that it was so broad. It wasn't really defined. And that was my concern. So I thank you for that clarification.
And that was never our intent.
Right.
Yeah.
I understand that. Thank you. Thank you.
Thank you. Oh, Senator Flexer.
Thank you, Mr. Chair. Good afternoon. I just wanted to thank you both for your testimony this afternoon and your work on this legislation. And I don't think I've had the opportunity to publicly congratulate, I guess it's not new anymore, but Auditor Chapin. It's nice to see you in this role, and congratulations. And two of my favorite former legislators are our state auditors. So that bodes well for the success of this bill moving forward, at least whatever I have to say about it. So congratulations to you, Clark, and glad to have you both here today testifying and working with us moving forward. Thank you.
Thank you.
Thank you. Seeing no further questions, we appreciate your testimony and your being with us today.
Thank you.
Next up is Mirzet Mumunovich, followed by Senator John Fanfara, followed by Vincent Ferricelli. Mr. Mumunovich, whenever you're ready, you can begin your testimony, and just start by introducing yourself.
Dear Senator Flexer, Representative Blumenthal, and members of the Government's Council, I wish my testimony was as delicious as Jacqueline's or the pizza guru's, but my name is Mirzet Mumunovich, and I'm a currently resident of Rocky Hill. I'm here to testify in support of SB 1158, an act designating various days, weeks, and months, especially in support of the number 111 in the bill, the Bosnian Genocide Remembrance Day. This will designate July 11th as an official commemorative day for recognizing those lives lost in Srebrenica genocide and other atrocities during the aggression on Bosnia and Herzegovina. I was born in Bosnia, currently reside in Connecticut for the past 20 years. I am a graduate of Charter Oak State School. I'm currently employed with Hartford Public Schools as a behavior technician. I am a survivor of ethnic cleansing and genocide that took place in Bosnia and Herzegovina in the early 1990s by the Serbian armed forces, whether from Serbia or from Bosnia. Like thousands of other Bosnians, I have lost family members in the conflict, 23 exactly, with the same last name. My mother was taken from our home by the Serbian army in June of 1992 and was never seen again. Parts of her body were discovered 10 years later in a mass grave site, one of dozens, if not hundreds, of similar sites across the entire country. Part of my mother was laid to rest in a local Remembrance cemetery next to thousands of her friends, acquaintances, and families that shared the same fate. 30 years later, we are still searching for her remains. My two uncles, who were also taken by the Serbian army, are still unaccounted for, bodies have never been recovered. My two sisters and I was 8 at the time, my younger sister was barely a year old, were taken from our home by the Serbian army and were taken to Sušica concentration camp in our hometown. From there, several days later, we were transported to a free territory and were united with our father. Unfortunately, I share similar experiences with thousands of other Bosnians, many who currently reside in Connecticut and are in this room here in support of the bill. and who will have a chance to testify. We all have similar tragic story of genocide, murder, imprisonment, and torture. I'm here kindly asking you to help us honor that memory and in supporting of the bill SB 1158, line 112. Future generations in Connecticut can learn about the genocide that took place in the end of 20th century in the heart of Europe. Thank you.
Thank you, sir, for sharing your story. Are there questions from the committee? Seeing none, thank you very much, and we appreciate your testimony. Is Senator Fonfara present? Next is Vincent Faricelli, followed by Senator Saud Anwar. Is Mr. Faricelli here? Hopefully I'm pronouncing his name correctly. Faricelli, thank you. Yeah, wasn't as good as I thought. All right, next up is Representative Anthony Nolan, if he's present. Not seeing him. Next is Deborah Shander or Scander from the Connecticut State Libraries. Whenever you're ready, you can begin your testimony.
Senator Flexer, Representative Blumenthal, members of the committee, good afternoon. I'm Deborah Schonder. I'm the state librarian. I'm joined by Brad Bullis, who is a member of our library staff. We're here to speak about HB 6829 concerning fair terms and contracts and licenses for electronic books for libraries. We appreciate the opportunity to share our perspective with you today. The advent of ebooks in both text and audio form dramatically shifted the relationship between libraries and publishers and has moved us from traditional purchases to renting collections through licensing. These licenses are undeniably crafted in ways that benefit publishers to the detriment of libraries and greatly affect our mission to provide equitable access to all. Libraries face significantly steeper costs than consumers. We pay those costs again and again to maintain access to the same content. We are limited in who we can lend those resources to and for how long and in what way. And we may not even be given the option to acquire them at all. Our autonomy to make decisions about how to lend ebooks has been taken from us. We've had to surrender our mission of access to the terms publishers put in these licenses. Thanks to 2013 legislation, Connecticut first conducted a study in this matter, and then in 2015 allocated bonding funds to the state library to develop the first statewide ebook platform of its kind in the country. But these measures are not enough. The underlying issues that led to that study, that led to the creation of that platform remain, and they continue to impact every library in the state and across the country. In recent years, legislators and librarians from across the country have questioned the existing model through bills like HB 6829. Every bill has faced significant legal pushback from publishers. They obscure the issues with talk about federal preemption and conversations about the free market. But that is all their words are, obfuscation. Here are the facts. In order to acquire an electronic book for its collection, a library's only option is a license offered on unsustainable and unfair terms. And Connecticut has the right as a state to say that the terms of these contracts, these licenses, are unfair and they are discriminatory, and to pass legislation which is equitable for libraries and publishers alike. We know from past response that this is a complicated matter. Any legislation that Connecticut passes must be comprehensive and responsive to the need of every library type because there are diverse libraries across the state and citizens that we serve. We ask that you address the concerns of public libraries and research libraries. Consider the leisure reader and the person who relies on the library for their every book. Remember that some of us like audiobooks and some of us need audiobooks. Make it clear that the libraries are the ones who can determine what is an equitable price, not the publishers. It is not our desire to remove publishers from this conversation. We will continue to pay for the materials that we want. We will continue to support authors with our purchases and our recommendations. But as it currently stands, the relationship between libraries and publishers on electronic books is too unbalanced. They should not be able to continue dictating a library's mission through unreasonable terms. Thank you.
Thank you, Ms. Schonder. Are there any questions from the committee? I will ask you one. Could you describe a bit for us? You mentioned that there are certain restrictions on how you can lend ebooks. How does the treatment, how do the terms that you're subject to different from the terms that a private ebook purchaser would have?
Absolutely. So one thing to talk about first is when we're talking about ebooks, you are not purchasing it at all. You're purchasing a license. You don't own that content. You could actually, a publisher could actually take that book from anybody, whether it's on a private Kindle or from a library book. So we've gone from a traditional model of ownership to simply a license to access. And if you're a consumer, I can go onto Amazon and I can buy a book for $14.99 the day it's released. I could wait until it's on sale for $1.99, and I have that choice. Libraries have no choice in the costs of the books that they purchase. They are typically 3 to 10% higher than any other. They cost 3 to 10 times more than any other consumer is asked to pay. So if I pay $1.99 as a consumer, a library might have to pay $55, $65, $90 to purchase a license to access that book. And then it expires within typically 2 years. That is the current primary model for these licenses. A library can either purchase something for 2 years or 26 loans. If you've borrowed a book from your library before, oftentimes library checkout terms are 3 weeks. If you multiply 3 by 2, you can't even get to 26 loans in the course of 2 years. So essentially, taxpayer money is being spent to purchase access to these licenses that doesn't even get used in the course of the terms. So that is one of the terms. And so what we're looking for is better opportunity to negotiate for those costs, negotiate for choice in terms of how we access it, depending on the type of library that you are in. An academic library might be looking for perpetual access. They are typically wanting to purchase those so that faculty members, students, researchers can use those books long-term. As you would see, a public library might be interested in getting the latest James Patterson for as long as it's popular until the next James Patterson comes out. So we are looking for an opportunity to have some negotiation on that. But what we are seeing is we are having to spend significantly higher costs over and over again. Our collections essentially vanish from the shelves in this current model, and that money has to be spent over and over again. So we're not even able to create collections in the way that we used to under this current model.
Thank you for that answer. I'm sure we'll hear testimony from publishers on the other side opposing any sort of rebalancing of this relationship. Would it be fair to say that you're not looking to determine a certain set of terms, but really rebalance the negotiating power or allow yourselves some negotiating power in this relationship?
Absolutely. So one of the things we've seen with publishers in the past with previous bills, those previous bills often said it created a mandate. Publishers must sell under X terms. And that is why we often saw pushback in other states. The bill that's currently before you today does not make that a mandate. It says, if you sell, here is what Connecticut says is an equitable term that we want to talk about. But we, as I said, we may be interested in different terms depending on the different circumstances. We will continue to buy these resources. We just want to be able to make sure that the balance between what we're spending and what we're able to provide is more fair across the purchases that we're making.
And one particular provision I'm interested in is that it's my understanding that in at least some of these contracts or licenses, you are not permitted to share with any, one library in Stanford is not allowed to share with the library in Norwalk the terms that they paid or agreed to with regard to these books. Can you speak a bit to that?
Absolutely. So Connecticut is a leader in lending in the traditional print model. So we, for example, have the right for anyone in the state of Connecticut who has a library card can go into any other library, borrow a book and return it to whichever library that they would like. Or you can request a copy that is in an academic library and it can go to you in a public library and you can use it. So there is rich resource sharing already that's been in existence in Connecticut. And so your question about interlibrary loan in the licensing model is that is typically not something that libraries are able to do with electronic content at all. It is protected by digital rights management. We would continue to protect these through digital rights management, but it would allow, it means that a library that is having to pay significantly higher costs to access the resource to begin with is limited in how long it can keep it, can't even then lend it to somebody who lives just across the municipal line or just across the state. So what we are hoping to see in this bill is a freedom, a greater increase in freedom for that as well, while continuing to maintain digital rights management, because we will want to make sure that the publishers and the rights of these authors are protected in terms of the lending, but simply the greater increase in the ability to share among Connecticut residents.
Thank you for that answer. And one more question. In addition to the interlibrary loan situation, I've noticed in your testimony that you indicated that there are often provisions in these licenses saying you can't tell other libraries what you paid. They can't tell you what they paid. There's no opportunity for sharing that information about these negotiations at all either. How does that affect your ability to negotiate?
Absolutely.
For these
Absolutely. It's a
books?
great question. And it essentially is what you said, we can't talk to each other. So we can speak in general terms. We can say, well, we think these are what the costs are, but we are not actually able to speak to our colleagues and say, did you get a deal? What are you paying for these books? What were you able to negotiate? We're not able to do that, but then we're also not able to share information and address this in a collective manner, which is what we're also hoping to address here.
Well, thank you very much. We appreciate your testimony here today. I certainly appreciate you indicating that you're willing and interested in working with us and working with publishers to try to find a solution here.
Absolutely.
You know, based on your testimony and reports from libraries across the state, it certainly seems like there's an imbalance in this negotiating relationship. And I certainly think that while publishers, copyright holders should certainly be paid for their work and the holdings that they have, the state of Connecticut and its library system should not be at a disadvantage vis-a-vis the private consumer. That certainly doesn't seem right, especially as a bulk purchaser, essentially. So we appreciate your testimony here today, and we look forward to working with you on this bill.
Thank you so much.
Next up is Douglas Lord, followed by Colleen Murphy.
Good afternoon. Co-chairs Flexer and Blumenthal and Representative Bronco. Thank you very much for the opportunity to testify in support of Raised Bill 6829. My name is Douglas Lord. I work at the CH Booth Library in Newtown. I'm the president of the Connecticut Library Association, which is a member-driven group of almost 800 librarians throughout all of Connecticut. And on behalf of CLA, I speak for membership in support of this legislation. You have seen written testimony from many librarians and library adjacent organizations. You will also be hearing from many other very smart and very dedicated librarians today about this exact issue. The cost for ebooks and digital media is a runaway train, and it has been for many years. And this legislation has the opportunity to fix that. I'm glad, Representative Blumenthal, that you brought up the prospective opposition to the legislation that tended to rely on federal copyright law. But this particular legislation has nothing to do with that. It's strictly contract law focused. And it provides, focusing this bill on contract law provides Connecticut to potentially be the first in the nation to reel in these costs to benefit all of the taxpayers in the state. It's about sustainability and also about equity. I also appreciate that you brought up that libraries and publishers are not enemies. We never have been. Libraries believe in providing patrons access to materials that they need, but the pricing structure at the moment is not advantageous to libraries, and it is very advantageous to publishers. All we're asking is for the opportunity to negotiate a fairer price, just like any other public funding contract, from road salt to Wi-Fi access to energy efficiencies, what have you. Libraries do not want to stand in the way of commerce. We understand the profit motive, and indeed publishers have been in a intrinsically supportive relationship with libraries for many, many years. Both sides completely understand this relationship. We're just looking for a bit more equity. Thank you very much for the opportunity to testify. We really appreciate it.
Thank you very much for your testimony. Are there any questions from the committee? Questions? Seeing none, we appreciate you being here with us today and your testimony,
Thank you, sir.
along with all your work on behalf of our state libraries. Seeing no questions, we'll move on to Colleen Murphy, followed by Senator Fonfara, followed by Senator Anwar.
Good afternoon, Representative Blumenthal, Senator Flexer, and members of the GAE committee. I'm Colleen Murphy, the Executive Director and General Counsel of the FOI Commission. Thank you for the opportunity to testify today on 4 bills before you, all of which we provide more elaborate written testimony on. So I'll try to keep things a little bit short, but bear with me as there are 4 bills. First, the FOI Commission strongly supports Senate Bill 1155, an act implementing recommendations of the FOI Commission, which seeks to amend various provisions in the FOI Act. The amendments are largely for cleanup purposes, if you will. The bill seeks to clarify and update certain terms in the Act, such as governmental function in situations where government contracts with a private entity to perform such a function. It also amends the word educational records to mirror the phrase used in the Family Educational Rights and Privacy Act, or FERPA, and the term handheld scanner to update and modernize the mechanisms by which the public may make copies of public records. There are no changes to the fee structure with regard to such copies in this proposal. Section 4 of the bill eliminates certain training requirements that the commission was required to conduct that really have nothing to do with the commission or its mission, specifically smoking and vaping. We're not experts on that, so we'd like to eliminate that requirement. Section 7 of the bill allows for electronic transmission of special meeting notices to members of a public agency. That's just to go along with other updates regarding electronic transmissions that were added to the act during the pandemic, essentially. So it will speed up notifications to agency members. Additionally, Section 11 of the bill ensures that the appropriate parties are named in FOI appeals regarding safety and security. We consulted with, I guess, the 2 biggest stakeholders in this area, DAS and Emergency Services and Public Protection, regarding these changes, and neither objects to them. We thank the GAE committee for raising these proposals. So that's probably the easiest one because we support it. The other 3, we are here to speak in opposition. The commission opposes Senate Bill 1157, an act concerning revisions to the FOI Act concerning employees of public agencies. Section 1 of that bill proposes to add certain classifications of workers to the list of public employees in 1217 of the FOI Act, whose residential addresses may be protected from disclosure. The new classifications are for judicial marshals. However, for that one, we specifically note that they are already covered, we believe, as are employees of the judicial branch. So we think they're already covered. Then the others are employees of the Office of Attorney General and 2 individual categories of employees within the Department of Aging and Disability Services, those within the Disability Determination Services Unit, and those within the Bureau of Rehab Services. The concept of adding classifications of workers whose home address would be, quote, protected has for the most part been opposed by open government advocates for years, and not because advocates don't care for the safety and security of public employees. Rather, as transparency advocates, we believe first that we must be transparent about how little protection is afforded by these provisions. They essentially only guarantee that the employee and the employing agency may not release an address, not that addresses are exempt from all government records. And in 2000,
Director Murphy,
yeah.
Your 3 minutes have elapsed, so if you could please summarize the rest of your testimony.
Okay, I'll try. So second, the provisions are unfair, we think, may pose a constitutional problem. Third, they're bad from a statutory perspective because they essentially poke holes in the FOI Act for very little gain. If the legislature wants to head in that direction, we would recommend exempting all public employees and not carving out these individual groups. The last two bills, I'll try to go quickly on. The commission opposes Senate Bill 1153, an act establishing an exemption from disclosure for certain higher ed records pertaining to research or teaching under the FOI Act. We believe the proposal is extremely broad and we question the purpose behind such broad language. It's also vague and doesn't define many of its terms. And there's a great public interest in all studies and research conducted at public universities, but especially those that address significant issues of our time, such as climate change and impacts on the pandemic. We would propose that if this legislation is going to go forward, that it be narrowed very heavily, and also that perhaps a temporal limitation be put on it, such as is done in Alaska, Arizona, and Michigan. And last, the commission objects to Section 1 only of Senate Bill 1154, the one that the auditor spoke on previously. In a recent decision, the commission did point out that although it was dismissing a complaint, it was reserving the right, I guess, essentially to say that all complaints are exempt from disclosure. We believe the whistleblower protections should be there to protect the whistleblower, and the current statute does that and protects the records of the investigation. I think the commission is trying to make a distinction that a complaint is a complaint and not the investigation itself, as it has done in other areas. However, if a complaint were to reveal the whistleblower, the commission, as it did in that case, would find that it's exempt under current law. But we're happy to discuss this proposal and all the others with the interested parties, and look forward to potentially narrowing them or eliminating their going forward. Thank you.
Thank you. Are there questions from the committee? Seeing none, I just wanted to ask you about I believe is it 1157, the provision on addresses. Is there any, could you identify for us any public purpose in having a state employee's home address?
Right, I guess that's the tricky question. There are probably some very limited situations where an address is important, at least the town where one resides, in the municipal area where, for instance, if you're a police officer and you live in a certain town, you get certain credits or points for that. So there may be a limited interest there. And I think that is the question that we're asked a lot, and we don't have a ready answer for that. But I think what we're doing by carving out these exemptions piece by piece, one by one, I think that is unfair. And I think our problem with it is that it is giving people a false sense of security. So that's mainly our concern, is that we don't want people to walk away thinking, oh, I now have that provision and I'm now protected from disclosure of my address. As we know, they're readily available anywhere almost at this point in time.
Well, thank you for that answer. I certainly understand for some people it makes sense to have addresses be publicly available. We may be some of them. Voters may want to verify that we live in the districts where we're supposed to, but to me, it seems pretty far-fetched that a public employee's home address would be relevant in a way that it would need to be known by the public. And I think the reason behind the specific state employees mentioned in these laws is to try to be as narrow as possible, but also to recognize that these state employees are subject to more high conflict situations that may put them at more risk. So I appreciate your saying that you are willing to continue working with us on these bills and their outlines. We certainly look forward to that process. Next up is, I think it was Senator Fonfara, followed by Senator Anwar, followed by Karen Florin.
Good afternoon, Senator Flexer, Representative Blumenthal, members of the GAE committee. It's been a long time since I've been before this committee. I chaired it 172 years ago. Probably not that far off, but I am here today to testify in support of Senate Bill 1158. Very interesting title and act designating certain days, weeks, and months. Members of the committee, there are a number of important items in this bill. I'm here today to testify with respect to one of them, and I thank you for raising the bill in general. And that is to proclaim July 11th of each year Bosnian Genocide Remembrance Day. I'll just say parenthetically that there are approximately 3,000 Bosnian citizens in Connecticut today. I happen to represent Hartford and Wethersfield, which there are a number of Bosnian residents. And despite the horrors that this community experienced in Bosnia, I can't think of a more positive citizenry than this community, and how they have emigrated from another country and have integrated and become such a strong part of the fabric of Connecticut, and in particular Hartford and Wethersfield, and we are very, very lucky to have them. With respect to the circumstances that took place in 1995 in particular, this is began as a result of the deteriorating conditions after the breakup of Yugoslavia, in which despite several efforts to reform a functioning government, but being foiled repeatedly, particularly by the Serbians and Bosnian Serbians in that country. But if I would, I beg the indulgence of the committee to read what I think is will help everyone understand better what took place then. And this was increasingly aggressive behavior, military behavior on the part of the Bosnian Serbs. The offensive commenced in July 6 of 1995 with Bosnian Serb forces advancing from the south and burning Bosniak homes along the way. Amid chaos and terror, thousands of civilians fled Srebrenica for the nearby village of Potokari, where a contingent of about 200 Dutch peacekeepers were stationed. Some of the Dutch surrendered, while others withdrew. None fired on the advancing Bosnian Serb forces. On July 11th, Bosnian Serb military, may I continue just shortly? Thank you.
Yes.
Military leader Ratko Mladic strolled through Srebrenica, and in a statement recorded on film by the Serb journalist said, "We give this town to the Serb nation. The time has come to take revenge on the Muslims." On the night of July 11th, a column of more than 10,000 Bosniak men set off from Srebrenica through dense forest in an attempt to reach safety. Beginning the following morning, Bosnian Serb officers used UN equipment and made false promises of security to encourage the men to surrender. Thousands gave themselves up or were captured, and many were subsequently executed. Other Bosniaks were forced out of Potokari that day through the use of terror, including individual murders and rapes committed by Bosnian Serb forces. The women, children, and elderly were placed aboard buses, some of which were brought from Serbia and driven to the Bosniak-held territory. The men and boys were taken on July 11th and 13th to various holding sites, mostly in Bratunac. Some killings occurred on the evening of July 12th, but mass evacuations of mostly blindfolded Bosniak males to execution sites began in earnest on the evening of July 13th. The destinations were primarily north of Srebrenica and a 35-mile long band alongside the Drina River, which marks such Bosnians' borders with Serbia. They included a football field in Bratunac, several meadows and fields near Lasanica and Nova Kasaba, a warehouse in Kravica, a factory in Karadzic, a school in Rahodzic, a dirt road in Sezka Valley, and culture center in Pelika. The executions continued at least through July 16th, when hundreds of people were reportedly shot at a state farm and and village in Brujano. Although Bosnian Serb forces were primarily responsible for the killings, a police unit from Serbia was recorded on video participating in the execution of 6 Bosniaks. It was later discovered that many of the victims of the massacre had their arms and feet bound. Many of the bodies also showed signs of mutilation. Madam Chair, Mr. Chairman, there are families here today who lost family members in this massacre. And I think at minimum, what we owe these families is recognition in the manner that you have put forward in this bill, and we're grateful for you for it. Thank you.
Thank you, Senator Fonfara. Are there any questions from the committee? Seeing none, we appreciate your testimony.
Thank you very much.
Next up is Senator Anwar, followed by Karen Florin, followed by Jeffrey Berger.
Good afternoon, honorable chairs, Senator May Flexer and co-chair Representative Matt Blumenthal, and the ranking members and the honorable members of the GAE committee. I am here as well to ask for full support from every member for Senate Bill 1158. There are different parts to this bill, but I'm going to speak to line number 27 to line number 31, which is about the Bosnian Genocide Remembrance Day. As you just heard from our honorable senator about the community and the stories and the horrific stories, I can share with you. I have the good fortune of interacting with many of our Bosnian American community members. Each one, and then now we are seeing grandchildren, and then we are seeing children, and the ones, the direct witnesses of this massacre. The pain is like it happened yesterday, and it's something that has truly harmed them such a degree, but they have been able to come together with such grace and such beauty to give back to America and then be part of our community, part of our state. This community is active. They are working to make our state better. They are in nursing background, medical background, legal professions, you name the profession, they're part of it. But each one of them carries in their heart this pain. And all you have to do is just have a conversation of what happened, and they will share with you that pain. And that pain is very real, very significant. And we can't undo what has happened, but it's important to bear witness to what has happened and to speak about it. In a matter of a few days, by July 11th, about 28 years ago, over 8,000 people were slaughtered and murdered. And these were brothers, sisters, and parents, and women and children who were murdered during that time. And during about a few years' time, there were over 100,000 people that have been murdered. This has been recognized by the UN General Assembly. This has been recognized by US Congress and the International Court of Justice. Today you will later hear from one of the professors from Genocidal Studies professor and a World's Authority with Southern Connecticut State University, Professor David Pettigrew. He happened to be one of the witnesses to be able to document on behalf of our country and the world of what had happened. And he will speak, and he is from Connecticut. Today, we have an opportunity to speak about this because in the state of Connecticut, we are one of the few states which has a genocidal study curriculum. When we had the Holocaust, we said never again. But never again happened. But then we said never again. And then we will continue to fight and be one of the best states and the best group of people in the world who say when never again is never again, we stand for it. And this recognition of this day is going to help us be able to share this pain with the rest of the state, with our Bosnian brothers and sisters. Thank you so much for allowing me to speak and be here. Thank you.
Thank you very much, Senator Anwar. Any questions from the committee? Seeing none, we thank you very much for your testimony, and certainly thank you and Senator Fonfara for representing your Bosnian constituents here today. Next up is Karen Florin, followed by Jeffrey Berger. Is Karen Florin present? Not seeing her. Jeffrey Berger.
Yes, sir, Mr. Chairman.
There we go. All right, whenever you're ready.
Good afternoon, Mr. Chairman, Madam Chair, ranking members and honorable members of the GAE committee. My name is Jeffrey Berger. I am a State Property Review Board member. I am accompanied by Board Director Dimple Desai and staff Tom Jarrett. On behalf of Mr. Greenberg, the Board Chairman, and board members, I am here to express support for raised House Bill number 6827. Currently, the board reviews contracts with consultants, i.e. architects, engineers, construction administrators for major capital projects prior to their employment by the Department of Administrative Services, Division of Construction Services, for amounts over $100,000. It also reviews the transactions involving leases, purchases, and sales other than condemnation by the Department of Transportation. Mr. Chairman, I'm going to skip around my testimony to help expedite your time. You have our written testimony on the record. Connecticut General Statute 4B-3F requires the board approval or disapproval of any acquisition of development rights of agricultural land by DO Commissioner of Agriculture, approval or disapproval of DAS/DCS contracts, and approval or disapproval of the sale or lease of any property by the Commissioner of Transportation. Since its creation in 1975, the board has saved approximately $88.3 million of state of Connecticut taxpayer money. The board strongly supports House Bill 6827. No other independent board or agency reviews the merits of DAS/DCS contracts with respect to cost, scope of work, equitable distribution of contracts among consultants, or the compliance with state laws for procurement. Reducing the dollar threshold from $100,000 to $50,000 for DAS/DCS proposals will have negligible effect on timing. On the other hand, the proposed language in this bill increases the potential of oversight and of cost savings to the state's taxpayers. Currently, DOT is required to seek the board approval for the acquisition or the sale or lease of any property. It is prudent to require the board approval for licensing and other contractual agreements to make sure that the transactions are fair, transparent, uniform, and comply with state statute and regulations. These agencies have to prepare proposals, contracts, or agreements, regardless of whether they submit them to the board for a review to undertake projects. Therefore, there should not be any fiscal impact to those agencies under this bill. Also, the time taken by the board in reviewing these proposals as described is negligible. It also should be noted that there is no impact to revised general statutes as it relates to DOE Act. For the committee's past history, this bill passed under consent last session. The bill has been pared down to help reduce the fiscal note, which was attached to the bill previously, and is under consideration under the two current proposals presented under the current rendition of the bill. Thank you, Mr. Chairman, Madam Chair.
Thank you. Thank you very much for your time and your testimony today. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. We look forward to working with you.
Thank you, Madam Chair.
Right, next, I really want to get your name right. So if I say it incorrectly, when you come up, please correct me. Rudin Mujinovic. I'm so sorry. But when you get up here, you tell me how to say it correctly because it's important that I say it right. And after you're finished testifying, we will hear from Miles Rappaport. Welcome. Please correct my pronunciation.
Oh, that's all right. My name is Zahrudin Mujinovic, and I am a resident of Plantsville, Connecticut, and I'm more importantly a member of the Bosnian community here in Connecticut. I'm a graduate of Trinity College, University of Hartford, and currently I'm an IT engineering manager at the Hartford right up the street from here. So I thank you for your time, Senator Flexer, Representative Blumenthal, who's probably out eating some lunch, and members of the Governing Administration and Elections Committee. I'm testifying in support of SB 115, an act designating various days, weeks, and months specifically in favor of item 112 in the bill, the Bosnian Genocide Remembrance Day. This day would designate July 11th as the official commemorative day for recognizing those lost lives in Bosnian genocide during the Bosnian War. I'm going to try and keep this brief in the interest of time. One thing you'll notice today with me and most of my other community members testifying is we're all millennials of a similar age, and there's a reason for that. Most of us came here about 20, 25 years ago as refugees with our young parents, mostly orphan moms usually, and obviously there's a reason for that. But more important, the reason this is important to me is I'm a parent of two school-age children. Having July 11th be designated as the Bosnian Genocide Remembrance Day in Connecticut will make it easier for me to teach my kids of what actually happened and explain to them why they never met their grandparents and other members of the family. I'm also hopeful that by passing this bill, and that those in power, specifically teachers and other Connecticut residents, will be able to amplify this message and the fact that some 25 years ago, 30 years ago, 30 to 25 years ago, a horrible act in Eastern Europe happened, an act that vanquished many lives, much more than 8,300 that we're seeing around in the media for Srebrenica, but just in general, way more than that. And by passing this bill, I'm hoping it's going to make it easier for the Connecticut and for my kids to learn what actually happened. So when they talk to their friends, they'll, it's not going to be just blank stares in their faces. And I really do urge you to support SB 118 and help it pass through the legislature. Thank you.
Thank you. Thank you very much for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again. Thank you very much. Next, we will hear from Miles Rappaport, who will be followed by Halid Dervisvich. And again, please tell me if I got it wrong, but Miles is next, followed by Halid, followed by Tanya Smith. Welcome. The floor is yours.
Thank you very much. I'm really glad to be with the committee today. My name is Miles Rappaport. I am a West Hartford resident. I had the privilege of serving on this committee for 10 years and also working closely with the committee when I served as Secretary of the State back in the 1990s. I'm also the co-author with Washington Post columnist E.J. Dionne of a book that came out last year called 100% Democracy, The Case for Universal Voting. And I'm testifying today in support of House Bill 5717 and House Bill 5704, and on the concept of universal voting in general, this being a subject matter public hearing. I'll quickly like to thank the co-chairs, Senator Flexer and Representative Blumenthal, ranking members, Senator Sampson and Representative Francesco, and the committee as a whole for being willing to entertain this big and very new idea, at least in the American context. I'd also like to thank Representative Santiago and Representative Haddad for co-sponsoring the legislation. I appreciate it. And I did want to say a thank you to Congressman John Larson, who really wanted to be here today to testify. He is the sponsor of the Civic Duty to Vote Act in Congress, HB 7536, HR 7536. And he was hoping to be here today, but he had to go to Washington. But I believe he will be submitting testimony. The concept of universal civic duty voting is very simple. It redefines the act of voting, not simply as a fundamental right, but also as a required civic duty. It asks every citizen to be part of the fundamental act of self-governance in our country and hopefully in our state of Connecticut. Universal voting would immediately and dramatically increase voter participation, help reduce polarization in our politics, expand the influence of communities whose voices are now less heard and have been underrepresented, and create a political system much more responsive and more reflective of a broader base of citizens. So this is a radical idea, or it may seem like a radical idea in the context of the United States, but in fact, it is neither new nor untested. There are 26 countries around the globe who use universal voting now, 13 of them in Latin America, 5 in Europe. Belgium was the first country to adopt universal voting in 1892. And the most recent adopter is the country of Chile, which in December voted unanimously in the Chamber of Deputies to instate universal voting. Australia offers nearly 100 years of proof of concept. Universal voting was adopted there nationwide in 1924, 199 years ago. Voter participation immediately jumped from 60% to 90%, and it has stayed there every year, every election since then, 90% turnout participation rate. It's a light touch enforcement in the country of Australia. I can talk about it more, but it's astonishing that the proposal is so successfully used in so many countries has gotten no discussion whatsoever in the United States. So one last point I want to, and I'll be happy to answer questions, but it's critical to note that universal civic duty voting does not require people to vote for or against any particular candidate. People can vote none of the above. They can cast in a blank ballot. They are not compelled to speak in any particular way. The only compulsion is that to participate. Okay, let me stop there. I did submit written testimony and I have some printed copies of it. And I will say that I also have books available. So if any members of the committee would actually like a copy of the book, I'd be glad to give you one.
Thank you. Thank you very much for your time and your testimony. And I'm not sure if the Office of State Ethics is still here, but I can tell you that our state ethics laws allow for members of the legislature to receive those kinds of educational materials. So
thank you very much. Thank you very much.
And thank you again for your testimony. I know that a number of members have questions, so I'm going to start with our Vice Chair, Representative Morin Bello.
Thank you. And thank you for your testimony today. Are there any states that currently have universal voting, or are there any states that are now considering it?
Yes, there are no states that currently have universal voting. As I said, I'm was astonished when I heard about it just a few years ago that I had never been in a discussion about it. But there are a number of states that are actively thinking about it, as is Connecticut. So the one most recently is the state of Washington. In the state of Washington, a bill, Senate Bill 5209, was submitted with 14 Senate sponsors, including the Senate President, Majority Leader, and Chair of the Elections Committee. It was recently given, I testified, I went out to Olympia and testified for the vote along with the Speaker of the New South Wales Parliament. And the bill was actually passed by their analogous committee to GAE with a do pass recommendation. I don't know whether it will pass, but it had significant discussion. A bill has also been filed in Utah, which gives all of its cities the ability to do ranked choice voting if they like, to add the idea of universal voting as one of the permissible things that municipalities can do. So, you know, what I appreciate about your having this hearing today is that Connecticut is a leader in opening up this conversation. I believe that we're at the very beginning of a national conversation about whether or not voting should be considered a civic duty. And I'm deeply appreciative that Connecticut is one of the places where this conversation is beginning.
Thank you. I appreciate that.
Thank you, Representative. Are there other questions or comments from members of the committee? Representative Haddad.
Thank you. It's good to see you again, Mr. Rappaport. You know, as somebody who led this committee for a number of years and was a former Secretary of the State, I value your opinion on these issues, and I appreciate your time advancing what I think is a new idea for us. Let me also say that, because I know that just for a moment, you know, I was really upset to learn about the death of Karen Hobart Flynn over the weekend. You know, I know that you were the president of Common Cause and she succeeded you in that position as well. And so I just wanted to acknowledge, you know, Karen is somebody who was a real presence in this committee for a long time. You know, she's was here at the founding of our citizen election program, was incredibly accomplished. And I know that you were a colleague of hers, as many people here remember her fondly before she left for Washington. So I just wanted to acknowledge her passing. You mentioned Australia as an example. Can you tell us a little bit more about how exactly it works in Australia? This is a new idea, and I think that people just need to understand. Well, I'd like to hear from, like, you know, how does this work in a vibrant democracy, and what if anything can we learn from Australia's experience?
Okay, thank you. It's just a very interesting little bit of history. Actually, let me stop by also saying that I was a very good friend of Karen Hobart Flynn. She and I work together on many, many issues, and she is a real loss to democracy advocates all around the country. So thank you for taking note of that, Representative Haddad. In Australia, the universal voting was actually initiated by the Conservative Party back in 1924, out of the concern that the Labor Party, representing the kind of rising labor union movement, would be able to turn out voters much more effectively than the Conservative Party. So they initiated this idea, proposed this idea as a way of evening the playing field. And then the Labor Party said, fine, we like this idea too. So it was actually a very bipartisan agreement. Over the years, here's the way it works. First of all, they have a very strong centralized electoral commission. The Australia Electoral Commission is well funded. It's nonpartisan. It's highly professional. It has a lot of ability to set standards and enforce them. So what the commission does is they have what's called the Federal Direct Enrollment Program, which is a little bit like our voter registration, automatic registration system here, where they really go out and try to make sure that everyone is on the rolls. And 96% of Australian citizens are currently on the voter rolls. Of that 96%, 89.71% voted in the last election for prime minister. So here's what they do. They do a tremendous amount of voter education, as do the political parties, as do civil society organizations. They make it very easy to vote. You can actually vote from anywhere in the state where you are. They have a very kind of celebratory civic culture. It's really something I learned about. They have what are called democracy sausages. Now, they do have vegan alternatives now. I just want you to know that. But the democracy sausage is a great tradition. It's a sausage with onions on top, folded in one piece of white bread. So that's and what's more, you can go, since you can vote anywhere, you can go on Yelp and find out where the best sausages are, and you can go vote based on the sausage you want to get. Anyway, I'm not trying to trivialize it, but it's an indication. The elections are on Saturday. It's a very kind of celebratory culture. So what happens if you don't vote? If you don't vote, the commission sends you a letter saying, gee, you didn't vote. Can you give us a reason? And basically any reason that you give is accepted. I was visiting my grandmother in Perth. I had to work that day. I was ill. All that is fine. If you don't answer at all, they send you a second letter. And if you don't answer that one at all, then they send you they assess a fine of 20 Australian dollars, which is about $15 US. And, again, very, very few people ever are asked to pay that, but they consider it like a parking ticket, just sort of part of what you do. So there's never been an attempt to repeal it. People are very, very satisfied with the system. And, it works from the Australians' point of view. And I've talked to many of them. They really say, we can't imagine why other countries don't do it this way. It is a fully inclusive democracy. It is what we do here. And I guess the last thing I would say on this is that I think there's a very strong analogy to the system of jury duty that we have here. We are required as a matter of civic duty to serve on a jury. And the reason we've been doing it for 100 years or more, even back to the beginning of the country. The reason that is a required civic duty is because you want the jury pool writ large to be fully reflective of the population when somebody's guilt or innocence and appropriate punishment is being decided. I think the analogy to voting is very strong. We want, or we absolutely should want, the decisions that are made about the laws under which we live and the people who are making those laws be decided by the most fully reflective population. And we don't have that now. So, again, when I heard it and I thought about the jury duty, and you're fined if you don't go. If you get summoned to jury duty and you don't do it, you get fined. And, people may not want to go serve on a jury, but nobody says, how dare they make me serve on a jury? It is part of our culture, and it's accepted part of our culture. And I hope 50 years from now, so will voting.
I hope we can get it done. We can realize these increases in voter participation earlier than 50 years from now.
Okay.
Because I do agree with you that the ultimate goal is to ensure that we as elected officials and our elected government is accountable to everybody and every citizen. And it's hard it's hard to imagine how that really happens in a system where only 50% or less participate in an election. So thank you for your advocacy. I think this is probably going to take more than a single year to pass a piece of legislation like this, but you're really contributing to the conversation about democracy in Connecticut, and I commend you for it, and I thank you for it.
Thank you very much.
Thank you, Representative. Senator Sampson.
Thank you, Madam Chairman, and thank you for being here today. Just listening to the conversation, it's certainly, we work very hard to try and increase participation in voting as much as possible. Education, I think, is a key ingredient to that. And, just making sure that, young citizens especially recognize the value of their own participation in our electoral process. I think that's what we have got to get back to if we really want to get people involved in voting on a grander scale. I mean, Connecticut does pretty well compared to other states, but I can certainly respect folks that are interested in trying to promote more participation in voting. So we definitely are on the same page there. I do have some concerns about the notion of this bill, and I noticed it's been called a bunch of different things. Universal voting seems like a far more reasonable term than mandatory voting, but effectively, if it is required, I guess the thing that I would say is voting is a right in America. And I think a right implies that you have the opportunity to choose whether you exercise that right. So I guess I'm looking for your reaction to whether or not you're actually dissolving that right by no longer taking away the choice to exercise it by making it mandatory. Through you, Madam President or Madam Chairman. Why do I do that? For the record, the Madam President would refer to the President of the Senate, not the United States. But
okay, well, I thank you for your question, and it's obviously an important one. I would say a couple of things in response. One is that we call it universal voting and not mandatory or compulsory voting, although it's called those things in other places. Not just for the kind of ease of messaging, but for a specific reason, which is that the compulsion is not to vote for or against anyone. The compulsion is only to, or the mandatory part of it is only to participate. So we would actually recommend, E.J. Dion and I actually recommend in the book that ballots should have a none of the above option explicitly, so that it's very clear that there's no requirement to speak on behalf of a candidate or against a candidate if you don't choose to do that. So I guess on the question of whether there is a right not to vote, I guess I don't think it has the same force as the right to vote, because I think the right to vote is the participation in our democracy as a whole. And in the bill, by the way, the bill has not been drafted, so that there are many issues about how you would actually go about drafting it if you decide to. I'd be glad to help you as you go along. But we would propose that there is an ability to proclaim oneself a conscientious objector and say, I really don't want to vote, and you have that right, whether it's religious or just philosophical. Basically any reason that you have for not voting is accepted in Australia, and I would recommend that if we do this here, we do the same thing. So yes, it is certainly more asking more of people and requiring them to participate, as I say, as we do now with jury duty. And I think that the benefit of it is that it is an infringement, if you will, in the ability to just say, I don't really want to bother with all this. But I think the benefit of having a 90% participation rate in our democracy and in the decisions would be so overwhelmingly important that I think the minor inconvenience that this bill might create for people, I think, is well justified.
Through you, Madam Chairman. Thank you for that answer. And I guess you ended your comments right where I would say that's where the debate lies. It's the notion of the infringement versus a relative benefit. And, I look at the United States as a much different place than Australia, for one thing. I mean, this is a nation of free citizens. And how free can you actually be if someone's forcing you to vote, is my opinion. Sure, I think people should participate in the electoral process. People should be informed and they should vote. But I also certainly would respect anyone who doesn't participate in any of our other rights, particularly the ones that are protected by our Constitution. The right to keep and bear arms, for example, some people choose not to. If there was a compulsory requirement to keep and bear arms, I would find that just as much of an infringement. The right to engage in speech. You know, I think something is lost in being free citizens and having rights if we are no longer free to choose whether we exercise them. And I don't know if that's entered into your thought process here. I mean, it seems to me like, you know, the legislatures and governments, as they grow, have a tendency to begin to decide things for other people. And I think that this country was founded on the notion that we're not going to have government that decides things for other people. At least that's where I view it. And as a member of the minority, I mean, you know, full disclosure, I end up being the guy here saying, no, we shouldn't be imposing these type of things on people that don't want them. And in almost every case, I think freedom is the position that should reign supreme in America. And that freedom would extend to the right to be able to decide whether or not to participate. I get the idea that you've included in this process some element of an opt-out, but the opt-out itself is also a violation of freedom. I'm just curious to have your reaction to my comments on, you know, is America a different type of nation? I mean, I truly think it is. I mean, they don't have anywhere near the same individual liberty as we do in America. And again, this is a notion of individual rights. You know, the benefit you speak of might be a collective benefit. And that's only an opinion that it's a collective benefit to have more participation, but that collective benefit versus an individual right. And I think that that's what separates us from Australia. And I'm just curious why that would be a major part of your testimony, that it works so well there, because we are a different country. Through you, Madam Chairman.
Okay, I guess one of the reasons that we do talk about Australia is that I do think that is kind of an analogous country. It is, you know, was had its English roots as we had our English roots. It is a relatively very free country. There's, you know, it's very much like our country. It's not as diverse as we are, but it is diverse. And, you know, I think people think of themselves as very, very free citizens there. Not, you know, every country has its own quirks, et cetera, but I think Australia is much closer to us. But let me just go to the question of the infringement versus benefit. Let me just say a thing on the benefit. There is a problem to be solved in the United States. And you're right in saying that Connecticut does better than some other states, but we don't do as well as I think we might. In the 2018 elections, which were a record turnout for the United States for a midterm election, the total turnout was 50%. In the 2020 elections, which were a record turnout for presidential elections, it was 66%. The United States is well in the bottom half of voter participation among industrialized democracies, well in the bottom half. So, and the other thing is that it's not simply the aggregate number. The voting electorate has high propensity voters, which tend to be more wealthy voters, older voters, whiter voters, more highly educated voters, and lower propensity voters who are young people, a lot of young people, you know, people with less education, people with lower incomes, and people in communities of color. And so we have an electorate that is not fully reflective of the country as a whole. And for me, there's a very important reason to strive to achieve that, because when some people are voting, there have been major studies of how responsive government is, and they are very responsive to the people who are very high propensity voters, and of course to the donor community, and much less responsive to people who are not in that category. So I think we're solving what is, I think, a real problem in the United States. And we can do it without a huge amount of difficulty.
Through you, Madam Chairman. Thank you again for that answer. I mean, I can appreciate your position, and I just certainly don't want to turn this into a debate here, but a lot of what you are suggesting is pure opinion. I mean, you considered it to be a problem that not everyone is participating in the voting process. As much as I want to see more people participate, I don't consider it a problem. I consider it an exercise of those individuals' right to participate or not. And, 2018, you mentioned 50% of the people participated, but the other 50% didn't participate. Well, I'm here to protect their rights as much as the people that did. And I guess that's the difference here, is that once you cease to recognize someone's right as a right itself, for them to utilize in the way they see fit, and you suggest that somehow their right is gone because now you've turned what was once their opportunity to exercise their free will into something that the government requires of them. I don't know if you are still a sovereign individual anymore. You sound like a subject at that point, respectfully. And I'll just leave it right there. But thank you very much for coming in, and I look forward to a very interesting debate on this as time goes on. Thank you, Madam Chairman.
Thank you, Senator. Are there further questions or comments from members of the committee? Representative Santiago.
Thank you, Madam Chair. And I want to thank the committee for bringing this bill out just to begin to have the conversation. And thank you, Secretary, for being here today. In reading parts of the book, and the reason I introduced this bill along with my colleagues as not getting a penalty or a fine for not voting, that was concerning to me. I'm concerned about the burden placed on low-income folks, poor folks that couldn't pay that, and that's why this bill is different than the other one that was put in this committee. And people in communities of color, that if there is a penalty attached, what could be done to deal with that issue? If, let's say, this is an ongoing conversation. I mean, we, as a free society and as Americans, we're one of 4 states in the country that doesn't even have early voting. So we have a lot of voter suppression in this state. We're not as progressive as we think we are. So this concept is something that I can look at in the future, probably not in my time, the way things are going, but at least the conversation is being had. Because when you look at other countries, especially in South America, that's always called the Banana Republic, countries in Europe, countries like Australia, that people do exercise that right to vote. Again, that's one of the reasons why I put in this bill not to put in a penalty. Are there other ways that we can incentivize folks to, if it is mandatory for them to vote in other aspects?
Thank you, Representative Santiago. That's a very important question. I'll just speak momentarily internationally, which is that in the 26 countries that utilize some form of universal voting, there are very different mechanisms of how it's implemented. In Greece, as one example, there are no penalties whatsoever. It is simply an assertion that voting is a requirement. In other countries, they do different things. There are some places that have mild incentives as well. In the state of Washington, and the bill that was introduced in Washington, as you mentioned, there is no penalty. It is simply saying, it is simply a statement that voting is required. And then the discussion of how to implement or incentivize that, is still on the table. And you're right, I think this is a very early point of the discussion. The reason that we utilize Australia, but I don't want to back away from it completely. I think if there were a light in the places that there is some light touch enforcement, like Australia and like Uruguay, it seems like the impact on voter participation is greater. And so, it's a question of how do you do it? If we were going to do it, if I were going to design a bill for Connecticut, I would make sure that if there were any penalty, it's low, very low, It doesn't accumulate, it should not accumulate any interest. It should not accumulate any penalties. It could be satisfied by an hour or 2 hours of community service. And some exemptions and waivers could easily be written into it. So I think there's a lot of, I think you're right. And I think if there were a decision to add some incentives, like a slight tax break for people who register, or a lottery system, a lottery ticket for people who are registered and do vote, all that is, I think, worth considering. But I use the example that has worked for 100 years of a very light touch enforcement to say that seems to get the best results. So that's why we do recommend that. But again, we're at the very beginning of a very, very long discussion. I do want to say one other thing, which was to commend this committee and the state of Connecticut for making some real strides towards opening up the voting process over the last years. And I know you're talking about early voting this year. I know there may be a constitutional amendment for expanded mail-in. So all this is going in the right direction. I guess what I'm hoping to do here is to put out a North Star reform. And the point of universal voting is not, gee, we'd like to fine you. The point is to establish the principle that we want absolutely everyone to participate in our democracy. And I think we will be it is my opinion, of course, but I think we will be a much healthier democracy if we get closer to that ideal. And so that's why I'm delighted to have the opportunity to talk with you about it today. And I do want to once again express Congressman Larson's regrets. He and I did a joint op-ed, which you may have seen in the Hartford Courant recently, and he really wanted to be here. He will be submitting written testimony.
One more question, Madam Chair. Through the chair, as you know, in the state of Connecticut, we have the Citizens Election Program. How do you think if this was to happen in the future, campaign finance, where do you see those changes with that?
Interesting question. The Citizens Election Program, I go back, Representative had it to Karen Hobart Flynn, who is, just a key mover and shaker in creating that program. I think it's an excellent program. I think it's the model for other places in the country. I don't see any reason why that should change. I think that the issue of how campaigns are funded is certainly an issue, whether you have 90% turnout or 60% turnout. I guess generally speaking, I would say that people generally say that the power of people is the best antidote to the power of money. And so if you have a 90% turnout, I think that gives the people a little more leverage in the situation. So I would strongly support keeping the Citizens Election Program. And I think it could work easily hand in hand with the idea of universal voting.
Thank you, Mr. Rappaport. I just want to wrap up and say that there's a lot of decisions that the government makes for us. I mean, we have to pay taxes. That's mandated, right? We have to have a driver's license in order to drive. Some people decide not to have it, but it's mandated when you drive a car or any kind of vehicle that you have a driver's license. And civic duty, like you have spoken about, jury duty, we're mandated. And now they're getting tougher on people that don't show up for jury duty, and they're starting to give tickets, citations, and even issue a warrant if you are called numerous times and never even answer. So I want to say that thank you for bringing this idea to Connecticut. It's something that we should be looking at in the future. We have to get early voting and no excuse absentee ballot first before we join those other states that are more progressive and don't suppress the vote. And I want to thank the chairs again and the ranking chairs for allowing this public hearing on the universal vote. And thank you for being here.
Thank you.
Thank you, Representative. Sorry, former Secretary Rappaport. I wasn't sure if you had something else to say.
Oh, just to say thank you for this is, as you say, at the beginning of a long conversation. And I love the fact that Connecticut is one of the places where it's beginning. So we'll continue the conversation as we go. And thank you very much.
Thank you. And seeing no further comments or questions from members of the committee, thank you again for your time and your testimony this afternoon.
Great. Thank you.
Next, again, correct me if I've said this wrong, we will hear from Halid Dervisevich, followed by Tanya Smith, followed by Katie Maldonado. Gioglio. Okay. Khalid, did I say your name correctly?
Yes,
Great, welcome. The floor is yours.
thank you. Dear Senator Fletcher, Representative Blumenthal, members of the government administration and election. My name is Khalid Dervish. I'm the resident of Hartford. I'm here to testify in support of the Bill 1158, specifically the line number 112, dedicating this bill to Bosnian Genocide Remembrance Day. This day would designate July 11th as an official commemorative day for recognizing those lives lost in a genocide during the war in Bosnia and Herzegovina. I was outside playing when unexpected gunshots were heard from neighboring village of the Bosnian Serbs. This marked the beginning of what went on to become a 4-year-long war. Immediately, we packed our belongings and left our home to live in a neighboring Sarsa near Konjevic, later Srebrenica and Tuzla, and then America. A few months into the war, my mother returned home secretly, collecting crops from the land to feed her children. In the process of collecting the crops for our land, my mother was shot by a sniper from a neighboring village of a Bosnian Serbs. She became one of the first civilian victim of the war. Her last words were, "Oh, my children." I was 8-year-old during that time. I was old enough to see what's happening, but not old enough to understand why. Losing my mother had a great impact on me and my ability to move forward. It was difficult to accept the life without the mother. 6 months later, I lost my father. The last memories of my father were hours before his death. With my eyes half open, I saw him walking up to my older brother and instructing him to wake me up so we can eat a piece of cornbread that he brought before his final departure to the battlefield. He briefly scanned the room that we were sleeping in, and he left in silence. Later that day, we learned that he was ill. I lost my wings, a compass to move forward in life. It is difficult to explain what and how is it to grow up without the parents. No hugs, no aces, no bed stories, no movie nights, no special moments or dates. It was taken away from me forever. I immigrated to the United States of America at age 17 with my older sister, older brother, and our grandmother. Together, we started over. My faith and strong belief in Almighty God allow me to cope with the pain and gain ability to continue enjoying the life. Today, I'm healthcare provider, a husband, and a father of our 3 sons. My 3 sons did not lose the opportunity to meet their grandparents. Instead, it was taken from them. They will now only have stories about them. I urge you to all support SB 1158 bill and help us pass this legislative session because it raises the awareness and prevention on genocide. It allows to differently promote a culture of memories, which is integral part of the Bosnian identity and those living in the state of Connecticut. I want you to stand for the truth about genocide in Bosnia and Herzegovina, to be supported and recognized as the part of the diverse community in the state of Connecticut. I'm here as a war survivor and to raise my voice for justice, freedom, and peace. Thank you.
Thank you. Thank you, Khalid, for your time and your testimony this afternoon and your advocacy. Are there any questions or comments from members of the committee? Seeing none, thank you very much for telling us your story. It was very powerful. Thank you very much. Next, we will hear from Tanya Smith, followed by, and forgive me, Katie Malgioglio, and Robert Perez. Tanya, welcome. The floor is yours.
Thank you. Good afternoon, co-chairs Blumenthal and Flexer, and ranking members and other members of the GAE committee. My name is Tanya Rhodes Smith. I respectfully submit testimony today in strong support of House Bills 5702 and 5742, which would allow incarcerated individuals to vote in all elections. I am the director of the Nancy A. Humphreys Institute for Political Social Work at the UConn School of Social Work. We examine the connection between voting and community health, conduct research, and develop models to increase civic engagement in communities. Felony disenfranchisement laws were explicitly and implicitly written into many state constitutions and statutes to limit the political power of African Americans and other minoritized groups. We forget this history today because these laws are race neutral, but their impact continues to limit the political power and outcomes in communities most impacted by the criminal justice system. In 2022, the American Medical Association declared voting a social determinant of health. Communities that vote in higher rate are better off in numerous and important measures of well-being, including higher and better employment, life expectancy, education, and more. As further proof of the power of voting, civic participation has been linked with significantly lower recidivism rates. Voter turnout matters. Consistently, Hartford, Bridgeport, and other cities with the highest rates of justice involvement have the lowest rates of voter participation in our state. In local elections, it's common for turnout in these communities to be under 15%. Numerous studies, as the former Secretary of State referenced, numerous studies show that elected officials give more attention and more resources to voters, and this is amplified on the local level, so that 15%, the 15% that votes has outsized political power and voice. Look at voter turnout by district, and it's easy to see a relationship between higher rates of voter turnout and where community resources are directed. Overlay incarceration rates and arrest data and see the inverse relationship: lack of access to jobs, community investments, and more. These voting deserts are significant because voting is a highly relational activity. So when we think about a policy like felony disenfranchisement, we have to see its multiplier effect into the civic life of their families and communities, as well as their outcomes. Felony disenfranchisement laws are set at the state level, creating a dizzying maze of eligibility laws and access. I train thousands of people a year on civic engagement and can tell you that most people do not know if or when people with a felony can vote. And add that to the risk of being wrong, which is plainly stated on every voter registration form, a penalty of up to 5 years in prison and $5,000 fine. So it's easy to understand why individuals with a felony vote at the lowest rates of any other group. Promoting civic engagement while individuals are incarcerated gives us an opportunity to strengthen community ties and build civic IQ before people are released, so that when they leave prison, they have the practice and power of being a voter. I'm almost done. They have the practice and power of being a voter, a better understanding of their government, and the skills to engage in civic life. This positive engagement can promote conversations with families and plant seeds of civic connection in communities. Full enfranchisement would change the narrative in our state. It would end the misinformation and the administrative voter suppression that happens today for the 40% of incarcerated individuals that have the right to vote, but have not yet been convicted. And as I close, I urge you to ask, what benefit is gained to society by taking away someone's right to vote? Re-enfranchisement supports the re-entry, public safety, and community health and well-being goals we say we value in our states. Thank you very much, and I'm happy to answer any questions.
Thank you. Thank you for your time and your testimony today. Are there questions or comments from members of the committee? Representative Kristen McCarthy-Vahey, the floor is yours.
Thank you very much, Madam Chair. And Tanya, thank you so much for your time and testimony and for your tireless work in what you do over at the Humphreys Institute and at UConn with your students. Just a question in terms of how many states would we be following suit, and maybe give us a couple examples of some of those states, if you would.
Well, Maine and Vermont do not have any restriction on voting while incarceration. There's no disenfranchisement law in their state. Washington, D.C. has you can now vote while from prison while in the city of Washington, D.C. But in other states, there has been moved to expand it, but there's been no state in the country that has full reenfranchisement, and that is acted to fully reenfranchise voters. But it is different state to state, and Connecticut would certainly be in the forefront, and I think would join our New England neighbors, Maine and Vermont.
Thank you for that, Tanya. And I know as a social worker, and you referenced the connection to health, and
Yes.
as the co-chair of public health, and by the way, there's a social worker testifying over there right now as we speak. You talked about voting as a social determinant of health.
Yes.
And voting as it connects to community health.
Yes.
And I think that's an important connection. And I thank you for making that. Thank you, Madam Chair.
Thank you, Representative. Are there any other comments or questions from members of the committee? I just have one quick question. You
Sure.
referenced the 40% of people who are incarcerated but not convicted. Do you have any other suggestions in the public policy as to how we could make sure those folks that they are enfranchised?
There are folks working on that issue, including the Full Citizens Coalition, which I know I'm joined here today with them. And there are some very specific policy recommendations. But one of the things I think is really tricky is that it's complicated to know. And so the simpler we can make it, so when you reenfranchise all people, it takes away that guesswork, and it promotes conversation and it promotes participation. So I think that is really my first recommendation, is to simplify this and make sure that people have the ability to vote by absentee, but that we'd be happy to there are a list of policy recommendations on that, and I think you'll probably hear some today.
Thank you. Thank you again for your time and your testimony.
Thank you very
this
much.
afternoon. Next, we will hear from Katie Maglolio, followed by Robert Perez, followed by Jeffrey Daniels. Katie, please. I'm so sorry. I know I've butchered your
fine.
name.
You're fine. My name is Katie Malgioglio. Good
Malgioglio.
afternoon, distinguished members of the Government Administration and Elections Committee. Thank you for the opportunity to speak today. As I said, my name is Katie Malgioglio. I'm a resident of Hebron, a graduate student at the UConn School of Social Work, and a family member of someone who has been incarcerated. I'm here today to stand in strong support of HB 5702, an act allowing incarcerated individuals to vote. In the words of the late U.S. Representative John Lewis, the vote is precious. It is the most powerful, nonviolent tool we have in a democratic society, and we must use it. Disenfranchisement impacts our entire country and specifically targets Black and Brown communities. In comparison to the rest of the population, people of color are 5 times as likely to be in prison and almost 4 times as likely to lose their voting rights. Disenfranchisement laws were initially put in place after the Civil War with the purpose and intention of restricting Black men from voting. The overtly racist origins of policies like this still impact people today, including citizens in our own state. In Connecticut, nearly 70% of our incarcerated population is Black or Latino. Disenfranchisement is a racial justice issue. As a relative of a formerly incarcerated individual, I have seen how difficult reentry can be, and I know how incarceration can harm people, families, and communities. As a social worker, I abide by our code of ethics, which prompts us to respect the inherent dignity and worth of all people. Preventing incarcerated individuals from voting not only undermines their inherent dignity and worth as people and as human beings, but it suggests that voting is a privilege for a select few rather than a fundamental right that Americans, specifically women and people of color, spent years and years fighting for. Our New England neighbors, Maine and Vermont, have fully restored incarcerated people's right to vote. These states are leaders in the movement towards reenfranchisement, and Connecticut can be too. Restoring the right to vote for all incarcerated people will keep inmates connected to their community, help them reintegrate and adjust upon release, and lower overall recidivism rates. Studies have shown that voting creates better health outcomes and greater access to resources. Voting is one way that we can move political power to where it belongs and where it needs to be, with the people. Our democracy and our future as a state depend upon our citizens, all of our citizens, being engaged, informed, and making our voices heard. Connecticut must commit to full reenfranchisement and restore all incarcerated people's right to vote. I strongly support HB 5702, and I ask the committee to support and pass this legislation. Thank you for your time.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you so much.
Next, we will hear from Robert Perez, who will be followed by Jeffrey Daniels, who will be followed by Daniel Rosenthal. Is Robert here? Robert is not online. Okay, Jeffrey Daniels. Is Jeffrey here? Okay, come on up, Jeffrey. And after Jeffrey, we will hear from Daniel Rosenthal, who will be followed by Jacob Hemedovich. I'm really trying. All right, Robert is not here, so this is Jeffrey Daniels. Welcome, Jeffrey. The floor is yours.
Good afternoon. Dear Chairperson Flexer, Chairman Blumenthal, and members of the GAE committee. My name is Jeffrey Daniels. I am co-chair of the Legislative Committee of the Connecticut Council on Freedom of Information. CCFOI has advocated for government transparency and accountability since our founding in 1955. Our members represent leaders from the print, broadcast, and internet media, the Connecticut Bar, and civil rights, civil liberties, and open government organizations. I'm here to comment and offer context on 4 FOI Freedom of Information related bills. We support Senate Bill 1155 and are speaking in opposition to Senate Bills 1153, 1154, and 1157. In different ways, each of the bills that we oppose would deny to the public, the press, and even legislators a range of information that really should be accessible. Taken collectively, they dilute further the public's right to know and compromise transparency in government. We support the language in 7 sections of Senate Bill 1155. That was the package submitted by the FOI Commission. The language proposed in Section 6G, which clarifies that mobile phones and cameras are to be included in the law that currently allows the public to make copies of records using handheld scanners. This proposal specifically defines handheld scanners to include mobile phones, cameras, and other portable devices. The law simply tries to keep up with technology. Sections 1 and 2 of SB 1155 would clarify the definitions of governmental function. This language only affects the definition with respect to FOI, and will assure public access to contracts where such entities are in fact using public funds to carry out governmental business. We oppose Senate Bill 1153. Broadly written, this bill has the potential to exempt from public scrutiny a wide range of research information and data conducted by the staff and faculty of our institutions of public higher education. While we sympathize with efforts to protect personal safety by withholding certain private information, sufficient protections currently exist in FOI statutes. This bill threatens the rightful public access to literally all manner of research material under the guise of its being proprietary. Lost my place. Excuse me a second. Sorry to use up my time this way. I lost the page.
It's okay. We'll give you a minute.
1154. My error. This is an effort to not disclose formal complaint documents by whistleblowers. Existing FOI law currently exempts disclosing names and information of investigative files, a position supported by court decisions and one that extends to whistleblowers. The release of whistleblower complaint documents should be made on a case-by-case basis, not a blanket exemption as the bill proposes. And finally, 1157 would withhold release of employee residential addresses in 4 additional state agencies. You've heard a lot of testimony on this, so I'll just be brief. Much of this information is easily available in a town hall currently and on the internet. While we sympathize with the issue of public safety, this would really not have the effect of hiding it. In addition, the bill would expand agency notification requirements in cases involving over 50 employees before the FOI information would be released. And we can't really understand what purpose that would serve. I'm happy to answer any questions you might have. And
Thank
Thank
you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again very much for your testimony today. Robert Perez.
Yes, ma'am.
I'm so sorry for not recognizing you online and making you wait. The floor is
okay.
yours.
Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and the members of the Government and Administration Election Commission. My name is Robert Perez. I'm a lieutenant supervising judicial marshal of the state of Connecticut Judicial Branch. I offer the following testimony in support of Senate Bill 1157. I would like to thank the committee for raising SB 1157. As someone who's a lieutenant supervising judicial marshal employed by the judicial branch for 22 years, this is a bill that's very important to me. I love working for the people of Connecticut, but I would not want that work to put myself, my family, or my coworkers at risk because someone abuses the FOIA process. The nature of our work is very important and crucial to the judicial process. We ensure the safety of the accused during the process and the safety of those who partake within our courtrooms, which includes victims and their family. We provide a safe, secured environment, screening everyone who enters our courts. The FOIA process can be abused to harass and harm many lieutenants or judicial marshals assigned to provide security to our judges, staff, and visitors. Additionally, through knowledge of our personal information, it could be harmful to our family's safety. The misuse of the FOIA process to obtain residential address can lead to someone knowing where I live. This can create an unsafe set of circumstances, not just for me and my coworkers, but my family as well. The release of residential address information can result in threats of bodily harm, vandalism of our personal properties, and our families being harassed or even assaulted. While it's true that personal information can be found in other places other than FOIA release, sometimes all it takes is an internet search. That should not be the excuse for the state to help facilitate the release of that information. The open and transparent operation of state agencies is essential to our democracy and at the foundation of the idea of the government of the people, by the people, and for the people. However, does not mean my home address needs to be accessible to an FOIA request. For the safety and security, as well as the safety and security of our family and coworkers, I urge you to support Senate Bill 1157. Thank you for hearing my testimony.
Thank you. Thank you for your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your patience and for your testimony this afternoon.
Thank you, ma'am. I appreciate it.
Next, we will hear from Daniel Rosenthal, who will be followed by Jacob Hamidovich, followed by Sachin Pandya. Daniel, welcome. The floor is yours.
Hi, good afternoon. My thanks to Co-Chair Flexer and Blumenthal and the members of the General Administration Election Committee for the opportunity today. I'm actually the first person speaking today in favor of Senate Bill 389. There are a number of friends and colleagues of mine on Connecticut Voters First that will be speaking about many facets of ranked choice voting, but I will cover my focus, which is municipal government. Before I begin, I also want to thank Senator Ostin and my friend Senator Huang for their bipartisan sponsorship of Senate Bill 389. While I support the bill in full, as a local chief elected official, I speak today in support of ranked choice voting for certain municipal races. Truthfully, I support it for all races. However, I understand the need to limit it to this point to winner-take-all races, for example, mayoral races, until some of the complexities around boards of selectmen and minority representation, among others, can be worked out. In an increasingly polarized world, as you move up the electoral food chain, local government generally remains a place where friends and neighbors can work together to solve local problems, and personal knowledge of candidates usually overcomes tribalism. What better place to pilot ranked choice voting, where the differences between candidates are often nuanced, and it's not uncommon for voters to have a deep connection to more than one candidate. I would also add that it's not uncommon to have multiple candidates running to become local chief electeds. I don't know what they're thinking. As the barriers to entry in terms of signatures and other organizational issues are not as significant as statewide or congressional offices. I know from personal experience in my first campaign for first selectman in 2017, There were initially 4 candidates in the race. After the primary, the general election became a 3-way race. All of us were well known in the community, and I considered my opponents friends before and after the election. My relation to them was probably not dissimilar to many of our residents, and while I'm grateful I was elected with an outright majority of the vote, I believe our residents would have appreciated the opportunity to rank their preferences. Ranked choice voting would have undoubtedly enhanced the process by giving more options to the voters. With all the focus on democracy these days, with a peaceful transfer of power being paramount, being for democracy also means welcoming the free exchange of ideas and believing that anyone wishing to run for office should be able to. Ranked choice voting will make our system stronger, and we shouldn't be afraid to try it. Thank you for your time and consideration.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you very much.
Next, we will hear from Jacob Hamidovich, followed by Sachin Pandya, followed by Anderson Curtis. Jacob, are you here today? Okay, Jacob is not here. So Sachin? Is Sachin here online? I don't see them. So I'm going to move on to Anderson Curtis. Sachin here? Sachin's here. Okay, Sachin.
Good afternoon. Can you hear
Okay.
me?
Okay, I'm going to call on Sachin and then Anderson. Sachin, if I have pronounced your name incorrectly, please feel free to correct me, and welcome. The floor is yours.
Thank you very much. Good afternoon, distinguished members of the committee. My name is Sachin Pandya. I'm a professor of law at the University of Connecticut, and I'm here to testify in support of SB 1153, which exempts from the state Freedom of Information law records arising from university faculty teaching and research. I support this bill because it reduces the risk of people using FOIA requests as weapons to harass faculty, often to discourage research and teaching about topics they don't like. This FOIA harassment risk is real, and it threatens the high quality and competitiveness of our state's public universities. Unlike our state, other states already and expressly exempt from their FOIA statutes any records arising out of faculty, teaching and research at their public universities. Those states include Rhode Island, Maryland, Virginia, even New Jersey, which did this decades ago. Meanwhile, Connecticut lags behind. The reason is simple. Our FOIA law covers public records maintained or kept on file by a public agency. Public universities count as public agencies. Individual faculty members don't, but records arising from faculty research and teaching are routinely and often inescapably transmitted or stored using university information technology. And to that extent, they're arguably maintained or kept on file by the university itself. Examples include records stored on any cloud storage device the university provides, on a university-owned computer, any application for research studies involving human subjects that's submitted to the University Institutional Review Board, whether or not the board approves it, and regardless of how vulnerable those in the study population might be. Any faculty's teaching materials posted for enrolled students only via learning management software that includes any class recordings, often vital to students who miss class due to illness. Research details and grant applications submitted to external funders, and of course, any email or email attachment sent from or to a university email address. So, faculty face a lot of exposure and multiple degrees of legal uncertainty if a FOIA request comes in. Unlike previous people to have testified before you, it is simply not true that the existing FOIA exemptions handle this legal uncertainty. As a result, it's hard to know how best to reduce FOIA harassment risk for themselves, their classroom, their research teams, the people that participate in the studies, as well as their partners in public-private research collaboration. All else equal, that makes our public universities far less attractive and thus far less competitive than the ones in New Jersey and those other states with a FOIA exemption for research and teaching. This bill closes that gap. That's why I support it. Thank you very much, and I'm happy to answer any questions.
Thank you. Thank you very much for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony today.
Thank you.
Next, we will hear from Anderson Curtis, who will be followed by Don Schubert, who will be followed by Michael Garriman. Anderson, welcome. The floor is yours.
Thank you. Good day, Senator Flexer, Representative Blumenthal, the ranking members, and the other distinguished members of the GA&E Elections Committee. My name is Anderson Curtis. I am the Senior Policy Organizer at the American Civil Liberties Union of Connecticut. I testify today in strong support of House Bill 5702, an act allowing incarcerated citizens to vote. The right to vote is a fundamental aspect of democracy and a core constitutional right of the people. Historically, people of color have been disenfranchised from exercising their right to vote. Currently, Connecticut law deprives people of the right to vote when they are in the custody of the Department of Corrections and convicted of a felony. HB 5702 would restore that right to vote to people who are incarcerated. As a person who has had my voting rights restored and exercises my right to vote, I believe enfranchisement is an integral way for all Americans to participate in the democracy that governs them. The ACLU has submitted written testimony, but I want to take a moment to describe my experience while I was registering people on parole to vote. And that was a direct result of Public Act 21-2, which happened last year. As a policy organizer, I worked multiple voter registration events. At a voter registration event on October 18th, 2022, I met Ron Hall. Ron had recently been released on parole after serving 40 years. Ron came to the event seeking to register to vote for the first time in his life of 60 or so years. Ron shared his experience surviving 40 years of incarceration, learning that he had the right to register to vote, learning how to register to vote. I even had taught him how to send a picture that him and I took to his sister that day that he registered. And yes, here's Ron on the day that he voted. The joy on his face is priceless. The impact of Ron Hall registering to vote in the state of Connecticut after serving 40 years of incarceration and voting is an impact that cannot be measured. Unfortunately, Ron is no longer with us today. Yet I carry his truth in my testimony. I believe his truth testifies to the persistence and courage needed to travel the distance with your humanity and dignity impact. I have yet to meet another person who travels such a distance as Ron, but we all who live with a criminal record know our personal distance because our experience is our power. And I'm talking about the distance from incarceration to being restored your right to vote to actually going to vote. By restoring a person's right to vote when they're incarcerated in Connecticut, people no longer to be deprived of that right. They will allow their voice in decisions and policies by the government that impacts their lives. Restoring the right to vote not only expands and strengthens our democracy, but it helps the person maintain connection to their community and helps them reintegrate into their community. It's important to note that voter disenfranchisement of people incarcerated disproportionately impacts Black and brown people who make up 70% of the state's incarcerated population. Also, over half the people who are incarcerated in Connecticut are parents. Restoring their right to vote would allow them to have input on decisions that shape the lives of their children and their communities. Two of our neighboring states, Maine and Vermont, have managed to consistently facilitate voting within their prisons. HB 5207 is an important step to help people fully participate in our democracy, so I strongly urge this committee to support this bill. Thank you for listening to my testimony.
Thank you. Thank you for delivering it. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this afternoon. Next, we will hear from Don Schubert, followed by Michael Garriman, followed by Benjamin Fuller. Don, welcome. The floor is yours.
Good morning, chairs, members of the committee. My name's Don Schubert. I'm the president of the Connecticut Construction Industries Association. I have to tell you that we have a very respectful relationship with Attorney General Tong, and we fully appreciate his intentions with this proposal. However, we are opposed to Bill number 6826, an act concerning liability for false and fraudulent claims as it applies to the construction industry. I have to tell you, in my experience over many years, CCIA has been actively engaged in contracting reform, and we continue to support balanced efforts to fight fraud, waste, and abuse in government contracting. We had a hand in creating the pre-qualification statutes in Connecticut. I personally was actively engaged in creating a contracting standards board. We worked with the Office of the Inspector General in Washington, D.C. for the US DOT all the way back in 2006 on fighting fraud, waste, and abuse in DOT contracting. And in doing so, we focus on ensuring that the integrity of the contracting process is preserved. We're basically opposed to this bill because it'll change the risk profile to state construction contracts. False Claims Acts have broad legal elements that are interpreted broadly by the courts. They have very low standards of proof, and they have extremely high penalties and damages. This is a very aggressive law for very good reasons. Our concern is that the loose legal standards of the False Claims Act are remarkably problematical with the uncertain nature of construction disputes. There's often no clear meaning of true or false on a construction project. Questions of interpretation of contract provisions, specifications, drawings, and other technical requirements may be matters of opinion in which reasonable minds may disagree without making a false statement. Determining liability and calculating damages is never certain in construction disputes and often involve wide-ranging opinions from accountants to engineers. Unfortunately, the False Claims Act's very aggressive provisions create incentives for abuse, even if unintentional, by public actors. One of our big concerns is when a response to a legitimate claim for payment is a false claims allegation and the counterclaims, just to raise the stakes in litigations to get the claimant to back off. This poses a real danger to all construction companies in Connecticut and also all the hardworking employees that work for those companies. This creates after all the contracting reform in Connecticut, this creates a very dangerous situation for a contractor. Just on filing of an action, a contractor could have collateral consequences of suspension.
Excuse me, sir, your time for testimony is elapsed. If you could just finish up your time
Yes,
of
I'm
testimony.
Yeah, or non-responsibility determinations, and could easily put an organization out of business. While no one believes that businesses should have the right to submit false claims to the government, the legislature must consider whether this law that places businesses and hardworking people at risk is necessary, or if it would be an appropriate addition to the state's contracting reform measures. Thank you for this opportunity to testify. I apologize for going over, Representative.
It's no problem. Are there questions from the committee? Let me just check the Zoom. I'll ask one. We've heard from the Attorney General earlier about how a number of contractors that work in Connecticut also work in other states that do have these false claims acts that cover the industry as well. Why is it that you all are so concerned about Connecticut adopting this statute when many of your members are already subject to similar statutes in other states and appear to be it doesn't appear to be negatively affecting them?
Representative, a large construction contractor has compliance officers in place. A large construction company has all kinds of accountants and things like that. They have all kinds of procedures and everything else. And if they do run afoul of a false claims action or something like this, and they're facing suspension and debarment, they can afford to have a monitor. They can afford to engage in huge litigation. A smaller emerging contractor doesn't have those things. And an emerging contractor may be at times more apt to make a mistake. or more apt to do something that would subject them to something like this. And I don't even know if they would be able to withstand one of these investigations, let alone the litigation that goes along with it. So those larger contractors that I know that are working in other states, they've been working under the Federal False Claims Act for years. They can do it. They know what it takes to have a compliance officer on staff. We have ethics and compliance summits for our members. We recently had the OIG in to come in and talk about false claims actions with DBE fraud. They can do that. My biggest concern is these smaller contractors. They're the ones that are really going to be at higher risk for this, not the big guys. And the big guys can withstand this. They can work with it. They price it. They put it in their price. They spend a fortune on a compliance officer. They put it in their price. They can afford to do that. It's the smaller contractors in Connecticut that I think may really be at risk with this. And I've been working with the Connecticut DOT for over 40 years. And I can tell you that there's a lot of very good talent there. I have a lot of respect for the people that have been handling claims over the years. But government contracting over the years has also changed. There's a lot more oversight. Like you said earlier today, there's federal transportation bill. The first thing they did was send, the Office of OFCCP, Office of Federal Contract Compliance Programs, is in our office doing regular compliance meetings with our members right now. But what about the people that aren't our members, that don't know about these things, that don't know how to comply? This is a dangerous situation for them. This is a rather large change in the law. And with the federal law, like you said earlier today, it's the U.S. Department of Justice that decides whether to go forward with a false claims action. You've got an outside third party that looks at the action itself. They make a written decision, and then they allow the AG to proceed with the action. In Connecticut, the Office of the Attorney General is often representing the state in a claim situation, almost all the time. So there isn't that third party objective look at a false claims action in a state false claims act that there is with a federal false claims act. And that in itself is a big distinction that I think everyone needs to be aware of.
Well, I take your point, I guess, on the smaller contractors in Connecticut, but presumably they're subject, smaller contractors in Massachusetts and all the other surrounding states that have these laws are also subject to them there, and it appears that they haven't been negatively affected. I did want to ask a question about another element of your testimony. You talked a lot about the danger of confusion, I guess good faith confusion or mistakes. And I guess my question is, the standard for a false claim under the statute is that it has to be made knowing or knowingly. It has to be a knowingly false claim, which means that they have actual knowledge of the truth and then act in deliberate ignorance or reckless disregard with regard to the truth or falsity of the information. So I don't understand how someone who knows the truth and then doesn't tell it, how that's a slippery or vague standard. It seems like one of the highest standards that we have in the law. So
I read that standard a little bit differently than you do, Representative. In my mind, the first element has actual knowledge of the information is basically watered down by acts in deliberate ignorance of the truth or falsity of the information, or acts in reckless disregard of the truth or falsity of the information without regard to whether the person intends to defraud. In my mind, those second and third elements water down the knowingly element. And maybe that's something we can discuss, but it's just the way I interpret that. I'm sorry.
I appreciate your feedback on that. And I mean, I think either way, that's a pretty high standard. Regardless of how you read it, that's a pretty high standard of knowledge. It's not certainly a negligence standard. It's one that demands a pretty irresponsible and close to purposeful misleading of the state with regard to the claim. So, it seems like a pretty high standard to me. And so I guess, I guess we just agree to disagree on that. I guess those are all my questions. I appreciate your answers.
Yes, so thank you very much for this opportunity to testify. And Representative, if I may, the one thing that really concerns me when we look at these legal elements, false is not defined. False is not defined. And when I practiced law years ago, one of the things that always bothered me the most was when two civil engineers disagreed with each other. And I never, there's nothing worse than that in a lawsuit, but false is not defined. And that just really, when you get in situations like that, you don't know which one is true and which one is false. But thank you very much for this opportunity today.
I appreciate that. I don't understand how that could be considered a knowing falsehood if you've just got two civil engineers disagreeing, but I appreciate your testimony.
Well, thank you.
And I'm sure we'll hear from more of your members and colleagues coming up.
And I'd be happy to be here for a resource for you at any time.
I appreciate
Thank you
that.
very much.
Next up, we have Michael Garman, followed by Benjamin Fuller.
Thank you. Thank you very much, Mr. Chairman, Madam Chair, and members of the committee. My name is Michael Garman. I'm a student from New Haven and a strong supporter of ranked choice voting. I'm here today to testify in support of all the RCV bills before this committee, especially SB 389. The principle of ranking is intuitive. If you've ever tried to get a group to pick an ice cream flavor or a restaurant to go to, you've used ranked choice methods. Ranked choice voting is just the same concept for elections. Don't just take my word for it, though. A nonpartisan poll asked Alaska voters how they felt about ranked choice voting after using it for the first time last year. 85% found it easy, and 95% said they'd received clear instructions. These figures were consistent across all demographics. With ranked choice voting, you can rank as many candidates or as few as you choose, from most to least favorite. If someone gets a majority of first place votes, they win. If not, the one with the fewest first place votes is eliminated and their supporters' second choices count now. Every vote only counts for one candidate at a time, one person, one vote. This continues until someone gets a majority. If you want to vote for just one candidate, you can, but you have a greater chance of being on the winning side if you rank as many as possible. With RCV, voters have greater freedom to select from candidates with nuanced views, and elected officials have a stronger mandate to govern, since they're guaranteed majority support. RCV also helps parties pick the strongest candidates possible. Analysts agree that one of the most important factors behind Republican Glenn Youngkin's upset in the 2021 Virginia gubernatorial election was the fact that the state GOP used RCV in their primary. Similarly, it's unlikely that Alaska would have a Democratic Congresswoman, Mary Peltola, without RCV. I have talked to hundreds of young voters, Democrats like me, Republicans, third-party supporters, and independents in the last few months, and I can tell how passionate people my age are about political issues. When campaigns are negative and focused on personal attacks instead of constructive arguments, though, it discourages us from participating. RCV encourages campaign civility, since candidates have to convince voters they'd be a good second choice even if their first pick is someone else. Similarly, RCV encourages elected officials to take into account the needs of all their constituents. Gen Z is by far the most diverse generation in U.S. history in terms of both political beliefs and identities. Please consult my written testimony for more information about how RCV can help all voters, including LGBTQ+ people like myself, get the representation we deserve. All in all, young voters are passionate about making our state and country the best places they could possibly be. We don't want to burn down the system. All we ask is for a seat at the table and the opportunity to work with people of all stripes to break through the gridlock and effect real, meaningful change. Ranked choice voting would bring about the spirit of compromise we desperately need and make us more optimistic about the future of Connecticut and the United States. With that in mind, I urge you all to support the RCV legislation before you, especially SB 389. Thank you very much for your time.
Thank you. Are there any questions from the committee? Seeing none, we appreciate you being here virtually and contributing your testimony.
Thank you very much.
Next up is Benjamin Fuller, followed by Amina, I beg your pardon, Koljanjic. That's definitely wrong, but I hope you'll correct me when you come up.
Thank you for your time, Chairman Flexer, or Chairperson Flexer, Chairman Blumenthal, and esteemed committee members. This testimony regards raised Senate Bill 1150. This testimony is submitted on behalf of the UConn Center for Voting Technology Research. My name is Dr. Ben Fuller. I'm a resident of Tallinn, Connecticut. This testimony is on behalf of the center. The Center for Voting Technology Research was created in 2006 to advise the state of Connecticut on election security, election technology, and auditing programs. Our team has studied and contributed to both theory and practice of risk limiting audits. We published academic work on the topic, led the design of the Connecticut pilot executed in January of 2022, authored portions of the report on risk limiting audits, and worked with the GAE committee in 2022 on the language in Raise SB 472, which is revised in SB 1150. We are strong advocates of risk limiting audits, which are known as RLAs. They provide a rigorous, cost-effective means of checking the veracity of an election, are designed to be transparent so that observers can verify the audit procedure and outcome. RLAs improve confidence in the entire tabulation process and can detect errors that might change election outcomes, including errors in tabulation, reporting, and aggregation. We emphasize that RLAs are the only known auditing technique that provide these critical guarantees, providing direct assurance that the final outcome of an election matches the physical ballots cast by voters. RLAs lead to more transparent and trustworthy elections. The National Academy of Sciences book, Securing the Vote, Protecting American Democracy, recommended that all states implement RLAs. RLAs are becoming the standard audit procedure with existing deployments in 11 states. We support Raise Senate Bill 1150. We do have one requested change. The Voter Center requests that the pilot program in Section 12 be conducted after the 2025 state election. This change anticipates statewide adoption of new tabulation equipment by 2025. The pilot carried out on this new equipment will best inform the creation of RLA procedures. More generally, developing the operational details of RLAs in tandem with the specification and procurement of new equipment will lead to the best results for both new equipment and RLA deployment. The Voter Center prepared a fiscal note in 2022 on the estimated cost of Raise SB 472 last year. We're developing a fiscal note on the upfront and continuing costs of supporting RLAs in Connecticut as specified by SB 1150. There are substantive changes in comparison with the 2022 fiscal note due to the anticipated adoption of new tabulation equipment. As new equipment will have superior support for risk limiting audits, we anticipate a decrease from the 2022 fiscal note and its addendum submitted by the Office of the Secretary of State. RLAs are the standard for verifying election outcomes. They are transparent, observable, and verifiable by the public. RLAs are also effective in finding common errors and improving election processes. We welcome any questions or clarifications both on the RLA committee recommendation and the benefit and trade-offs of conducting RLAs in Connecticut. Thank you for your time and attention.
And thank you. Are there questions from the committee? Seeing none, thank you for being with us today and for contributing your testimony. Next is Amina Koljanczyk. I'm sorry. Followed by Anthony Nolan, followed by Danielle Cheeseborough.
Good afternoon, Senator Flexer, Representative Blumenthal, and members of the Government Administration and Elections Committee. My name is Amina Koljanczyk. I am a resident of Wethersfield. I am testifying in support of SB 1158, an act designating various days, weeks, and months specifically in favor of item number 112 in the bill and Bosnian Genocide Remembrance Day. This day would designate July 11th as an official commemorative day for recognizing those lives lost in Srebrenica genocide and other atrocities during the Bosnian War. I am a second-year law student at Quinnipiac University and a proud member of the community in Connecticut. I came to the United States as a refugee in 2002. I was only 2 years old, so I did not experience the war, but it still had a huge effect on me and my life. Because of the atrocities that my people had to go through, I am so proud to be a Bosnian Muslim and always represent my community in the best light. I am so grateful for the community in Connecticut for being so kind and accepting of us and refugees in general. The war in Bosnia began in 1992 and lasted for 3 years for the purpose of displacing and committing genocide on Bosnian Muslims. My parents were younger than me when the war started. My mom was 17 years old when the Serbs, the aggressors, burned down her entire village, killed her father, and took her to a concentration camp. My mom was at the camp for 2 days and witnessed the scariest events possible. In 1992, she was hoping to graduate high school and live the life she loved with her parents and siblings. My father was 20 years old and had to run for his life when the Serbs, along with the Serbian army, had entered their village. They were not merciful towards anyone. Once my father reached a safe area, he decided to go back to his village and help the people there while my mom begged him to stay. Every night, he helped women and children escape to safe areas because the Bosnian Serbs, they did the most horrific things to women and young girls. I am so thankful that both of my parents made it out alive to live and tell their story. And I am so grateful to be here today. I urge you to support SB 1158 so we can truly follow the phrase never again. Thank you.
Thank you, Ms. Kuljancic. Did I do that right?
Yeah.
All right, learning has occurred. Any questions from the committee? Representative Morambella.
Amina, thank you for coming here today and advocating and speaking out. I appreciate that.
No, thank you guys so much. Thank you.
Further questions from the committee? Seeing none, we appreciate you being here to share your testimony. Next up is Representative Nolan, followed by Danielle Cheeseborough, followed by Ed Hawthorne.
Good afternoon, Senator Flexer, Chairwoman, and Chairman Blumenthal, and ranking members, and Rep. Lauren Bellows. Thank you for allowing me to come in and speak after being at numerous things today. I'm here to ask for your support in regards to SB 1158. As the speaker before came and spoke in regards to the many important things in that bill, I wanted to talk in reference to Ann Petrie, which is, I think, on the second page of the bill. We celebrate March as a National Women's History Month, which should prompt us to ask the question, why is there not a day to celebrate the history of Ann Petrie? Ann Petrie was the first African-American writer to sell over 1 million copies of her groundbreaking novel published in 1946 called The Street, which is one of the first novels to address the experiences of Black women in terms of race, class, and gender. She is known to be one of the most prolific writers of that century. Ann Petrie was born and raised in Old Saybrook, Connecticut, where she received a degree in pharmacist from the University of Connecticut of Pharmacy in New Haven in 1931, and worked in her family business for several years, while also writing short stories. In 1938, she moved to New York and worked as a journalist, writing articles for newspapers between 1944 and 1946. She studied creative writing at Columbia University. She also worked at an after-school program at a public school, number 10 in Harlem. It was during this period that she experienced and understood what the majority of the Black population in the United States had to go through in everyday life. She returned to Old Saybrook after her notoriety of The Street, and in 1947, she completed the writings of Country Place. In 1947, The Narrows in 1953. She was also known for her other stories, including children's books. However, these other writings never achieved the same success as her first book. She also lectured at the University of California, Berkeley, Miami University, and Suffolk University, and was visiting professor of English at the University of Hawaii. In 1944, she was inducted into the Connecticut Women's Hall of Fame, where the Writers and Journalists category and the Department of the Interior listed the pharmacy building where she was born on the National Registry of Historic Places. Tara Jones was an established author who also wrote in 2018, "I can't figure out why this work is not more widely read and celebrated." After such a stunning reception in 1940, Why hasn't this novel become a college staple? Connecticut should be asking the same question. We gave a citation in regards to Ann Petrie last month at the Waterford Rise event in Waterford, Connecticut. This bill was put in by Representative McCarty, and it's just something that I believe is real important as far as coming to recognize someone who has done something amazing, especially as a Black woman, to get 1 million copies of her own book. And I just wanted to come before you and read a little bit about her so that you had a little bit more understanding, and ask for you to consider this to pass through the committee. And I'll answer any questions if I can.
Thank you very much, Representative Nolan. Are there any questions from the committee? Seeing none, we appreciate your testimony here today and your advocacy for this bill.
Thank you for allowing me to come up before you after a day full of stuff. And thank you guys for doing this marathon that you're doing today.
All right, next up, Danielle Cheeseborough, followed by Ed Hawthorne, followed by Kate Byrode.
Hi, thank you so much. Just to echo Representative Nolan, thank you for the marathon, of which I'm sure is many while you're in session. So for those who don't know me, I'm Danielle Cheeseborough. I'm the first selectman of Stonington, Connecticut, and also a member of the Connecticut Voters First Advisory Board. And I'm here to offer my testimony in support of Senate Bill 389. Both myself and my colleagues from around the state have testified before many of you on various bills of importance to our community, and you have no doubt heard from many of your own constituents regarding different proposed bills that are critical to the diverse array of stakeholders. It is with that understanding that I come here to say, I believe the bill before you today is the most important bill you will hear this session. And that's because it impacts the very foundation of our democracy. It will impact the future of how legislation will be formed across our country and how it is discussed and how it's presented to voters. We are currently in one of the most polarized eras of our recent history. Research continues to show Democrats and Republicans viewing the other party as not just opponents, but as a threat to the nation's well-being. And it's not just true when it comes to the political parties. A recent Pew poll showed that the public's trust in their elected officials and in one another is at an all-time low. It seems so many Americans and those watching our country believe our political system is dysfunctional. We are in a bad place, but it's not beyond repair. I really believe that with every challenge comes an opportunity, and ranked choice voting is such an opportunity. It gives people with diverse views and backgrounds a better option to get involved. I know from speaking with local officials from around the state that it is very hard to find good people willing to run at any level. So I keep asking myself, why have we allowed a system that puts up artificial barriers to nearly 50% of Connecticut residents who are not in either major party? Speaking from personal experience, it's extremely challenging to run for office at any level if you are not in one of the major parties. I believe we should be doing all we can to recruit and engage potential candidates to serve. Instead, we are putting up unnecessary barriers and limiting our potential as a state and a country. There's a reason that ranked choice voting is gaining momentum around the country, with increased bipartisan support from current and former elected officials, such as former President Barack Obama and former Florida Republican Congressman David Jolly, just to name a few, as well as 9 different Nobel laureates. We are facing such complex issues, long-term challenges, and our current system is just not set up to help elected officials solve these problems. The current partisan system is not productive, nor is it sustainable. It is often more politically valuable to leave the divisive, challenging problems unsolved and continue to turn out the base on unproductive ideological divides. We continue to allow for a
Excuse me,
system.
Ms. Cheeseborough, your time of testimony has expired. If you could please wrap up your testimony.
Yes, I'll just say that I really think that all of you have an opportunity to be part of history, and I hope you'll take up that challenge, and we're here for any questions you might have.
Thank you very much. Are there questions from the committee? Seeing none, I thank you for being with us remotely today and giving us your testimony. Next up is Ed Hawthorne, followed by Kate Byrode, followed by Gus Marks Hamilton. Mr. Hawthorne, whenever you're ready.
A little bit too high with the microphone. Good afternoon, Senator Flexer, Representative Blumenthal, Representative Morambello, Representative Haddad, and my state representative, Master Franceso. My name's Ed Hawthorne. I'm proud to represent over 200,000 working men and women as the president of the Connecticut AFL-CIO. It is on their behalf I sit before you here today to testify in strong support of HB 6826, an act concerning liability for false and fraudulent claims. Now, this, as you've heard before, I'm sure you've heard a bunch of testimony you did hear from the Attorney General himself today. It expands the authority of the Attorney General to investigate all state contracts for fraud and abuse. Currently, his office only has the authority to investigate less than 10% of all state agencies. He's limited to health care and human services. And yet they've recovered $180 million during a 13-year period by rooting out fraud that's from our tax dollars that gets returned to the people. I do want to address some testimony that I heard earlier, but before I do that, I want to talk about trust. Now, I often hear the phrase, if a tree falls in the forest, does it make a noise? If a law is on the books with no enforcement, what good is the law? Doesn't make a noise. We asked the committee to untie the hands of the Attorney General so he can do his job and he can represent the taxpayers of the state of Connecticut and root out fraud and abuse wherever it may be. And I was present when Don Schubert from CCIA testified earlier. He talked a lot about the standard, and I couldn't disagree more that it's a low standard of proof. Knowing is a very high standard of proof. You have to know what you are doing and do it anyway. And then to try to pass off the fact that, could be an honest mistake, or I heard earlier, good faith error, that's not knowing. Those are mistakes. And the law will differentiate that. I mean, they do it every single day in the courtroom. And also reckless disregard that was mentioned earlier, that's even higher than knowing. That is literally, that's acting with reckless intent. As far as, a fundamental notion of fairness, I believe we need to reward good actors and punish bad actors. This law is not hostile towards business. It's hostile towards businesses that don't play by the rules, that want an uneven playing field, that want to try to cheat their employees, especially in the construction industry, and not pay them the prevailing wage, or misclassify them at a lower level in order to cut their salary and take food off of their table. And that's why the Connecticut AFL-CIO is in such strong support of this, because we need to make sure that when this tree falls, somebody's there to hear it, and the Attorney General is there to catch them and restore the trust in government spending in the state of Connecticut. So I thank you all for your time, your attention, especially during this very long hearing. I'm getting buzzed, so I'd actually have pretty good timing, and I'll be happy to answer any questions you may have.
Thank you very much, sir. You timed it perfectly. Are there questions from the committee? I was hoping you would tell us a bit. So you talked about wage and hour or prevailing wage issues. Could you describe for us, first of all, how the False Claims Act will come into play to help root out fraud related to those issues? And also, in your experience through the AFL-CIO, what is the prevalence of those sort of issues in Connecticut as well as across the country?
Those issues are prevalent everywhere. I mean, contractors are based off of the lowest qualifying bid. So a lot of contractors from other states are actually attracted to Connecticut because we have such loose laws when it comes to enforcement and things like that. So they'll actually build into a bid fraud. They'll actually build into it lower pay. So that's why our surrounding states, we're actually attracting people now that are bad actors. So we were talking about the surrounding states already have this enforcement. We need more enforcement. I come from the Department of Labor. Prior to having this job, I worked for the Connecticut Department of Labor. I represented wage and hour investigators. There are not enough of them to enforce the laws that are on the books. There's not. I argue every day that we should have an army of people rooting out fraud because they end up taking in more money than we actually pay them. The same is true here. Let's root out fraud and abuse. Let's make sure people are paid what they're owed. What contractor will normally do on a job site, or not normally do, but the unscrupulous ones will try to do, is say they're supposed to be paid at a higher level. They'll say, no, that job was performed at the lower level job, and they'll pay them a lesser hourly rate. And that's where the wage theft comes into play. So if somebody's doing a higher classification job that should be paid at a certain level, the contractor's purposely paying them less to increase their bottom line. And that's not fair to the taxpayers. That's not fair to the person that's getting cheated. And we need somebody to get this money back for them.
I appreciate that testimony and explanation. I was wondering also, you know, the AFL-CIO is a national organization. And I was wondering if you could testify all about how False Claims Act across the country have prevented this sort of fraud, and whether contractors or others in the construction business have been able to continue to function and do business even in those states where they have a False Claims Act that covers that area of business.
To the best of my knowledge, it hasn't affected contractors in other states negatively. There's a set of rules that everyone should, you know, play on. And unfortunately, due to lack of enforcement in Connecticut, they're not playing on the same set of rules as they are in surrounding states. I can get you more information and get you somebody that really deals with that on the national level. And I'll make sure somebody follows up with you regarding that.
Well, I appreciate that very much and appreciate your testimony. Are there any? Representative Mastrofrancesco has a question.
Thank you, Mr. Chairman. I apologize. Very nice to see you. Thank you very much, Ed, for coming in. Just a quick follow-up. So right now, what is happening? How are false claims being filed for the contractors? There's no law in Connecticut right now that they can do that. What is the process right now?
They'll file the claims through the, it's my belief, they'll file the claims through the Connecticut Department of Labor, but there's such a lack of wage investigators there. If you go to the website right now, it's a wait time of 4 to 6 months. Wow. 4 to 6 months for people to get their money just back that they're owed. So for a complaint to even be heard. So it's not often we have somebody asking to do additional work. The Attorney General is asking to do that, and I believe they're well suited to do that, just as they do in other states.
In your knowledge through the Department of Labor, about how many claims come in a year on that? Any idea? I mean, is it, they're backed up, obviously.
Oh, yeah.
And it's taken a while to process that. Is it weekly that this is happening?
Claims come in almost constantly, Madam Representative. It's, you know, it's hard to keep up with it when you don't have the people to keep up with it. And that's really where that department is. The Attorney General does work hand in hand with them. But when they conduct the investigation, they hand it off to the Attorney General to negotiate the penalties and things such as that. So it really is there's not that proactive. So right now you're talking about reactive, right? There's that reactive of, oh, we filed a complaint. I mean, we could take that a step further and actually be proactive and go in and make sure everyone's following the rules and not wait for that complaint. Because often people are scared. You get shorted a few dollars, you think, well, maybe they'll fire me if I come in to file a complaint. And that's another important aspect of this bill is it, you know, it protects whistleblowers. That is another thing that is great about this bill, that it protects whistleblowers that are willing to come forward. And oftentimes, you know, people are scared. You know, a lot of people work paycheck to paycheck. There's a study out there that shows, you know, people can't, an unexpected expense of $400 is just too much for them. So when you think about filing complaint based off, you know, few $100s, maybe $1,000 here and there, they might wait and say, you know what, I'm just going to let this go and just keep going with it. But if somebody comes in and asks them what's going on, maybe it comes to light and maybe they're made whole.
Thank you. I'm just curious. So should this pass, how would it help the Department of Labor? Because they still have to file the claim, right? They still would have to file the complaint, and that would still go through the Department of Labor, correct?
I'm not sure if it would still go through the Department of Labor. I think the Attorney General will be able to directly investigate. Correct me if I'm wrong, Chair.
I don't know. It's a labor. I'm thinking it's a labor issue. So I'm just curious how this would help.
I look at it as OSHA. So OSHA, we have Con OSHA, we have Fed OSHA, right? So Con OSHA takes care of our state contracts and federal OSHA takes care of the private. Right. It would almost be that way with construction here, where, you know, the private contractors and things like that, it wouldn't limit anything. It would just be a better way of getting to the fraud and abuse that may be underlying in the construction industry. I mean, we have billions of dollars coming in right now from the federal government to rebuild our infrastructure in our state. And we need to make sure that it is spent the right way. It's restoring trust in the government, because fraud and abuse leads to mistrust, and that doesn't help anyone.
No, and I certainly agree. I think fraud and abuse is on top of everybody's minds today. There's so much money floating out there, and I think people want to know to make sure that it's being spent wisely, and there certainly is no abuse. So I can certainly appreciate that. Thank you very much for testifying today. Thank you. Thank you, Mr. Chairman.
Thank you. Are there any further questions for this witness? Seeing none, I'll thank you for being here today. I appreciate your testimony, and also for pointing out specifically that not only is fraud against the state in this sort of situation fraud against the taxpayer, but it also hurts individual workers and also all those businesses that are trying to play by the rules. So we appreciate you bringing that holistic picture to us today. Thank you very much for your testimony.
Thank you all.
Next is Kate Byrode, followed by Gus Marks Hamilton, followed by Ellen Paul.
Good afternoon, Senator Flexer, Representative Blumenthal, and honorable members of the committee. My name is Kate Byrode, and I am the director of the Cragen Memorial Library in Colchester, and I'm a resident of West Hartford. I'm here in support of House Bill 6829. I want to thank you for raising 6829 in this committee and appreciate your interest in the issue of the pricing and licensing terms Connecticut's libraries face as we struggle to build digital collections. Like many towns in Connecticut, Colchester passes its budget by annual referendum. This past year, it took 4 attempts to pass a budget. My job as library director is to responsibly steward the $53,000 appropriated for the purchase of library materials, everything borrowed by our users. It isn't a lot of money, about $3.42 per capita. Thanks to statewide purchasing contracts, we never, ever pay sticker price for physical library materials. Last year, we saved $25,000, stretching that budget by an additional 47%. But with ebooks and e-audiobooks, it's exactly the opposite. I can't stretch that taxpayer dollar. We're faced with a completely different marketplace. We pay far more than the consumer does for these same materials, even though we lend them exactly the same way as physical materials, one borrower at a time per copy. What adds insult to injury is that the majority of titles I purchase disappear from our virtual collection after 2 years, as most titles are licensed for 24 months or 26 loans, whichever comes first. I can't build a collection. Together, these practices make it virtually impossible to carry out a core mission of libraries, to build meaningful collections over time to serve their community's needs. Whether it's popular fiction or nonfiction titles in American history, social issues, economics, parenting, or cookbooks, we select with an eye to the future. When libraries buy physical materials at a substantially less than list price, we know that authors earn royalties and publishers make a profit. Otherwise, there wouldn't be a publishing industry. It's a wholly disingenuous argument that if libraries purchase digital materials more cheaply and could keep them on their virtual shelves longer, that the industry would suddenly collapse and authors wouldn't earn royalties. We believe better terms would make for better libraries for our communities. We believe better terms would result in more royalties for authors and continued profits for publishers. I believe HB 6829 would put Connecticut on the road to better stewardship of taxpayer dollars. Thank you for your time and attention. I'm happy to answer questions.
Perfect timing. All right. Do we have any questions from the committee? Seeing none.
Okay.
I appreciate your testimony. Thanks for being with us today.
You're welcome. Thank you.
Next up is Gus Marks Hamilton, followed by Ellen Paul, followed by Bakir Hodzik.
Good afternoon, Senator Flexer, Representative Blumenthal, ranking members, Representative Mastro-Francesco, and distinguished members of the Government Administration and Elections Committee. My name is Gus Marks Hamilton, and I work as the campaign manager at the ACLU of Connecticut Smart Justice Campaign. And I'm here today to testify in support of House Bill 5702, an act allowing incarcerated individuals to vote. The right to vote is a fundamental aspect of democracy and a core constitutional right that should never be taken away. However, Connecticut law deprives people of the right to vote when they're in the custody of the Department of Corrections and convicted of a felony. HB 5702 would restore the right to vote to people who are incarcerated on a felony conviction. As an organization that believes that enfranchisement is an integral way for all Americans to participate in the democracy that governs them, the ACLU of Connecticut supports this bill. We have also submitted written testimony, but I want to take a moment to describe my own experience and why I believe this committee and the General Assembly should restore the right to vote for people who are incarcerated. I spent nearly 8 years in Connecticut's prisons and jails. I had a very up close and personal look at how one of the state's largest agencies was operated. While I was incarcerated, legislation was passed by the General Assembly and signed into law that impacted the length of my sentence and when I was eligible for release. And that happened twice. While I was incarcerated, I paid taxes, yet never had representation here at the legislature. I thought it was ironic that I developed a better understanding of our state government, how it worked, and the impact of its decisions while I was in its custody, yet was never more disenfranchised and alienated from my rights as a citizen. When I was released and became eligible to register to vote, I immediately did so at my town clerk's office. And when I voted a few months later, it was an extremely proud moment for me. Yet I know many people who are also formerly incarcerated who have completed their sentences a long time ago and are still not registered to vote. They have told me that they feel an almost permanent alienation from their fundamental rights of citizenship. By restoring a person's right to vote when they are incarcerated, Connecticut would no longer deprive people of their fundamental civic right and allow them to have a voice in the decisions and policies made by government that impacts their lives. Restoring the right to vote not only expands and strengthens our democracy, it also helps to maintain a person's connection to their community and helps them reintegrate into their community when they are released. HB 5702 is an important step to help more people more fully participate in our democracy. So I strongly urge the committee to support this bill and thank you for listening to my testimony.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony today. Next, we will hear from Ellen Paul, who will be followed by Bakir Hodzik, who will be followed by Aleskia Tilly. And I welcome corrections for my pronunciation. Welcome, Ellen. The floor is yours.
Thank you. Thank you, Senator Flexer and honorable members of the committee. I am here today in support of House Bill 6829, an act prohibiting electronic book and digital audio book license agreements or contracts from including certain terms. My name is Ellen Paul. I am the executive director of the Connecticut Library Consortium, and every day I negotiate publicly bid contracts for libraries. The Connecticut Library Consortium is written into Connecticut General Statutes 11-9E as the Cooperating Library Service Unit, and we receive, we are partially funded by a line item of the same name in the state library budget. The state appropriates approximately $124,000 to our organization each year to negotiate publicly bid contracts on behalf of over 950 libraries across the state of Connecticut. As we talk about libraries and ebooks, I think it is important to understand the full scope of the library marketplace. The state of Connecticut has the Department of Administrative Services for their purchasing and procurement. Libraries across the state have the Connecticut Library Consortium. We serve every public library, public and private colleges and universities, and school libraries from Greenwich to Woodstock. We have over 100 publicly bid contracts that adhere to state, federal, and municipal procurement law for everything that libraries buy: books, supplies, technology, equipment. With an average discount of 40% off of list price, we save Connecticut taxpayers millions of dollars each year with our contracts. If you pick up a physical book in any public library across the state of Connecticut, you can be assured that that library did not pay full price for that physical book. They paid about 50% off of list price because they bought it off of our contract. Every public library in the state uses our contracts. But when we talk about ebooks, the same rules do not apply. Publishers will not negotiate the price, terms, and conditions of ebook contracts. Somehow, ebook publishers and vendors have been able to run afoul of procurement law for the last 20 years. With HB 6829, we are asking for that to change. Libraries across the state spend state, federal, and municipal dollars on ebooks. The state absolutely has the purview and an interest in regulating these contracts to ensure that those tax dollars are spent responsibly. As you have heard, libraries regularly pay up to 6 times the consumer cost for a license to lend an ebook, and then that license expires after 2 years or 26 borrows. The state would not allow a non-disclosure clause in their contracts. They wouldn't accept being charged 6 times more than general consumers for the same product. And yet libraries spending state, federal, and municipal tax dollars have been accepting these terms for years because publishers refuse to negotiate. I urge the members of the committee to support this bill and support the responsible use of public funds.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Representative Haddad.
Thank you. I'm gonna try to put this in the form of a question, I guess, but let me just say that this reminds me of a legislation that we did a couple of years ago around the availability of open source textbooks for colleges. And what we were hearing from students is that digital versions of their textbooks were nearly as expensive, and they wouldn't get any trade-in value for them, right? And so we had testimony from the publishers at that point, which actually proved quite helpful to us in passing good legislation. I don't know if any publishers will come before us today. But my question, I guess, is how much of this is analogous to, are there open source ebooks that are available to libraries, and do most public libraries access them?
So great question. There are some ebooks that are in the public domain. They've been around long enough that you can access those. But they aren't your James Pattersons, your bestsellers. Those are the things that you're still going to need to pay those inflated prices for. And then you as a library are going to lose access to those materials after that license agreement expires 2 years or 26 borrows.
Yeah, William Shakespeare, I guess, is maybe not as popular as James Patterson, though. One could agree that maybe he should be. And so after just 26 uses for an ebook, that's when the license expires, or 2 years, it's whatever comes first.
That is the majority of ebooks that libraries purchase, are under that 2 year or 26 borrows. So you can imagine an ever popular book like Harry Potter, you have to continue to purchase it over and over and over again at those same inflated prices to allow that 5th grader to be able to read Harry Potter in digital form.
Yeah, thank you for your testimony. I sitting here, I decided to co-sponsor the legislation, and so I wish us good luck.
Your colleagues in Mansfield, I'm sure, will appreciate that.
Thank you, Representative, and thank you again for your time and your testimony this afternoon. Next, we will hear from Bakir Hadzik, followed by Alessia Tilly, followed by Glacia Komardi. Welcome. The floor is yours. And again, please correct my potential mispronunciation.
Thank you. My name is Bakir Hadzik, and I'm a resident of Hartford. I'm also a freshman student at Vassar College, and today I'm testifying in support of SB 1158, specifically the section of the bill concerning the Bosnian Genocide Remembrance Day. Growing up Bosniak American, the genocide has defined my identity. For one, it's the reason why my community is here in our state. And I also grew up hearing countless stories from family members about how they survived horror after horror in their mainland. One of my earliest memories is of going to Bosnia to bury my father's brother after he was recovered from a mass grave, to bury the uncle that I was named after. The uncle who was 3 years into a mechanical engineering degree, who worked as an interpreter for the United Nations in Srebrenica, who the UN denied protection to when the Serbs invaded Srebrenica. The uncle who I will never know. And I could never forget my many visits to the Srebrenica Porešari Memorial to see his grave, where I stood by and prayed among thousands of marble tombstones, an army of lost lives and tragedy. Despite the genocide, Bosniaks have managed to establish themselves and thrive across our state. Yet the genocide still produces pain. How could it not? Little over 25 years ago, we watched as our grandfathers, grandmothers, mothers, fathers, brothers, sisters, cousins, and more died, slaughtered not for any crime, for their ethnicity and religion, things they could not control. And today, genocide denial runs rampant in Bosnia. It's even present in America, with lay people and academics alike trying to revise history to paint Bosniaks as liars and aggressors. We must fight that revisionism. We must commemorate. We must never forget. Otherwise, we risk validating fact over fiction, erasing actual history, and hurting those survivors who have already endured enough pain. This bill matters not because it does something massive. No, it is a small step forward, but it is a step forward. It helps preserve the memory of so many innocent lives, and it provides an opportunity for my community and for our entire state to learn about this tragedy and grow from it, to understand that no one should lose anyone to such senseless violence. In a world where crimes against humanity seemingly proliferate with little abandon, saying nothing forms a dangerous precedent. Let us set a better one and make never forget mean something. I urge you all to support SB 1158 and help it pass this legislative session. Thank you.
Thank you. Thank you very much for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your patience today. Next, we will hear from Alessia Tilley, who will be followed by Shaila Cromarty. Welcome. The floor is yours.
Hello, distinguished members of the Government Administrations and Elections Committee. I thank you for your time today. My name is Alieska Tilley. I'm a Danbury resident, and I will graduate with my MSW from UConn School of Social Work in May. I am here testifying in support of House Bills 5702 and 5714, allowing incarcerated individuals the right to vote. Disenfranchisement in Connecticut disproportionately impacts Black and Latino people, as they make up 60% of Connecticut's prison population, but only 13% of Connecticut's general population. This is both a human and civil rights violation and a form of systemic racism. Additionally, more than half of Connecticut's incarcerated population are parents, and 80% of incarcerated women are the primary caretaker of their children. All non-federal prisons in Connecticut are state-owned prisons. Incarcerated people should have their constitutional right restored to vote for legislators that hold the power to determine policies that directly affect their everyday experience, livelihoods, and their children and families. Engaging in civil process reduces recidivism significantly, and many studies show that people who vote have better health and well-being outcomes overall. Continuing to deny incarcerated individuals this right further excludes them from benefiting from these positive outcomes. Connecticut should choose to join its fellow New England states, Vermont and Maine, and be a leader in choosing to dismantle policies set in racism and slave era and restore incarcerated people their constitutional right by passing these bills. I also encourage the committee to establish standards necessary to properly exercise this right while incarcerated, including outlining the need for prisons to supply sufficient voter registration forms, absentee ballot, postage, and any other materials necessary to vote and register to vote. establish the process for registering to vote and voting in prisons, and allowing the address in which someone lived before becoming incarcerated when registering to vote. Ensure that all incarcerated individuals are made aware of their right to vote and informed when important election dates are approaching. Collaborative efforts should be made between the Department of Corrections, the Secretary of State, and the community organizations and advocates dedicated to criminal justice reform when making policies regarding incarcerated individuals and the right to vote. I urge the committee to support bills 5702 and 5714. I also want it on the record that I support ranked choice voting and universal voting in Connecticut. Thank you for your time.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Gloshaila Cromarty, followed by Rebecca Harlow, followed by Shannon Lane. Gloshaila, welcome. The floor is yours.
Hello. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and members of the Government Administration and Elections Committee. My name is Gloshaila Cromarty, and I am a Social Security Disability Claims Specialist in the Disability Determination Services Unit in the Department of Aging and Disability Services, with over 13 years of service. I offer the following testimony in support of Senate Bill 1157, an act concerning revisions to the Freedom of Information Act concerning employees of public agencies. I have also provided a more detailed written testimony. In my job as a disability claims specialist, I make Social Security disability determinations for residents of Connecticut. When claimants are denied benefits, they can often become very upset, and at times they can become threatening to disability claims examiners because the disability examiner is the person who they have been in contact with throughout the duration of their claim process. Last year, I made a determination on a particular claim. This particular claimant was denied for benefits. This claimant became enraged that he was denied and believed that I must have mishandled his claim. He created a narrative that I was incompetent and even implied that I may have been discriminating against him due to his nationality. He did extensive research, not only into myself, but also on my husband. And he compiled a letter laying out those research details. He filed a complaint against me through the ethics department, along with his letter. And that complaint was actually dismissed as having no merit. He also filed a complaint with the Department of Aging and Disability Services, along with his letter. The agency informed him that I had handled his claim properly and I did no wrong. However, he was adamant to prove that I was incompetent. He requested a copy of my personnel file under the Freedom of Information Act. This made me very worried for the well-being of myself and my family. This claimant seemed obsessed with discrediting me, and now he wanted access to even more of my personal information that could be found in my personnel file. Although my Social Security number and birth date were going to be redacted, my address would not be redacted unless I could prove that I had already taken steps to have my address removed from the internet searches. Fortunately, I had done this, but otherwise my personal address would have been confirmed to this claimant. All the emails that I had done had to be included as well. Some of those emails were emails that included talking about the birth of my child. And since the emails were dated, someone could easily figure out the age of my child. I felt helpless knowing that this claimant, who had already apparently spent significant time going through extensive research of myself and also my husband, would now potentially be able to figure out the age of my child. My file also included my W-2 tax forms with my number of dependents listed, financial documents concerning the purchase of my home, college transcripts, employee evaluations, and more. I am so grateful that I am a part of a union that supported me through this process. However, they could not stop the ultimate release of my file. Therefore, the claimant was told that he could pay for a copy of my file and pick it up at the Human Resource Office. Thankfully, this claimant had a change of heart and finally admitted that I had done no wrong, and he withdrew his claim request for my file. I still wonder, though, what would have happened to me, my family, or my coworkers if he had not done this. The open and transparent operation of state agencies is essential to our democracy and at the foundation of the idea of government of the people, by the people, and for the people. However, that does not.
I'm sorry to interrupt you, but can you please wrap up?
Yes. However, that doesn't mean that my home address should be accessible in a FOIA request. Thank you for considering this bill for the safety of myself, my coworkers, and my family. Thank you.
Thank you. Thank you very much for your time and your testimony. Are there any questions or comments from members of the committee? Well, I'll just say thank you again, and you certainly provided more compelling information than what we heard from the people who think this proposal should not go forward. So thank you, Lila. Thank you very much for that. Next, we will hear from Rebecca Harlow, followed by Shannon Lane, who will be followed by Madhu Gupta. Welcome, Rebecca. The floor is yours.
Thank you. Good afternoon, Senator Flexer, Representative Blumenthal, and distinguished members of the committee. Thank you for the opportunity to speak. My name is Rebecca Harlow. I work for the Case Memorial Library in Orange, and I live in Woodbridge. I'm here to express my support for HB 6829 regarding ebooks. I'm the chair of the ebook committee for Lion, which is the third largest library consortium in Connecticut. And I've been managing our digital book collection through Overdrive for the last 10 years. I'd like to share some of the data I've collected in that time to illustrate how unreasonable the current terms set by publishers are. When Lion began purchasing ebooks in 2007, all books were sold under the one copy, one user model, which says that once we purchase a book, we are able to lend that in perpetuity. At that time, we paid under $20 per copy. And this was the only time that the terms were similar to what we see for our print collections. We experienced anywhere from 5 to 10% increases in prices each year. And the first major shift that we see in terms happened in 2012 when the metered model entered the market. Over the next 10 years, more publishers moved toward that model, and those costs continued increasing in spite of the fact that we no longer were able to keep that title in perpetuity. Now in 2023, over 82% of the books we purchase are metered, and the average cost per title is over $42, which is a 100% increase over the last 10 years. Now we're spending between 30 and 40% of our budget just replacing a small fraction of the metered titles that have expired. By comparison, my library spends far less than 1% of its budget replacing print books. On average, the Lion Consortium spends over $20,000 a month on digital books, most of which is spent just trying to keep existing holds lists down. There's a 6-month-long wait list for almost every new title in our collection, and an at least 4-month-long queue for expired titles to be repurchased. By the end of the year, the Lion Consortium will have spent over $2 million taxpayer dollars on digital books through Overdrive, not including the $50,000 annual hosting fee that we pay just to make that content available to our patrons. In the last 10 years, we've lost access to over $1 million worth of content. And if we stop purchasing digital books today, by 2025, we would only have 14,000 books to show for a nearly $2 million taxpayer investment. If you're a child, if you're a teen, if you read in a language other than English, or even if you simply read nonfiction, libraries cannot afford to meet your needs under the terms that are currently offered by publishers. I hope you will agree that, contrary to what I read in the testimony from the American Association of Publishers, this is not a system that serves libraries and its communities well. On behalf of our consortium, my library, and the residents of Connecticut, I urge you to support this bill, and thank you for your time.
Thank you. Thank you for your time and your testimony today. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you.
Next, we will hear from Shannon Lane, who will be followed by Madhu Gupta, who will be followed by Lindsay Farrell. Welcome, Dr. Lane. The floor is yours.
Good afternoon. Thank you, Senator Flexer and the rest of the committee. My name is Shannon Lane. I am a professor at the Wurzweiler School of Social Work. I work with the Humphreys Institute at the University of Connecticut, and I'm the Deputy Registrar of Voters in the town of Bethany. I wanted to say two quick things before I make my main points today. One is just that the last time I was in this room to testify in front of this committee, Representative Williams was here, and I just wanted to know that I know you all miss him and we all miss him as well. The other thing I wanted to say, as somebody who's written 2 textbooks, is we desperately depend on libraries to make sure our students can get access to those books. And I don't speak for all authors, but I make almost no money off of it. So I really want to support the librarians here today. I've had the opportunity to work on issues around voting rights and voter suppression, including a recent article on voter suppression and incarceration. And I wanted to make 3 points today. The first is that felony disenfranchisement is racist in its intent and its impact. If you look at the Constitution of the state of Connecticut in 1818, it was we were one of the only New England states that specifically said you had to be white in order to vote in Connecticut. And while other states in New England had, for example, got rid of literacy tests earlier than we did, we're in compliance with the 15th Amendment earlier than we did. We took a while to get to that point. And today, as you've heard, felony disenfranchisement continues to systematically reduce access to voting and political power in communities of color. Millions of people can't vote because of their felony status, but also millions of people don't vote because they're confused by the rules around voting, and also the professionals they work with are confused about these rules. And the Humphreys Institute and my students at Wurzweiler are in the process of gathering some more data about that to help you all inform your decisions. The second thing I wanted to say is that retaining voting rights for folks who are incarcerated benefits everyone. It benefits their communities because they have the power to continue to address the systemic issues and the needs that they have. It allows folks who are incarcerated to vote in ways that help their children and their communities and their families. And it reduces recidivism, which saves us lives. It saves us dollars. It's good for everyone in Connecticut. And as Tanya Rhodes-Smith and others have already stated, people who vote are healthier, their communities are healthier, and that's important for us in Connecticut. And the last thing I wanted to say, to echo something Senator Sampson said earlier today, is that voting is a right. It's a basic human right, and removing this right works against the goals of rehabilitation and reentry to society. It lowers the political power and voice of communities that affect change, and it perpetuates systemic racism. So for me as a deputy registrar and a social worker who works every day to make sure our voting system provides access to everybody who's eligible to vote, particularly those who are frequently cut off from their own rights and access to power, I support this legislation, and I ask you to do it as well. Thank you for your time.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, I would just say the committee looks forward to seeing that research when you and your students are finished with it.
Absolutely.
Thank you very much for your time today. Next, we will hear from Madhu Gupta, followed by Lindsay Farrell, followed by Pamela Armstrong.
Good afternoon, Representative Blumenthal, Senator Flexer, and distinguished committee members for the opportunity today. My name is Madhu Gupta, and I'm the director of the Public Library of New London, and I'm the resident of East Lyme, Connecticut. I speak in support of HB 6829. When everything was shut down due to COVID, the libraries provided access to e-resources, including ebooks to our patrons. The demand for ebooks has significantly increased over these years. A library is able to buy a print book from anywhere, and any number of patrons are able to borrow them if it's available through their library card. Publishers are not directly selling the ebooks to libraries, and the price that the library pay for ebooks on average is 6 times what an individual pays for the same book. Even after paying 6 times more, they carry an expiration date, which is 2 years or 26 borrows. We're asking for fair pricing, the fair terms, so that libraries are able to provide equitable access to materials. Thank you for your time and consideration.
Thank you. Thank you for your time and your testimony today. Are there any questions or comments? Seeing none, thank you again for your testimony this afternoon.
Thank you.
Next, we will hear from Lindsay Farrell, followed by Pamela Armstrong, followed by Elizabeth Lane. Welcome, Lindsay. The floor is yours.
Thank you, Senator. Good afternoon. My name is Lindsay Farrell. I'm a senior political strategist with the Working Families Party. And I also was the state director of the Working Families Party here in Connecticut from 2012 until 2020, and previously worked with the party here in Connecticut since I moved to the state in 2007. So there are several dozen of us nerds around the country who deal with third-party election laws and rules and know them pretty well because we've been navigating politics through the lens of an independent political party year after year, and I am one of those nerds. I want to thank the co-chairs and the members of the committee for the opportunity to testify on the suite of ranked choice voting bills being heard today, 389, 5087, 5133, and 5701. So Working Families Party has several substantive concerns with the ranked choice voting proposals that we encourage the committee to consider before moving this issue forward. Ranked choice voting in its purest incarnation focuses on individual candidates, marginalizes party formations, and cancels out fusion cross-endorsement rules. WFP will oppose any RCV legislation which compromises our fusion election system in this state or makes third-party cross-endorsement votes indistinguishable from major party votes. So to explain why we're so committed to fusion, WFP believes strongly in the value of coalitions. Political parties, and the more the better, are good for democracy. It's how we structure and manage political competition and issues without violence based on the issues and the policy ideas that are associated with the parties. Coalitions are a good thing. They encourage the pursuit of common ground, and that's why we embrace fusion. Fusion also encourages partnership and coalition building between parties, often between the parties with more power and constituencies with less power. I think we can all agree that what American politics needs right now is more political partnership, not less. We also believe that in a real democracy, political parties should have the choice to endorse whichever candidate our members and leaders decide to. In this way, minor parties can build relationships with the elected officials who actually win to govern with the interests of the working families we represent, despite the limitations of our winner-take-all system. Do not take away our right to endorse the candidate of our preference and call it giving voters choices or expanding democracy. The thousands and thousands of WFP voters who just re-earned their right to cross endorsement on our line in the last election appreciate that their vote both helps to elect a viable candidate and to tell politicians what issues they care about the most. A lot of minor parties participate in our electoral system just to make a statement with their candidates. We understand that and don't wish to deny anybody that exercise, but WFP believes that political outcomes have a real impact on real people's lives, and we take that impact very seriously. Unless it protects disaggregated fusion, RCV would force parties like us into an impossible situation to either stay out of electoral politics entirely or run fringe candidates who have no chance of actually governing against the working families champions we find common ground with with the major parties, usually Democrats. Ranked choice voting represents a very complicated new set of rules that voters and election moderators will need to understand to use and calculate. The early execution of RCV in some other jurisdictions has seen a large share of ballot counting errors, which in the era of election denialism is much more than just a delay or an embarrassment or an inconvenience. In my written testimony, I provide some examples of that. Most Connecticut voters—
I'm sorry to interrupt. Can you please wrap up?
Oh, sorry, I apologize. Most voters would, I guess I would just like to say that WP would be unlikely to oppose ranked choice voting in party primaries or as a test adopted in municipalities that wish to conduct the experiment from which we can all learn. But in the meantime, we really urge the committee to proceed with caution.
Thank you.
Thank you so much.
Thank you. Thank you for your time and your testimony today. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony today.
Thank you.
Next, we will hear from Pamela Armstrong, followed by Elizabeth Lane, followed by Erna Alec. Pamela, welcome.
Hi, thank you. My name is Pamela Armstrong. I'm a Social Security Disability Claim Specialist at Aging and Disability Services for the state of Connecticut. I work with Gloshila, who you just heard from recently. I'm speaking today on behalf of CSEA P3B Union as a member representing both DDS and Bureau of Rehab Services employees. We work for the same agency and share a lot of the same clients. At DDS, we make Social Security determination disability determination decisions regarding work capacity. When people are found to be completely disabled, they're awarded disability income and medical coverage, and BRS counselors help people with disabilities find jobs. I support SB 1157. This is a bill that is very important to me and my coworkers because we are concerned for our safety. I'm asking for you not to reveal our home addresses under the Freedom of Information Act. I love my job and I'm proud to serve the citizens of Connecticut. I've been a state employee for 14 years now. At DDS, we work with people who have both physical and mental health impairments. We deny more claims than we allow. Well, many claimants have very severe disabilities. They often don't meet the strict guidelines for Social Security disability, and we have to deny many claims. When claimants are denied benefits, they often get very angry with us. I want to tell you about some of the claimants that we serve. I've removed all personal identifiable information, and my written testimony has a little more information. I'm trying to condense this for you. I've worked with claimants who have documented histories of murder, assault, and rape. I've worked with claimants who are sexual predators, pedophile, and exhibitionists. I've worked with claimants who are fire setters. I've worked with claimants suffering from paranoid delusions who believe the government is trying to kill them. I've worked with claimants who have sent me drawings of satanic winged creatures. My experiences are not unique in disability. We all work with the same claimants in one variety or another. For me, my family, and my coworkers, I do not want any of these people to be able to misuse the Freedom of Information process to find residential address information. While it's true that people can find some information on the internet, that should not be an excuse for the state to help to facilitate the release of that information. I believe that an open and transparent operation of state agencies is essential to our democracy. However, that does not mean that home addresses need to be accessible through the Freedom of Information process. For my safety and security, as well as the safety and security of my family and coworkers, I urge you to support Bill number 1157. I also encourage committee members to read written testimony from my coworkers, Stephanie Darden-Smith at DDS and LaTarsha Johnson at BRS. Thank you for your time.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments? Seeing none, thank you again very much for your time and your testimony. Next, we will hear from Elizabeth Lane, followed by Erna Alec, followed by Dominic Rapini.
Thank you, Senator Flexer. Good afternoon, honorable members of the Government Administration and Elections Committee. I'm thankful for your time and attention to these important matters that impact access to information of all kinds to every resident in our state, both young and old. My name is Elizabeth Lane and I live in Bloomfield. I have the privilege of serving the wonderful community of Bloomfield as the director of Bloomfield Public Library. I am also a mom of young readers. I am speaking today in support of HB 6829, commonly known as Connecticut's new ebook bill. I'm in the very important business of connecting people to information. It may sound easy, but I can assure you that it is not. Accessing information in an equitable way is a social justice issue. Libraries are struggling to break down the many barriers to access, but we do not have the staffing or monetary resources to battle the power of corporate entities who keep rewriting the rules. And more problematically, libraries pay a lot more for digital materials than the general consumer. We need your help to help us use tax dollars in the same way the average person uses their own money to buy an ebook. We need the government to step in. When ebook legislation went through this process in Maryland 2 years ago, I excitedly wrote Senator Slapp and Representative Gibson asking them to follow suit in Connecticut. In truth, we should have asked for this more than a decade ago. We are asking your help to level the playing field for all libraries, public, school, and academic, by creating a bill that allows us to better connect people to information without all of the added barriers and increased cost the publishing industry is putting up. I want to share 5 key points that the American Library Association once addressed about ebooks. 1, all published works must be available for libraries to purchase and lend to library users. 2, access to and use of ebooks must be equitably balance the rights and privileges of readers, authors, and publishers. 3, digital content must be accessible to all people, regardless of physical or reading disabilities. 4, library patrons must be able to access digital content on the device of their choosing. And 5, reading records must remain private in the digital age. You may also find an April 26, 2022 letter to Rhode Island Legislature from ALA urging the passage of ebooks legislation of interest. As that letter states, we need your help to enable public libraries to continue in the digital age to fulfill our mission of providing the public with access to information. I will include that letter in full in my written testimony. Stick up for libraries. Thank you, and please remember that just like you, libraries work to serve all. We must have ebooks for all. Thank you.
Thank you. Thank you very much for your time and your testimony this afternoon. Seeing no questions or comments from members of the committee, thank you again. Next, we will hear from Erna Alec, followed by Dominic Rapini, followed by Ariana Gonzalez. Welcome, Erna. The floor is yours.
Thank you, Senator Flexer. Dear members of the Government Administration and Elections Committee, my name is Edna Alich, and I'm a resident of Hartford. I am testifying in support of the Senate Bill 1158, an act designating various days, weeks, and months specifically in favor of item number 112 in the bill, the Bosnian Genocide Remembrance Day. This day would designate July 11th as an official commemorative day for recognizing those lives lost in Srebrenica genocide during the Bosnian War. I work at the American Place in the Hartford Public Library at Hartford Promise, and I'm also a city commissioner for the Commission on Refugee and Immigrant Affairs. But most importantly, I'm a Bosniak woman, and my identity, like so many others, revolves around the Bosnian genocide. My current work serving refugees in the community is in part due to my family being displaced and forced to seek refuge in other countries and cities like Hartford because of the genocide that has plagued our country. Many Bosnians that live in Connecticut are also currently serving our community in so many ways possible, from being educators to nurses and lawyers. We are continuing our lives, even though the genocide stays with us, with our families and our loved ones. Every July 11th, we remember the genocide. I mean, how can we forget when we still have family members missing or we are still recovering bodies? Just last year, my great aunt finally found her son, who was about my age when the genocide happened. After 27 years, they finally recovered his body and identified him. After 27 years, my aunt finally stopped looking out her window, wondering if her boy will come back to her. We buried him in Potocare, where the Srebrenica Memorial Center is located, where many other members of my family are buried, where over 8,000 bodies are to be buried. This summer will be 28 years. The trauma lives with us, continues, and it's intergenerational. Bosnia serves as a reminder that genocide and atrocities are not so far from us, that hate can bring out the worst of people, and that we must combat that on a daily basis so we can live in peace. 28 years later, we ask you to remember with us, to stand in solidarity with the Bosnian community here in Connecticut, as we collectively come together and recognize July 11th as not only a day of tragedy, but a day to never forget. This bill will serve as not only remembrance of the Bosnian genocide, but as a means to call everyone to remember and fight to stop other genocides, like the ones against the Rohingyas and the Uyghurs. This bill will remind each of us that Bosnia should never happen again to anyone, anywhere. I urgently urge you guys to support Senate Bill 1158 and help it pass in the legislative session. Thank you so much.
Thank you. Thank you for your time and your testimony this afternoon. Seeing no questions or comments, thank you again. Next, we will hear from Dominic Rapini, followed by Ariana Gonzalez, followed by Helen Humphreys. Welcome, Dominic. The floor is yours.
Thank you, Representative Senator Flexer, and the distinguished members of the GA committee, at least the ones that are still here. Thank you for your endurance. My name is Dominic Rapini. I'm a Connecticut business person working in the areas of consumer electronics. I am a certified election day moderator with experience in elections and special elections and recounts. And I'm also a former candidate for Secretary of State here in Connecticut. So I'm here, well, I have issues with many of the election bills today. I do want to spend my time talking about ranked choice voting and that where I'm in opposition to SB 389 and HB 5704. So ranked choice voting violates an American principle that has stood the test of time for nearly 2.5 centuries. One voter, one vote. Connecticut already has 6 political parties on the ballot. Candidates from each party must raise money, build support for their ideas, and earn every vote before Connecticut voters select by mandate a single winner In RCV, every candidate gets a vote, just like in Little League, everybody gets a trophy. Jerry Brown, the governor of California, vetoed the expansion of ranked choice voting in 2016 and said that RCV was overly complicated and confusing and deprives voters of genuine, informed choices. The state of Connecticut has enough issues that we need to solve for our elections without introducing the chaos and the confusion around ranked choice voting. So some points of illustration. In 2021, New York City had a primary for using ranked choice voting, 10 candidates, and it took them 3 weeks to actually come up with the winners of that election. As they went through every round of ranked choice voting, remember, they can only start the counting until all ballots are in, including absentee ballots. As they went through, at the end, 140,000 voters in New York City did not vote for a second, third, or fourth choice. They were eliminated and disenfranchised in a phenomenon called ranked ballot exhaustion. We see that those delays, any delays in voting, can cause confusion and really result in mistrust with the electorate. And I think that's something that is a major issue with ranked choice voting. We also see an increase in ballot spoilage, right? It's because of the confusion around this process that many voters not understanding the whole rules, they fill out their ballots. They're not complete, or they're either thrown out or they have to go back for new ones. MIT answered the question about, hey, ranked choice voting is supposed to have, less negative advertising. And what they did a study using Maine as an example, and they actually saw an increase in negative advertising in Maine during ranked choice voting. So it did not solve that problem. In fact, we always have to ask ourselves, what problem are we trying to solve? And I think that any system of elections that requires an instruction manual is far too complicated, and I think it will actually depress voter turnout, as we've seen in other instances. Thank you for your time.
Thank you. Thank you for your time and your testimony. Are there questions? Representative Labriola.
Thank you, Madam Chair. Thank you for coming here, Dominic. Thank you for all your advocacy around the state for several years now. We were talking before this hearing started, and you mentioned that though you've testified by Zoom before this committee in recent years, this is the first time you've testified in person in about 10 years.
That's right, since 2012.
So first, did you want to finish your statement?
Well, no, I think that my statement was complete. There's a lot of examples. I can talk about Alaska and examples, but it's all about confusion and complication, and really it causes a problem for voters who we already struggle. And last year, just in 2022, we only had a 52% turnout of voters in Connecticut, and that was based on all voters that are registered to vote. We got to do better, and we can't make it more confusing. Otherwise, we're going to go in the other direction.
Well, I do have one follow-up question. As you know, here in Connecticut, we're operating under a constitution from 1966, because in 1962, the legislature that was elected actually held over their offices, even though they all had 2-year terms, until 1960. Everybody was elected in 62, stayed in office until 66, because the U.S. Supreme Court issued its decision regarding one man, one vote, and that the Connecticut House of Representatives was unconstitutional.
Right.
Because prior to that, actually every city had 2 state representatives. Hartford had 2 state representatives, and Derby had 2 state representatives. And so the Supreme Court deemed that framework, as other states too that had that, was in violation of one man, one vote. It was deemed to be unconstitutional, so we had to adopt a new constitution. So I hadn't really thought about or heard the argument about the violation of one person, one vote as a reason to not adopt ranked choice voting. But I wonder if you could expand on, I guess the idea is that these voters or the candidates who drop out would effectively have 2 votes or more, and that's potentially unconstitutional.
Well, it's certainly we're going to have to amend our constitution here in Connecticut to even adopt this. We're talking about a long runway for this to happen. But, we've had one voter, one vote. It's been our practice in our country for over 240 years, right? That's the principle. Everybody understands that. Even if they didn't do well in civics, they kind of understand they get one vote, they get one chance to make it right. We want our voters to be engaged. We want to make sure that they learn as much as they can about every candidate, let alone 5 candidates. And so what happens is you don't have time in our busy lives. I often alert about the 3rd or 4th or 5th candidate. And what happens is you don't even fill them out. And if your first choice is not selected in the first rounds, then you may end up having no vote in the final tally. So I think it's important that we keep it simple, right? And we make sure that is our guiding principle, is to keep it simple and keep it something people understand. And then let's focus on having great candidates and inspirational campaigns to get people out to vote.
Thank you again, Dominic. Thank you.
Thank you, Representative. Seeing no further comments or questions, thank you again for your testimony.
Thank you, Senator Flexer. And if I may say something to our friends and our neighbors and friends from Bosnia, that while we may not be able to pronounce your last names, we'll never forget your stories. It was inspiring today. Thank you for that. Thank you, everybody.
Thank you. Next, we will hear from Ariana Gonzalez, followed by Helen Humphreys, followed by Austin Collins. Ariana, welcome. The floor is yours.
Hello, good afternoon, distinguished members of the Government Administration and Elections Committee, and thank you for having me today. My name is Ariana Gonzalez. I'm originally from New Haven and a current Derby resident. I will be graduating with my MSW from the UConn School of Social Work this May. I stand in support of House Bill 5702 and 5714 concerning incarcerated individuals and their right to vote. This is fundamental to any healthy democracy and critical to ensure our state government is truly for the people. There are currently 20 million people in our country who have a felony conviction. In Connecticut, the disenfranchisement of incarcerated people disproportionately impacts Black and Brown people, as these populations make up 60% of Connecticut's prisons population. This is both a human and civil rights violation in a form of systemic racism. By passing this bill, Connecticut would be a leader in our country, similar to our neighboring New England states like Maine and Vermont, who include this population in the democratic process. Washington, D.C. sends over 2,000 ballots to incarcerated citizens and are able to vote while in prison. Alabama and Mississippi are now also in the process of allowing some of their incarcerated citizens to vote. As a proud Boricua, even Puerto Rico allows people to vote from prison and has created an in-person voting options for its incarcerated citizens. Connecticut has a history of voter suppression and discrimination against non-white populations through its constitution and literacy tests. Connecticut must be a model for other states and make clear casting a ballot is a fundamental right of citizenship, not a privilege. Restoring the vote will allow space for positive reintegration into communities, increases public safety and civic engagement, and lowers recidivism rates. Additionally, I value this issue because more than half of the people in Connecticut prisons are parents. This keeps parents from advocating for policies that directly affect their children and shape their daily lives, such as school funding or policing in their community. Not only does this disadvantage families, but the racial bias and discrimination is detrimental for families of color and locks them out of the democratic process. We need equitable systems that work for the people and honor the dignity and worth of every human being. Keeping our incarcerated population informed and educated promotes that everyone is worthy enough to be a part of evidence-based decision-making processes. The isolation of being a non-voter reinforces disenfranchisement, which then continues in communities because voting is a highly social behavior. By restoring the right to vote for those in prison, we'll be promoting racial justice in our state. By denying the right to vote, individuals will not be seen as stakeholders in their communities. I support House Bills 5702 and 5714, and I urge the committee to support and pass this legislation. Thank you for your time.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments, thank you again for your testimony. Next, we will hear from Helen Humphreys, followed by Austin Collins, followed by Colleen Bailey. Helen, welcome. The floor is yours.
Thank you, Senator Flexer, and thank you, chairs, ranking members, and honorable members of the Government Administration and Elections Committee. My name is Helen Humphreys, and I'm the Communications Coordinator for Connecticut Citizen Action Group. CCAG is thousands of members strong, and it recently celebrated 51 years of fighting for social, economic, environmental, and racial justice. I'm here today to provide testimonies on 3 different topics. So I will do my best to go as fast as possible. First is HB 5704 and 5717 concerning universal civic duty voting. This bill was introduced to address and improve voter turnout in Connecticut. and Connecticut should strive for universal participation in our elections. And we believe that this is a good place to start this conversation. However, rather than implementing fines, we're supportive of incentive-based voting policies rather than punitive ones. Therefore, we're in support of a study on this issue to deeper understand how we can increase voter participation. Next, I'd like to testify in support of HB 5712, establishing a task force to study ranked choice voting. I've spent the last 5 years working in the democracy reform movement, and both here in Connecticut and around the country, I've worked with a number of different RCV campaigns. I believe that a study of this policy and whether it would be beneficial for our electoral system is the way to approach this issue. Connecticut residents deserve to understand this issue deeper and how it would affect the electoral process. Finally, I'd like to testify in strong support of HB 5702 and 5714 concerning incarcerated individuals and voting. CCAG strongly supports this bill as the right to vote is fundamental to any healthy democracy. Felony disenfranchisement disproportionately impacts historically marginalized Connecticut communities. The unequal and disproportionate rates of criminal punishment by race and income continues to systematically reduce political power in minority communities. And in a country where the prison industrial complex continues to run rampant and unchecked, we must work to support the rehabilitation and well-being of our incarcerated individuals. As we have heard today, civic participation has been linked to lower recidivism rates. And so Connecticut's elections by no means are perfect, but if we continue to address the roots of voter suppression and disenfranchisement, we can move our state towards a healthy, representative, and functional democracy. Thank you very much for your time.
Thank you. Thank you for your time and your testimony today. Seeing no questions or comments from the members of the committee, thank you again. Next, we will hear from Austin Collings, followed by Colleen Bailey, followed by Anthony Fartaria. Austin, welcome. The floor is yours.
Thank you. Dear Chairs Flexer and Blumenthal, Vice Chair Slapp and Morambello, Ranking Member Sampson and Mastro Francesco, and members of the Government Administration and Elections Committee. My name is Austin Collings, and I'm a college student and a resident of New Haven. I'm here today to communicate my strong support for HB 5087, an act concerning ranked choice voting for state and federal offices. This bill would enact ranked choice voting in Connecticut for all state and federal elected officials. Our current system of first past the post voting does not work for everyday Connecticut voters. Due to the nature of this system, voters are practically only given 2 choices out of fear of vote splitting. These types of elections leave out the largest proportion of voters in our state, as over 40% of voters in Connecticut are registered as independent voters. The great idea behind ranked choice voting is that it enables all voices, viewpoints, and even third parties an equal chance at winning. Voters are able to rank multiple choices and don't have to vote for an undesirable candidate out of fear of vote splitting. In every state and municipality where ranked choice voting was instituted, voters have consistently approved of its enactment and support its continuation. For example, Maine, a fellow New England state, instituted ranked choice voting in their elections in 2018, and 61% of voters in the general election expressed support for keeping and even expanding ranked choice voting after using it for the first time. Additionally, research has shown that ranked choice voting has promoted more civil election discourse. This is due to the nature of ranked choice voting, forcing candidates not only to campaign for first choice votes, but for second choice votes, the choice votes as well. Throughout these past years in American politics, we have seen relentless negative and toxic advertisements and discussions between candidates. Personally, enacting ranked choice voting would allow me a greater voice in Connecticut politics, as many Gen Z and other younger voters don't feel as attached to the 2 main parties. Many voters, including myself, have felt hopeless with the negativity and toxicity of American politics right now, and instituting ranked choice voting would help address this problem. In conclusion, I urge you to amend Title IX of the General Statutes to provide for ranked choice voting for federal and state offices in order to give Connecticut voters more freedom with their ballots to create a more positive campaign environments. Let Connecticut lead the way in becoming one of the first states to adopt ranked choice voting, setting an example that the nation can follow to make our elections more democratic. I urge you to vote yes on House Bill 5087 so that this bill can be brought to the floor of the CGA and allow Connecticut voters more freedom in their elections. Thank you for your time and consideration.
Thank you. Thank you very much for your time and your testimony today. Seeing no questions or comments, thank you again. And next we will hear from Colleen Bailey, followed by Anthony Fartaria, followed by Tanisha Senior. Colleen, welcome. The floor is yours.
Thank you. Thank you for the opportunity to speak in support of HB 6829, an act prohibiting electronic book and digital audiobook license agreements or contracts from including certain terms. My name is Colleen Bailey, and I'm the Executive Director of the West Haven Library. During the pandemic, libraries across the U.S. saw an increase in usage of our ebook collections that has never come back to previous levels. We've for years been paying 2.5 times the cost of consumers. It should not cost a library $75 for the latest bestseller in digital format when the physical copy with discounts costs maybe $20 to the public. Authors do not receive more compensation for their literary works from digital copies versus print. Libraries are not a threat to the publishing industry. If they truly thought we were, they would not turn out to library conferences giving away advanced copies of their books in hopes that librarians would help to sell them. Librarians help to create readers by matching the right book to the right person. My library belongs to the consortium Lion, who you heard from Rebecca earlier, consisting of 29 libraries in the state. We share resources, ebooks being one of them. We each pay in for the purchase of e-content that is shared among all of us. In addition to the shared content, my library will also purchase additional copies throughout the year to help meet the demands, which can still see holds of up to 6 months long. In December of last year, 78 of those additional ebooks we purchased expired and were automatically removed from the collection. Comparing those same books, 58 of the physical copies we still currently own and circulate. To replace all the available digital materials would cost my library an additional $2,300. For a library in a distressed municipality, that is just not attainable. In West Haven, much like other cities and towns throughout Connecticut, the library is a lifeline for many. The patrons expect that their tax dollars are being spent in their libraries and what they need, such as ebooks. Libraries are just asking for the pricing modules to be fair. Please support HB 8629. Thank you.
Thank you. Thank you for your time and your testimony today. Seeing no questions from members, thank you again. Next, Anthony Fartaria, followed by Tanisha Senior, followed by Tinu Thomas. Anthony, welcome. The floor is yours. Looks like Anthony might not be here. Is that accurate? Okay. Tanisha Senior, and please correct me if I've said your name wrong. Welcome. The floor is yours.
Hi, thank you. It's Tanisha Signor. Good afternoon, members of the committee, and thank you for hearing my testimony today. My name is Tanisha Signor. I am a Master's of Social Work student at Southern Connecticut State University, set to graduate this May. My concentration is Community Organization Policy and Leadership, and I'm an intern with the Social Welfare Action Alliance. I'm also working with the Full Citizens Coalition for my placement and my capstone work. I am testifying today in support of HB 5702, an act allowing incarcerated individuals the right to vote. I stand in support of this bill because I believe the right to vote is an inherent right to every resident in a healthy and just democracy. As an MSW student, I am required to do a capstone project. The focus of my capstone is felony disenfranchisement. As a country, we have been disenfranchising certain populations of people from voting since the beginning of our nation. Connecticut is no exception. By doing this, we are damaging the possibility of an individual's rehabilitation and reintegration into society, and disallowing our progress as a society that we can make by learning with and from the incarcerated individual's lived experiences. As a social worker, there are many reasons why the right to vote is a crucial part of individual life in a democratic society. Citizenship theory suggests that mental health of marginalized people can be deeply damaged if they are restricted from participating actively in and with their community. From a mental health perspective, fully experiencing citizenship is imperative, especially for marginalized populations. It is impossible to talk about voter disenfranchisement without taking race into account. The prison system was designed to impact people of color more greatly, and it is working the way it was intended. In Connecticut, Black residents account for only 13% of our population, but for 42% of our state prison population. The incarceration of Black adults is over 9 times more than of white adults. In Connecticut, We also have the third highest incarceration rate of Latinx people in the entire country. It is impossible for us to have a truly representational, just, and equitable state if large scores of specific groups of people are being prevented from voting. Allowing people to vote while incarcerated gives Connecticut the opportunity to support individuals' rehabilitation by asking them to take part in a civic engagement, and it is shown to have beneficial effects on recidivism. As a result, reenfranchisement for incarcerated individuals is also valuable from a public safety perspective. In 2021, Connecticut reinstated the right to vote for people who are on parole, giving thousands of people the right to vote. I believe this was the right step, but it did not go far enough. This bill is an opportunity for Connecticut to be on the forefront in the fight against voter disenfranchisement in our country and to begin fortifying a new meaning of true governmental representation for our residents. I urge the committee to pass HB 5702 in its current form and designate the right to vote for these people. Thank you for your time.
Thank you. Thank you for your time and your testimony. Seeing no questions, thank you again. Next, we will hear from Tinu Thomas, followed by Javier Serra, followed by Laura Del Salvio. I'm not sure that Tinu is here. I don't see Tinu, so I'm going to move on to Javier Serra. Welcome, Javier. The floor is yours. Javier, you are still muted.
Thank you. Sorry about that. Good afternoon, Co-Chair Flexer, Co-Chair Blumenthal, and esteemed members of the GAE committee. Thank you for providing this opportunity to speak today. My name is Javier Serra, and I'm a former class president at Grant High School and current first year at Harvard College. I'm a member of the Harvard Undergraduates for Bipartisan Solutions, an ideologically diverse group that proudly supports SB 389. I'm also a member of the Board of Advisors of Connecticut Voters First. Today, we have arranged for testimony by a number of witnesses in support of SB 389. For your convenience, I will give a brief overview of our testimony. A more comprehensive outline has been submitted as my written testimony, where you will also find a public letter signed by 116 Connecticut voters in support of ranked choice voting. The testimony we have arranged is as follows. Testimony of Monty Frank, a former candidate for lieutenant governor in 2018, alongside the late Oz Griebel. Mr. Frank will describe how SB 389 allows RCV to be enacted in a measured and achievable manner. The benefits of ranked choice voting by Laura Del Savio, the Director of Communications of Connecticut Voters First. Draft legislative language, where Scott Muller, founder and chairman of Connecticut Voters First, will describe how SB 389's three elements are tightly focused and appropriate for introducing RCV on a pilot basis. How ranked choice voting works. Earlier, you heard from Yale student Michael Garman on how ranked choice voting serves underrepresented populations, and soon you'll hear from Holden Culotta, a Southern Connecticut State University student, on how Gen Z voters, above all, want their vote to matter. How ranked choice voting has improved representation of minorities in elections around the country. This testimony was submitted and written by Terrence Carroll, the 54th Speaker of the Colorado House of Representatives. Why ranked choice voting changes the incentives in elections and improves political culture, by Henry Rowland, a former infantry officer and current leader of the Connecticut chapter of Veterans for Political Innovation. How ranked choice voting can strengthen the voice of underrepresented communities in Connecticut, by Bishop John Selders. Ranked choice voting is a bipartisan reform, by Jonathan Bydlak, the Director of Governance Program at R Street. Mr. Bydlak will describe the impact of ranked choice voting on the political marketplace. The special benefits of ranked choice voting and presidential preference primaries, by Mary Frances Metrick, a business executive and member of the board of directors of the Ford Party. The advantages of providing an option for municipalities to use ranked choice voting in single winner municipal elections, where you heard from stakeholders, First Selectman Danielle Cheeseborough of Stonington and First Selectman Dan Rosenthal of Newtown, on the merits of ranked choice voting as a municipal option provided by SB 389. Addressing common questions and concerns, by Mike Ergo, the managing director of Connecticut League of Conservation Voters and former First Selectman Stonington, Connecticut. Elections administration challenges in adopting ranked choice voting in Connecticut, by Drake Ramkey, former election official from Colorado with over 10 years of experience in administering elections. Thank you for all of your time and attention in listening to each one of these important testimonies. We hope you support SB 389.
Thank you. Thank you for your time and your testimony this afternoon. Seeing no questions or comments. Thank you again. Next, we'll hear from Laura Del Savio, followed by Ivelisse Correa, followed by Kira Parrott. Welcome, Laura. The floor is yours.
He's incredible, isn't he? So I am the Director of Communications for Connecticut Voters First. Over 13 million Americans are using ranked choice voting right now. 8 of 10 recent ballot measures passed in 2022. So I'd like to share some of the reasons why those ballot measures have been successful. RCV empowers voters to choose the candidates they like best. It eliminates a spoiler effect. It encourages electoral competition and choice. It encourages positive campaigning. Political discourse is improved with RCV, and it results in the election of consensus candidates over those with extreme ideologies. RCV improves voter engagement and satisfaction, and it builds consensus. The research around RCV is clear, and it's been implemented in so many different places that the data that we are presenting today throughout the testimony of all those people mentioned by Javier is based on concrete experience. We've heard some criticisms that RCV is confusing. The data doesn't support that. In fact, 85% of Alaska voters said it was simple, and this number is similar in New York City and in many other places across the country. Data around ballot error is that RCV rates of error are lower to or equal to those of our current system. RCV is one voter, one vote. Contrary to the opposition talking point, every voter's ballot counts just once. Voters are free to choose not to use all the rankings allowed, but they are also now free under RCV to vote for a candidate that they prefer, who may be less likely to win. And that's one reason why the case of Alaska is further evidence that RCV works. In fact, in Alaska, which has been used to attack RCV in some cases, Sarah Palin had a 61% negative rating compared to Peltola's 53% positive rating. In the end, the candidate who was most liked won. Peltola was said to be categorically the most popular figure in Alaska by an Anchorage paper. It should not be surprising that she won. RCV rewards positive campaigning, and that's exactly how Mary Peltola approached her campaign. RCV is a powerful change, a powerful reform for American politics, for Americans voters, and for candidates. It represents opportunity and freedom for many people to get involved in our politics in a different way. We talk a lot about the voter experience, but not enough about the candidate experience. And as you heard from First Selectman Danielle Chesborough earlier today, it really does impact the ability of a candidate to be a viable opponent in a race in an election. I would be happy to answer your questions.
Thank you. Thank you very much for your time and your testimony this afternoon. Are there questions or comments from members of the committee? Seeing none, thank you very much for your testimony today.
Thank you. I would urge you to look over the complete portfolio submitted by Connecticut Voters First. We answer a lot of questions for you there.
Thank you. Next is Ivelisse Correa, followed by Kira Parrott, followed by Mike Tamburino. Is Ivelisse here? I don't see them. Ivelisse? No. Okay, so we will move on to Kira Parrott, who is here. Kira, welcome. The floor is yours.
Hi, good afternoon. Hello, my name is Kira Parrott, and I am the library director at the Darien Library in Darien, Connecticut, and I'm a resident of Norwalk. I'm here to testify today in support of HB 6829. The current terms dictated by publishers and ebook vendors harm every type of library in the state of Connecticut, and in turn do harm to residents and taxpayers from every municipality. Here at Darien Library, like almost all public libraries, ebooks are enormously popular, and they're growing in their popularity and usage every single year. We've seen a huge tick up since the beginning of COVID, when many patrons discovered for the first time that they could download great ebooks and e-audiobooks for free from their local public library, which is a great and wonderful thing. But what is not great are the patently unfair terms of use and the unreasonable costs that public libraries must members pay in order to obtain and to keep these digital materials in our circulating collections for our communities. So if you were today to go and download an ebook version of some hot new title, let's say from Amazon, you're going to download it to your Kindle, you're going to pay anywhere between $9 to about $12 for that ebook. But here in the public library, for that same exact ebook, we're going to pay between $60 to $80. And get this, even after we pay that inflated cost, the book is actually not owned by us. It's actually on loan because they're going to disappear from our collection after 2 years or 26 uses, whichever comes first. So for very popular titles that have a long shelf life, we have to purchase them again and again, and sometimes again, at that already inflated price point. This pricing model makes it virtually impossible, pardon the pun, to build a rich and accessible collection for our residents. It also makes it impossible to give our patrons access to the materials that they want and need while remaining fiscally responsible with the very precious resources and dollars that we have. The books either disappear after that time limit or checkout limit, or there are incredibly long waits, these hold lines for the titles that we have. And your average reader, your average patron just does not understand. They say to us, well, why don't you just buy some more copies of this ebook? And we have to explain that while we wish we could at $60 to $80 a pop, it's just not fiscally responsible. If publishers and ebook vendors offered lower, reasonable prices and fair terms of use, public librarians would buy more copies and hopefully authors would make more money in royalties. HB 6829 is not just good for Connecticut's public libraries, it is also good for taxpayers and great for readers at every age and every stage. I urge you to support it. Thank you for your time.
Thank you. Thank you for your time and your testimony. Representative Blumenthal.
Hey there, it's Matt Blumenthal. Just wanted to say thank you for being with us today and for your service to the Darien Library.
Thank you.
Thank you, Representative. Thank you again for your time and your testimony this afternoon. Next, we will hear from Mike Tamburino, followed by Scott Muller, followed by Ann Manusky. Mike, welcome. The floor is yours.
Yeah, thank you, Madam Chair and members of the committee. I wanted to comment on House Bill 5701. I am passionately opposed to ranked choice voting. I find it very confusing. I think, and I want to echo just a few of the points that Dominic brought up, but one that hasn't been mentioned is that typically people are well-informed. Typically, they are blessed with a reasonable level of intelligence, but not everybody is. We have a lot of much older senior citizens. I think they would find ranked choice voting incredibly confusing. It is complicated. I think that maybe you have a situation where voters just will opt out. They won't rank anybody. They'll just choose their top candidate. I think that it's been proven that it's more difficult to audit. So therefore, it's not transparent. And I think in a time when people are becoming much less trustworthy of our elections, I think right now we're up to about 60% of people do not trust the results of elections. I think that this only adds to that distrust and will only make that percentage go higher. I think there are other options. If we want a majority candidate to win in all cases, I think a runoff is a simple, better choice. I realize it's a more complicated process. It adds more expense and you need another election, but I think overall it's just a better choice. And I just want to make another comment. Since the ERIC system was brought up very early in the hearing, Senator Mastro Francesca had commented some concerns about it. Some news broke today that 3 states today announced they're opting out of the ERIC system, and 2 have opted out already. So whereas a high of 32 states were using the ERIC system, it's now down to 27. And the fact that 3 opted out today should be a real concern for Connecticut and its use of the ERIC system going forward. So I hope the committee will look into the ERIC system in the states that have decided to not use it and why they have. There is another choice out there. It's called Omega for America, and they claim to have a much better system. Thank you.
Thank you. Thank you for your time and your testimony. Seeing no comments or questions, thank you again for your testimony. Next, we will hear from Scott Muller, who will be followed by Ann Minuski, who will be followed by Holden Kulata. Scott, welcome. The floor is yours.
Sir, if you could just turn on your microphone, make sure you're entered into the
Sounds
record.
like a good plan. I'm the chairman and founder of Connecticut Voters First. I spent my career in practice of law, a fair amount of that in federal government service. Since Election Day 2016, to use the phrase the day after Election Day, I should say, phrase of one of the prior witnesses, I've sort of made myself a nerd about election law, including in Connecticut. My testimony has attached to it a draft of legislation that would implement 389. And I have several things which I would like to ask. First, that you actually take a look at that testimony and the draft legislation and keep in mind two suggestions and a request. First, the suggestion is to view the draft legislation as having three distinct and segregable parts, each of which could serve as an appropriate pilot for ranked choice voting. Those elements are the use of ranked choice voting in the presidential preference primary, a single election once every 4 years. The use of ranked choice voting at the option of a municipality, but only in single winner elections. And finally, as is has been proposed by Congressman Jim Himes, use of ranked choice voting in federal elections, that is for US Congress. We chose those three for several distinct reasons. First, they avoid all potential constitutional issues under the Connecticut Constitution. Second, they avoid to the maximum extent we could any other potential complicating issues under Connecticut law, such as the laws protecting minority rights in multi-body elections and the like. Second, I specifically ask that you look at the effective date provisions of that draft legislation. There are two issues that arise with respect to implementation. One is the implementation issue that the current machines, that is the tabulators, are not capable of ranked choice voting tabulations. You've heard the Secretary of the State talk about the fact that they are in the process of working on new tabulators. And our legislation specifically builds into it an escape hatch for the Secretary of the State with respect to any of the elections I've described in the event that she concludes that it's not possible given the infrastructure. Second, you've heard discussion about fusion voting and the possible inconsistency between fusion voting on the one hand and ranked choice voting legislation on the other. We've talked to a number of experts. We believe that is not a square hole and a round peg, or vice versa, I guess I should say. It can be done, and there are ways to do it. Our legislation specifically, first of all, you should, as you heard, the fusion voting issue does not apply to primaries, so it's not an issue there at all. We support fusion voting, and we built into the legislation an escape hatch for the Secretary of the State in the event that she concludes that she cannot find a way to square with an appropriate ballot design, fusion voting and rules. Last thing I would ask you to do is to consider, as the last paragraph of my written testimony, to adopt the draft legislation as your own or to send it to LCO to become a form of 389, and further that you adopt House Bill 5701, conform it to 389, so the final bill has both numbers on it. Thank you very much, and I'm open for any questions you may have.
Thank you very much, Mr. Muller. Appreciate your testimony. Do we have any questions from the committee? Seeing none, we thank you for your testimony and for being with us today.
Thank you. There have been several other issues which have been raised. There's actual evidence that we can put in, and we'll supplement our testimony if that's permitted.
We appreciate that. Next up is Ann Minuski, followed by Holden Kulata, followed by Sharon Scarlett. I do not see Ms. Minuski. That brings us to Holden Kulata, who I see on our Zoom. Mr. Kulata, whenever you're ready, you may proceed.
Thank you to the distinguished members of the Government Administration and Elections Committee. I am grateful to have the chance to speak with you all tonight about ranked choice voting, specifically SB 389, an act concerning ranked choice voting. My name is Holden Kulata. I'm a resident of Guilford, a political science major at Southern Connecticut State University, as well as a member of Connecticut Voters First Board of Advisors. I host weekly live forums on social media, which have been attended by some of the top election reform organizations in the country. And I've published a number of articles and letters on political polarization and ranked choice voting here in Connecticut. The case for ranked choice voting, or RCV, is particularly strong among Gen Z voters who are more politically independent and centrist than any previous generation. At the same time, Gen Z voters participated in the 2022 midterm elections at historically high rates. We are a generation that candidates cannot afford to ignore. A recent Gallup poll found that younger generations are somewhat less partisan than their parents and significantly less partisan than their grandparents. Furthermore, 22% of elections to the Connecticut General Assembly in 2022 went uncontested. Gen Z voters are passionate about all kinds of issues, but above all, they want their vote to matter. Any of the elements of SB 389 will reinvigorate our democracy and encourage Gen Z voters and candidates to get involved. And there are a number of reasons why ranked choice voting is vital for Gen Z voters and the long-term health of our state's democracy. First, it reduces political anger and negativity. Growing up in an era of partisan politics, Gen Z voters are motivated to vote more out of fear than hope or inspiration, which is a situation that has ominous implications for our future. RCV requires candidates to appeal to a broad range of voters, encouraging coalition building and problem solving over partisanship. Second, ranked choice voting empowers voters. Uncontested and non-competitive elections leave Gen Z voters with an impression that their vote has little impact on the policies that will be voted on by the winner. RCV will restore real competition to our elections, which will in turn boost confidence among Gen Z voters that our vote has a meaningful impact. And electoral competition also provides members of traditionally underserved communities realistic paths to winning elected offices, leading to a system that does a better job of reflecting the most diverse generation in US history. Third, ranked choice voting encourages civic participation. Increased competition gives young voters real choices and increased confidence in the power that each vote leads more young voters to engage with their democracy. Voter turnout has increased among Gen Z voters in areas that implemented ranked choice voting. And lastly, ranked choice voting expands political choice and opportunity. It expands electoral choice by eliminating the vote splitting effect or the spoiler effect, thus opening a lane for independent candidates from underserved communities to win elected offices. A greater number of viable candidates would further reduce partisanship by bringing the voices of the 41% of Connecticut voters who are not Democrats or Republicans to the table. Because in addition to being the most diverse generation, Gen Z is also the most politically independent.
I'm sorry to interrupt, but your time for testimony has elapsed. If you could just summarize the remainder of your testimony briefly.
That's all I had. Thank you. I appreciate it.
Thank you very much, Mr. Collada, for your testimony and for being with us here today, as well as your advocacy. Do we have any questions from the committee? Seeing none, again, we thank you and appreciate your testimony.
Thank you, Representative.
Next up is Sharon Scarlett, followed by Scott Dolch, followed by Leila Korkutuvich. Ms. Scarlett, you may proceed whenever you're ready.
Thank you, Chairmen Flexer and Blumenthal, ranking members and distinguished members. I'm retired. My profession was analytics. My name is Sharon Scarlett. I'm from Southbury. I'm here in opposition to Bill 5714. Voting is a privilege, not an absolute right to citizenship. And that part of losing freedom while incarcerated is losing the right to vote. Convicted and incarcerated felons should not vote because they have not paid their debt to society. I'd offer the opinion that once a prisoner or felon has served his or her full term, then according to the justice system, they have paid their penalty and should be able to apply for voting privileges, which I know Connecticut has already. But in my opinion, only after having a no arrest record for 3 years following release from prison. Here is one interesting point. Only very few states allow incarcerated to vote. The IPA Vermont.org site reports that only Vermont and Maine allow prisoners to vote. Note, this is a 2019 report, so the numbers may have been changed. And only 15 states allow released prisoners to vote. Note the National Police Union logically opposes this wild idea. The argument that the general laws reference prisoners voting as a form of racism is patently illogical. If a person is found guilty in a U.S. court, then the voting privilege is rescinded for every person who is in prison, no matter what skin type they have. The law does not say that you cannot vote if you are Black, Asian, Irish, Portuguese, etc. It happens that a large percentage are Black, and the law states that voting privilege is rescinded. That is an unfortunate outcome of the fact that large populations in prisons are Black. The law does not say if you are imprisoned and you are Black, then you cannot vote. Thus, racism is fake. The National Police Association said this: those who oppose giving prisoners voting rights, like the National Police Organization, Bill Johnson, argued barring criminals from civic participation is an important part of exacting justice. By showing profound disrespect for the law, you lose your privilege to have a say. Okay, I have one sentence left.
Go for it.
Okay. In deciding what the law is, said Johnson. He added that convicted felons should prove that they have been reformed to earn that right back rather than having it automatically restored upon being released from prison. Thank you.
Thank you very much for your testimony. I think you have a question from Representative Labriola.
Thank you, Mr. Chairman. Thank you, Sharon, for coming here and testifying. I have the privilege of representing the town of Southbury here in the General Assembly, and so I know that you wear several hats on behalf of the people of Southbury. So thank you again. I guess I have just one question with regard to this bill that you testified about. How do you think that passage of this bill would affect the victims of the crimes that perpetrators have committed?
That's a very good question. I feel it's like a disrespect. Okay. When you commit a crime and you're incarcerated, okay, that's telling you, okay, you need to do the time and do what you've been convicted for. Okay. But the person that's the victim is still hurting from that, okay, and will be hurting from that for the rest of their lives, okay? And that's what happens to victims. So therefore, I say, at the very least, this should stay intact and be opposed, okay? So at least it'll have something, okay? Victims, it lasts forever.
Thank you, Sharon.
You're welcome.
Thank you, Mr. Chairman.
Thank you, Representative Labriola. And seeing no further questions from the committee, thank you for your testimony and for being with us here today. Next up is Scott Dolch, followed by Leila Korkutuvich, followed by Rosanna Ferraro.
Good afternoon, everybody. Changing kind of the topics a little bit. Good afternoon, members of the Government Administration Elections Committee. My name is Scott Dolch, and I am the president of the Connecticut Restaurant Association. On behalf of Connecticut's 8,600 restaurant and food service location, the Connecticut Restaurant Association appreciates the opportunity to testify in support of Senate Bill 390, an act designating pizza as the state food. Connecticut is known for many incredible things: Mark Twain, Prudence Crandall, the Charter Oak, Mystic Seaport, UConn basketball, the invention of the Frisbee, ESPN, and so much more. And of course, one of the most iconic things in Connecticut began on June 16, 1925, when an Italian immigrant named Frank Pepe opened a small restaurant on Worcester Street in New Haven. Frank Pepe's Pizzeria sparked a new love in our state, the love of pizza, and it has persisted ever since. For nearly 100 years, pizza has become a draw for the city of New Haven, as Pepe's, Sally's, Modern, Bar, and so many more have helped crown New Haven as the pizza capital of the world. Of course, anyone who thinks that Connecticut's iconic and historic pizza scene stops at New Haven's borders would be sorely mistaken. Connecticut now has over 800 family-owned pizza locations enjoyed by residents and visitors alike. The movie Mystic Pizza helped launch the careers of stars Julia Roberts and Matt Damon, and downtown Mystic has become a tourist attraction as well for more than 35 years. Other famous landmark pizza restaurants can be found at every corner of our state, whether it's Colony Grill in Stamford, Saparti's in West Haven, Rosalina Pizza in Derby, E&D Pizza in Avon, Pleasant Pizza in Willimantic, Naples in Farmington, Mulberry Street in Manchester, Mondo in Middletown, and so many more. We all have our favorite pizza spot, and collectively, Connecticut's pizza restaurants deserve to be recognized for their role in our state's history and culture. The Connecticut Restaurant Association believes there is no better way to celebrate that unique and special role than by making pizza Connecticut's official state food. No state does it better than Connecticut, and we wholeheartedly support this proposal. Thank you for the time and considering my testimony, and I'm happy to answer any questions.
Thank you, Mr. Dolch. It's a pleasure to see you. We appreciate you standing up, being counted in favor of the Connecticut pizza scene. Seeing no questions from the committee, we thank you for your testimony and for being with us here today. Next up is Leila Korkutuvich, followed by Rosanna Ferraro, followed by Sandy Lamonaco.
Hi, everyone. It's on. So dear Senator Flexer, she stepped out, but and Representative Blumenthal, the members of Government Council, Administration, Committee, thank you for having us. My name is Leila Korkutuvich, and I'm a resident of Hartford. I am testifying in support of SB 1158, an act designating various days, weeks, and months, specifically in favor of item number 112 in the bill of Bosnian Genocide Remembrance Day. Thank you for having us here. Just like most of my members previously, I share the same life story. I am one of the survivors of Bosnian genocide. A while back, when I was much younger, I've heard someone say, everything starts with childhood and everything ends with childhood. And it certainly is the case in my life and in many lives of other kids that were born during that time and lived through the genocide of our homeland. A little over 30 years ago, I was 6 years old. I was also 6 years old when I had last had chance to feel comfort and love of my father. Life without him has not been the same. I have learned to live with this pain. It has not been the same. One thing that I have not learned is why would someone ever take his life away? And why would someone ever take 8,000 and plus lives away? Every experience ever since, every tear and every smile has been different. Graduating from college, getting married, having 2 children, these are all experiences that I have not had my most important loved one next to me to experience with me. They all come with sadness. My childhood memories are all related to war and traumatic events that such experience can bring. I have also accepted my childhood reality and would never wish such experience for any other kid or any other human being. The reason why I share this is not for others to feel sorry about my past experience or feel bad about us as a community. Our past has strengthened us in so many ways. I share my experience to bring awareness and to be voice for all of the victims that are not here with us today and will not be with us ever. It is essential to learn from our past. I live with my past every day. Our grief is not limited to one day. Can I finish? Or yeah. So our grief is not limited to one day, but one day to remember and honor our victims would be enormous value to our community. it is essential to speak about our history if we don't want something, same thing to repeat itself. It is our responsibility to educate our children as well, that such cruelty is not acceptable and should never happen to anyone again. For many people, this just might be one day, but for us survivors, this is our whole life. I ask you to please support us with this bill so that Srebrenica and Bosnia and Herzegovina never happens again. Thank you.
Thank you for your testimony and for being with us today. Are there any questions from the committee? Seeing none, thank you again for being with us and for sharing your story. Next up, Rosanna Ferraro, followed by Sandy Lamonaco, followed by Michael Donnelly.
Hello, chairs and members of the GAE committee. Thank you for the opportunity to testify today. I am here in support of House Bills 5702 and 5714. I am Elizabeth Ferraro.
Sorry, Ms. Ferraro, there seems to be an echo. I'm not sure if that's on our end or yours. Do you want to try muting yourself and then unmuting yourself again? And then you can continue your testimony.
I'll give this a shot. Is that better?
No, not really, unfortunately.
Actually, if you want to let the next person go, I'll log off and come back in.
Okay, that sounds good. We'll come back to you in a minute.
Sure thing.
Next up is Sandy Lamonaco. Not see Sandy Lamonaco. Next is Michael Donnelly. Mr. Donnelly, whenever you're ready, you can proceed.
Thank you. Good afternoon, chairs and the committee. Appreciate your time and your attentiveness and frankly, your stamina in listening to all this testimony today. I'm here in opposition to Bill 6826. I have submitted testimony and I am here today on behalf of the construction law section of the Connecticut Bar Association. I think it's important to note that we are not a lobbying group. We are a group of attorneys who practice primarily construction law here in Connecticut. And we are in opposition of the False Claims Act for largely the reasons that Mr. Schubert testified to several hours ago. And I guess along with Mr. Schubert, I and the other members of my section will also have to agree to disagree with you, Representative Blumenthal, with respect to the bar set by the False Claims Act. It's our view that there is a real likelihood of litigation that is unnecessary because the term false isn't defined, and because the term knowing only applies to knowing the information and not to what false means. And under the circumstances in construction, there is just too much uncertainty. And frankly, the litigation history of the False Claims Act in other states and under federal law shows that it is rife for abuse. We also believe that there are existing solutions with respect to the problems that were raised by Attorney General Tong and Mr. Hawthorne. Mr. Hawthorne, for example, raises the prevailing wage issue, which he acknowledged is a Department of Labor issue and would be better addressed by simply having more people conducting enforcement on behalf of the Department of Labor. Mr. Schubert mentioned that the False Claim Act, if it's adopted in the form that it has been proposed, would change the risk profile for contractors. whenever you change the risk profile, you also change the pricing, and the result of that will likely be an increase in the cost of public jobs in Connecticut. And that's an increase that will be felt by all of us as taxpayers. So it's for all of these reasons that I and the construction law section oppose Bill 6826. Thank you for your time.
Thank you, Attorney Donnelly. Are there questions from the committee? All right, I had a question. You mentioned that you see at least significant part of the problem with this statute or this bill is drafted as stemming from the fact that it does not define false. If we did define false in the bill, would that ameliorate any of your objection?
Depending on what the definition is, it would certainly help.
Okay, thank you, sir. Seeing no further questions from the committee, we appreciate your testimony.
Thank you.
I see Ms. Ferraro has returned. Let's see if you can go forward.
Let's test this out. Is that working okay?
Much better.
Oh, great. So as I was saying before, chairs and members of the GAE committee, thank you for the opportunity to testify in support of HB 5702 and HB 5714. I'm Rosanna Garcia Ferraro. I'm the program lead for health justice policy advocacy at Universal Healthcare Foundation of Connecticut. We are committed to accelerating the movement for health justice because health is a human right and core to social justice and equity. We support these bills because the right to vote is fundamental to any healthy democracy, as well as to ensuring healthy communities and ultimately to health justice. For us, universal means everybody, including those in our carceral system. Health justice cannot be achieved unless we address the inequities and disparities faced by those most impacted by injustice, oppression, and racism. Disenfranchising those in our carceral system is an injustice that perpetuates the systemic racism embedded in that system and in our society more broadly. Communities that vote have more access to healthcare and better health outcomes than communities with low voter turnout. For us at Universal, this is just one of many compelling reasons to ensure that everyone has the right and opportunity to vote, including those community members currently incarcerated. All communities need resources to achieve health justice. Voting is one way that communities ensure that they have access to these critical resources. And I'm not simply talking about access to healthcare, but also quality public education, jobs with fair wages, safe and affordable housing, and any number of other needs. There's been a lot of compelling testimony today about how voting also reduces recidivism and helps those that have been incarcerated transition back to their communities. In fact, it keeps them involved in their communities despite their incarceration. I hope that for the health of our democracy, our communities, and all Connecticut residents, this committee advances HB 5702 and or HB 5714. I appreciate your time this afternoon. I know it's been a long day, and I would just like to echo the others that support these bills as well. Thank you.
Thank you for your time and your testimony. Seeing no questions from the committee, we say thank you and for being here with us today. So next up is Calvin Page, followed by Faith Ham. Do we have Calvin? Do not see him. Is Faith Ham present? Not see Faith. Audits Muminovic. Oh, there you are, Mr. Muminovic. Whenever you're ready, you can proceed.
Good evening, Senator Flexer, Representative Blumenthal, and members of the Government Administration and Election Committee. Assalamu alaikum. My name is Audits Muminovic, and I am currently a resident of Rocky Hill, Connecticut. and I'm here to testify in support of SB 1158, specifically number 1112 in the bill that outlines and helps commemorate the Bosnian Genocide Remembrance Day. So I started my introduction with the greeting Assalamu alaikum, which is an Arabic greeting that is used by Muslims around the world and by my family and my fellow Bosnian community members as well. It is a greeting that means peace be upon you, that we wish to share with everybody. But something that my family and my community members have not always felt. So as you guys heard throughout the day, during the war in Bosnia, which started in 1992, how can we expect a mother to feel peace when there are missiles and rockets flying overhead and landing, exploding near her newborn son, sending shrapnel, glass, and other dangerous debris to land on top of him while he sleeps in his crib? How can a grandmother have peace as she is terrified, running through the woods, holding her grandchild, trying to avoid enemy and avoid gunfire, trip, fall, and roll into a cold creek full of blood and other bodies just so she can save that baby boy? How can that baby boy learn what peace is and feel peace when he is in jeopardy of growing up without a father because his father was shot and had to be separated from his family? So sadly, all those short examples of that newborn son, that grandson, that baby boy, those are all things and stories that happened to me and my family. So while I may be one of the lucky ones where, I was reunited with my father and my family made it through, but peace is something that they still lack. So peace is something that they do not have inside their hearts and inside their minds, as they're always terrified of that happening again. And that is so true for many Bosnian families that live here in the United States and in the state of Connecticut. There's nothing that we can do that will ever ease the pain and make things better. The genocide that happened in Bosnia is engraved in the hearts of every member of my community. It is a big part of the suffering that we all still hold deep down in our hearts. And this is why I urge you guys to help support SB 1158, Bosnian Genocide Remembrance Day, not to help us find a solution to help us get past it, but to stand with us in commemoration with all the family members that live in the state of Connecticut.
Wa alaikum salam, and thank you for your testimony. Are there any questions or comments from the committee? Seeing none, thank you for being with us today, sharing your testimony and sharing the story of you and your family. Next up is Andrew King, followed by Alex Brandorf, followed by Monty Frank. Do we have Andrew King present?
Hello.
There you are. If you could go on video, if that's possible, and begin your testimony whenever you're
There
ready.
you go. Good evening to the chair of the committee and members of the committee. My name is Andrew King. I'm from Milford, Connecticut. I'm here to testify about ranked choice voting and universal voting. First, on ranked choice voting, I believe it's complicated, results in lower turnouts, erodes trust in elections, and silences voters. Faith in our voting system is at an all-time low right now. Adding a complex system of ranked voting will result in less faith in our elections due to the long drawn-out process and significant voters' remorse. I have several issues with RCV. It allows for one party to game the system, to put their party's candidate in office. One candidate acts as a jammer to bleed votes and allow their fellow party member candidate to win, even if he doesn't have a majority. This is not the idea of our founding fathers. This is not one person, one vote. Also, ballot exhaustion creates an artificial majority. By eliminating the lowest scoring candidates for successive tabulations, it results in votes being silenced. RCV will result in extended periods of no results after an election, which can go on for weeks. I would like to note to this committee that recent polls show that over 66% of voters flat out turn RCV down when told this. There's two examples I'd like to cite from the state of Maine. Of the 98 recent RCV elections, 60% of the winners did not win by a majority of the total votes cast. Also, in the Maine 2nd District, in the 2018 Democratic primary, of the total 126,139 votes, only 117,250 counted towards the final round. That's 7% of the voters who had no vote for the winner. Connecticut has one of the highest voter turnouts in the country. RCV will lower that due to lack of faith in this convoluted system and the complicated process involved. While I feel these are good reasons to oppose RCV, others may have the opposite opinion. However, one issue that no one can argue is that we just don't have the money for the process involved. Well, I feel the one thing I wanted to also talk about was universal voting. I feel voting is very important, but the act of not voting is just as important. We are Americans and we have a choice to participate or not participate if we so choose. Making someone vote, even if they vote none of the above, is forcing them to vote. I heard Miles Rappaport say that in mandatory voting, the penalty should be low for not voting. Well, what if someone won't accept your low penalty and won't comply? Now what? Are you going to fine them double? What if they don't accept that either? What's next? Are you going to throw them in jail? Removing the choice to vote is removing a fundamental right of Americans. Thank you for your time.
Thank you, sir, for your testimony. Are there any questions from the committee? Seeing none, we thank you for your testimony and for being with us today. Next up is Alex Brandorf, followed by Monty Frank, followed by Thomas Sheffy. Mr. Brandorf, I see you are with us remotely, and you may proceed with your testimony whenever you're ready.
Thank you, Senator Flexer, Representative Blumenthal, Ranking Member Sampson, and Mastro Francesco, and distinguished members of the GAE committee. My name is Alex Brandorf. I'm from New Milford, Connecticut, and I'm a supporter of Connecticut Voters First and Voter Choice Connecticut. And I'm testifying in favor of HB 5701, an act instituting ranked choice voting for municipal, state, and federal elections. Ranked choice voting addresses an ongoing problem and concern for me and for many voters, which is that in races involving more than two candidates, choosing to vote for the candidate that seems best qualified in one's view may result in siphoning votes away from your second choice, the more electable candidate. This may well result in the candidate you least agree with winning the election, despite them not having earned the support of the majority of the electorate. Best case, even if your second choice candidate wins, it will be with a smaller margin of victory that does not truly reflect the sentiment of the electorate and leaves a false and skewed impression of the will of the voters. I faced this difficult choice in past elections, for example, when Griebel and Frank were running for governor under the Serve America movement platform. I found that though they best fit my views and were very deserving of my vote, I had to vote for my second choice major party candidate so as not to risk inadvertently helping my least favorite candidate win. We should not have to accept a system where our second best choice is the best case outcome. We can and need to do better than that. Ranked choice voting would eliminate this serious flaw and would allow voters to vote their preferred candidate without worrying that it would inadvertently throw the election to the opposition. By doing so, it would allow the true sentiment of the voters to be reflected in the initial vote. This is crucial so that, regardless of who wins, our elected representatives can then better understand and therefore better represent the wishes of their constituents. I also believe the current system contributes to driving our political discourse towards opposing and polarizing positions, whereas I believe most voters, while they may lean one way or another, are closer to the middle than the official party platforms of either major party. This is evidenced by the fact that most voters are registered as unaffiliated. I believe ranked choice voting would, over time, allow candidates to emerge that better represent the middle area where most voters live, and would help bring people together toward consensus, middle-of-the-road solutions that take into account all viewpoints and concerns in a more balanced way. At least it would help encourage rather than discourage those discussions by requiring candidates to solicit support from a broad majority of voters. In conclusion, we urgently need a system that allows third-party and middle-of-the-road candidates to emerge and to have a realistic chance of success, and doesn't require voters to fear that making their preference known will be throwing their vote away. I therefore support implementation of ranked choice voting for federal, state, and local elections in Connecticut and urge you to favorably vote HB 5701 out of the GA committee and to actively encourage your colleagues to get this implemented as soon as possible. Thank you for your time and thoughtful consideration.
Thank you for your testimony. Are there any questions from the committee? Seeing none, we thank you for being with us here today and for contributing your testimony. Next up is Monty Frank, followed by Thomas Sheffy, followed by Jonathan Bidlack. Probably got that wrong. Mr. Frank, whenever you're ready, you can proceed.
Bello, Representative Bronco, esteemed members of the committee. My name is Monty Frank. As you know, I was a candidate for Lieutenant Governor in 2018 alongside the late Oz Griebel. I was also chair of the Griebel-Frank for Connecticut Party. I now serve on the advisory board of Connecticut Voters First. I'd like to describe for you the genesis of Senate Bill 389 and how proud I am to work with Governor Lamont to bring ranked choice voting to Connecticut. This journey is not rooted in the study bills or the prior efforts to bring forth RCV. To the contrary, this effort is independent of them, is more narrowly focused, and grew out of my run with Oz in 2018. While we did not win, we did well enough to secure the third line on the ballot for the governor's race in 2022. That prime real estate served as a jumping off point to discuss RCV with all three candidates for governor, including Bob Stefanowski, Ned Lamont, and Robert Hodeling. All of them endorsed ranked choice voting. This bipartisan or tripartisan support was instructive to us in developing Senate Bill 389. In the end, we endorsed Governor Lamont and Lieutenant Governor Bisowitz because of their strong commitment to RCV. And as you all saw, Governor Lamont talked about RCV, early voting, and no excuse absentee ballots during the campaign as central tenets of needed election reform, and RCV specifically as a way to improve our democracy. The governor reiterated his support for RCV during his inaugural address and in written testimony submitted to this committee today, which I'd like to highlight. Governor Lamont in his testimony says, this bill, meaning 389, presents a well thought out path forward for implementation of ranked choice voting. It allows the parties to choose whether ranked choice voting is appropriate for the presidential preference primary, allows municipalities to choose whether to use ranked choice voting for their single member elections, and specifies that ranked choice voting be used in federal congressional elections. He continues, ranked choice voting has been used successfully in a handful of municipalities around the country for decades. And in recent years, the procedure has been implemented broadly and successfully in Maine and Alaska. In those jurisdictions, it appears that ranked choice voting has promoted consensus and ensures outcomes that reflect the full will of the voters. He then thanks the committee, and he says, in conclusion, it's exciting to see ranked choice voting implemented around the country, and Connecticut's time is now to begin work on this important reform. We all agree. And if I could make one final suggestion, if you advance this bill, and I hope you do, it would honor my friend Oz Griebel and all the people he touched if this bill were to be named the Oz Griebel Ranked Choice Voting Bill. I strongly supported RCV and viewed it, as I do, as a key democracy reform. Thank you.
Thank you for your testimony, Attorney Frank. Are there any questions from the committee? Seeing none, we thank you for being here with us
Thank
today
you. Good to
and
see
sharing
you.
your perspective. All right, next up is Thomas Sheffy. Not see him. Oh, there he is. Apologies. Followed by Jonathan Bidlack or Bidlack. Sorry about that. And then Nicole Porter.
Afternoon, Chairwoman Flexner, Chairman Blumenthal, Ranking Members Sampson and Master Francesco, and members of the Government Administration and Elections Committee. My name is Thomas Sheffey. I'm the Vice President of the Connecticut Council on Freedom of Information. CCFOI has advocated for government transparency and accountability since our founding in 1955. Our members represent leaders from print, broadcast, and internet media, the legal community, and organizations that support open government and an informed citizenry. I'm here to oppose Senate Bill 1157, which would automatically exempt residential addresses of an expanded group of employees in 4 more state agencies. The statutes already exempt certain personnel and agencies where such release might be conceived to represent a threat. Expanding it to these agencies is unnecessary. The first proposed exempt category, a judicial marshal employed by the judicial branch, is already covered by this exemption number 10, which covers all employees of the judicial branch. The second 2 categories are subgroups of the Department of Aging and Disability Services, people in the Disability Determination Services Unit, and employees of the Department's Bureau of Rehabilitation Services. The fourth and final category would exempt all employees of the Office of Attorney General, which is clearly overly broad and unnecessary. The proposed bill has a provision in the event of a mass request for the addresses of 50 or more employees, for individual employees and their collective bargaining representatives to receive special notice if the agency believes it is an invasion of personal privacy. Our objection to this bill is the same as has been in recent years. It limits the public ability to hold public employees accountable. The Freedom of Information Act helps ensure accountability for public employees paid with public dollars to work on the public's behalf. The public employee's residential address is an important factual piece of the information in accomplishing that goal. One example is that of Melissa McCaw, the former secretary for the Office of Policy and Management, who was subsequently hired as finance director for the city of East Hartford. The Journal Inquirer reported before she formally transitioned to her post in East Hartford that she owed property taxes in Middletown. When this was reported, East Hartford required her to rectify the situation before she could assume her new fiscal role. The ability of McCaw's address as a public employee made accountability possible. Also consider what happens if a state employee is arrested. A residential address is a key piece of information that helps the public know that the arrested party is, in fact, the state employee in question or someone else with the same name. We understand the legislature enacted section 1-2217 for security concerns. But this exemption, may I finish? Is actually a placebo presented as a panacea and erodes the FOI Act while doing little or nothing to protect the employees seeking it. The Connecticut's Model FOI Act was enacted to increase the public's trust and confidence in its government. When it is perpetually subjected to a death by 1,000 cuts, that trust and confidence is undermined and diminished. Thank you, and I will be glad to answer any questions or follow up with any information you require.
Thank you, sir. Are there any questions from the committee? Seeing none, we thank you for being with us today and for contributing your testimony.
Thank you for your interest and curiosity.
Next up, we have Jonathan Bidlack. Did I get that right? Was I close?
It's Bidlack.
Bidlack. All right. Well, a 50% chance and I blew it. Jonathan Bidlack, followed by Nicole Porter, and then Cheryl Greenberg. Mr. Bidlack, whenever you're ready, you can proceed.
Sure. Thank you, Co-Chair Blumenthal, Co-Chair Flexer, members of the committee. I am Jonathan Bidlack. I'm the director of the governance program at the R Street Institute, which is a nonpartisan public policy research organization in Washington, D.C., where I conduct and oversee research on election reform, including ranked choice voting. I really appreciate the opportunity to speak with you today. This is an issue of particular importance to me. I now live in Maryland, but much of my family hails from Connecticut, and a large part of my family continues to live in the Nutmeg State. So I appreciate that. RCV is an important electoral reform for many reasons, but especially because it improves the incentives of voters, of candidates, and of elected officials. When voters can express their preferences through ranking, they become more directly invested in the election. There's tremendous value in voters having as much input as possible into who represents them and to be free to vote for their favorite candidate. And in this sense, RCV makes elections function a little bit more like a marketplace where individuals can choose any product they want to best meet their needs. And as someone who appreciates free markets, I think this is a very important benefit. Under RCV, voters don't have to vote strategically. They don't have to worry about which candidate other voters like, and they don't have to try to decipher polling data to figure out which candidates are viable. They can just vote their conscience, and the result is that a wider range of political perspectives get injected into the public debate. But RCV also creates healthier incentives for you, our elected representatives. RCV encourages legislators to represent the needs and wishes of all their constituents because broad support is imperative to winning an RCV election. Candidates in RCV elections can't just rely on support from their base, which can make the dialogue between candidates more substantive and more cordial. These effects are especially important as our country becomes increasingly polarized. And we have studied the impact of RCV in the recent elections in Alaska, which I know have come up today, and we found strong evidence for these effects. And I suspect that now with officials in office under the new system there, we'll see elected officials increasingly prioritizing staying in touch with their whole constituencies. And I want to make one final point about the critique of voter confusion that's often discussed. Our research has not found this to be the case, especially as RCV has become more common across the country in states as diverse as Maine and Virginia and Utah. When presented with an actual RCV ballot, voters know what to do. And as someone with a background in economics, I know that markets too often seem very complicated, but every day people make decisions for themselves about what products they like. And the same is true for RCV. In practice, people know how to rank candidates and they like to do it. So for these reasons, I encourage you to advance Senate Bill 389 out of committee. And I thank you again for holding today's hearing, and I'm happy to answer any questions.
Thank you, Mr. Bidlack. It's good to see you. Are there any questions from the committee? Seeing none, thank you for being with us today and for contributing your testimony. Next up is Nicole Porter, followed by Cheryl Greenberg, followed by Jessica Rubin.
Thank you so much. Get it.
Oh, there you are. I'm sorry.
Apologies.
Whenever you're ready.
Yes. Good afternoon, Co-Chair Blumenthal, Co-Chair Flexer, Ranking Member Sampson, and Master Francesco, and distinguished members of the Government Administration and Elections Committee. My name is Nicole Porter. I'm the Senior Director of Advocacy with the Sentencing Project, a national research and advocacy organization headquartered in Washington, D.C. I'm joining you today in full support of House Bill 5702, expanding the franchise as part of a long arc to challenge mass incarceration. And in fact, 2023 is the 50th year of the nation's mass incarceration era. My colleagues at the Sentencing Project have found that 1973 was the first year of the unprecedented surge in the nation's prison rate. Felony disenfranchisement policies are a collateral impact of mass incarceration and impact everyone who's justice involved, including persons completing their prison sentence. These policies are inherently undemocratic. I have submitted written testimony, so I'm going to highlight two important points given the comments of many others who've joined in support today. So first, the United States is very much out of line with world standards, and it's important to take a fresh look at the rationale and impact of felony disenfranchisement policies that can only be described as aberrant by international norms. A study found that 17 nations impose no ban on persons voting while incarcerated, including persons sentenced to prison. Secondly, a national poll conducted by the Sentencing Project along with national partners, Common Cause and Stand Up America, found that 56% of likely voters support expanding the franchise to persons completing their sentence inside of prison. Persons completing their prison sentence retain other political rights. Many have published commentary in national newspapers. They are entitled to freedom of speech. They can also electioneer on behalf of candidates. They can donate money. And the loss of voting rights is an example of undermining their civil rights while they retain other political rights. And 25 states and Washington, D.C. expand voting rights to citizens with felony convictions over the last 25 years. Connecticut expanded voting rights to persons on parole in 2021. And in addition to ending felony disenfranchisement in Washington, D.C., several other states are considering similar measures to House Bill 5072 this year, including pending measures in California, Massachusetts, Illinois, and Oregon. So I'll wrap up my comments there. I welcome any questions or feedback from the committee, and also offer the Sentencing Project as a resource as you all continue to deliberate on this important legislation, and emphatically support for House Bill 5072 and encourage the committee to advance the bill.
Thank you for being with us today and for sharing your testimony. Is there any question or comment from the committee? Seeing none, thank you again. Next up is Cheryl Greenberg, followed by Jessica Rubin, followed by Scott Jarzombeck. Professor Greenberg, whenever you're ready.
Hi, can you hear me?
Loud and clear.
Okay, great. Hi, my name is Cheryl Greenberg, and I thank you for allowing me to testify today in strong support of HB 5702, an act restoring the voting rights to all persons incarcerated. I'm a professor of history at Trinity College, and I also teach at Cheshire Correctional Institution through Wesleyan's Connecticut Prison Education Program. I've taught 5 different courses there since 2015 and worked with dozens of incarcerated men. For their sake and for ours as a society, I feel very strongly about this bill. There are so many reasons for my support, but let me focus my comments on 2: the benefits for incarcerated people themselves and the benefits for society. You've already heard statistics about how many people's lives could be affected and how, and I want to, including health impacts, racial disparities, and community political power. I want to concentrate here on the civic and human rights impact of restoring the vote to all citizens, the right to vote. By the way, it's not a privilege, it's a right. The men I have taught are deeply engaged with news of the outside world. They listen to programs and podcasts. They watch documentaries, read articles, and are eager to discuss the issues of the day. They've had time to think and are so grateful when we discuss their views seriously in class. Too often, their views are not taken seriously, and they feel alienated from the system. These people, citizens of the United States and of Connecticut, are thoughtful, surprisingly knowledgeable, engaged individuals. They want to be part of the wider world, to improve it for others. Returning the vote to these men and women gives them back some of their human dignity and civic voice, invests them in the world and community they will re-enter. By taking away their right to vote, we force those in prisons to step outside of society. And once outside, it's often very difficult to step back in. And as we found with younger voters, the greatest indicator of continuing voting and civic engagement is early and sustained access to the ballot. If the goal of prison is rehabilitation of individuals to fully functional and engaged members of society, there are few things more valuable than restoring this basic right of citizenship, helping these men and women become productive and active citizens, making them feel like they belong, like their voices are important and valued, and that what they do matters. The second reason is how our society benefits from restoring the vote to incarcerated citizens. When one casts a vote, it is a statement of commitment. I want to improve my community, so I'm supporting this candidate or that policy. When these men and women re-enter society, as most of them will, that engagement in the political system will continue. Voting makes people invested in the outcome, and we all need that investment if we want to build stronger and more resilient communities across the state and the country. As a society, we have a choice. Do we want to make sure that those returning to society believe they have a stake in what happens, that they have the power to make a difference? Think of the potential these thoughtful voters have to help their communities. Or do we want to continue to send the message that if you broke the law, your voice no longer matters? There is no point in engaging in the system because society has made it clear that you have no place with us. I urge you to strengthen the path to engagement and commitment to help create productive and thoughtful citizens. Please support HB 5702 and restore voting rights and citizenship rights to all those who are incarcerated. Thank you.
Thank you, Professor. Are there any questions or comments from the committee? I have one quick question, which is, I assume that you're in support of the portion of Senate Bill 1157 designating Trinity College Day.
Oh, is there any question? Absolutely.
Well, I'm glad we got that confirmed. Thank you for sharing your testimony. We appreciate it.
Thank you.
Next up is Jessica Rubin, followed by Scott Jarzombek, followed by Fabrice Beaudoin. I'm sorry in advance. Look forward to you correcting me.
Senator Flexer, Representative Blumenthal, and honorable legislators, my name is Jessica Rubin. I'm the Associate Dean for Experiential Education and a clinical professor of law at UConn Law School. I support Senate Bill 1153. At UConn Law School, our faculty members engage in a wide range of clinical advocacy and research. I direct a clinic that serves a unique statutory role as a court-appointed advocate in animal cruelty cases under 54-86N. Advocates can be volunteer attorneys and supervised law students, and they present information to courts, including information about animal victims, witnesses, defendants, human victims of associated crimes, and identifying information. In connection with this service, UConn's clinic compiles files and research based on the cases. SB 1153 would exempt from public disclosure these records. The clinic's files and research should not be subject to public disclosure for the following reasons. First, the identity of these case files and the identities of defendants charged with animal cruelty is in and of itself private information. Second, most animal cruelty cases end without convictions and instead are nollied, dismissed, or dismissed after a defendant completes a diversionary program. All of these outcomes are not public. When a defendant uses a diversionary program, their file is statutorily sealed during the program and disposed of at the end of the program. So most animal cruelty cases end without public records. All of these cases would be sealed and or destroyed within the judicial branch. But because UConn's clinic as an advocate maintains case files, these files are at risk of public disclosure. It's a unique situation due to the statutory court appointment and UConn's status as a public entity. If any other law school or any private lawyer was appointed as an advocate under 54-86N, their files would not be accessible because they're not subject to FOIA. I'm concerned, very concerned, about defendants' identities, charges, and other case information becoming available to the public through this loophole, where the same information would be handled as confidential by the judicial branch in the same exact cases. Records compiled and maintained by UConn in connection with its service as an advocate should not be available to the public by virtue of UConn's status as a public agency subject to FOIA, if this information would not otherwise be available to the public. The third reason is that personally, I have experienced harassing calls and emails from individuals seeking case information from our clinic, followed by improper FOIA requests for that same information. I fear that our clinic's work and research is vulnerable to such requests, and as a result, I keep my office door locked and conduct my work and my research with the constant fear of it being used against me. Providing the university with the proposed amendment to FOIA would supply a necessary tool to protect case records and close the door on harassing requests from individuals. And for these reasons, I urge the committee to pass Senate Bill 1153.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you again for being with us today and for contributing your testimony.
Thank you.
Next up is Scott Jarzombek, Fabrice, followed by Fabrice Beaudoin, followed by Jason Cassiano. Whenever you're ready, you can proceed.
The distinguished members of the Government Administration and Elections Committee, I'm here to testify in support of HB 06829, an act prohibiting electronic book and digital audiobook license agreements or contracts from including certain terms. I have the honor of being the town librarian at the Fairfield Public Library, one of Connecticut's highest circulating libraries. We circulated over 500,000 items in 21-22, and we continue to see growth this year. 25% of those items circulated were digital. In this year's budget, we requested and received an increase in our collection budget to meet the demand for ebooks. However, as we came out of the pandemic measures and patrons began to return to the library, we did see a plateau in digital usage. That has changed in recent quarters, and we are now starting to see growth again in the use of this part of the collection, creating a wait time for such items by 19 days. Even with an increase in our budget, there's a significant gap between demand and what we can afford to supply. Libraries are not seeking to take money out of the hands of publishers, and most certainly writers, the individuals who are creating this content. Authors, editors, publishers for decades have understood the importance of libraries in promoting and supporting literacy in our nation and commercial publishing. If they did not, they would not include libraries in their book tours, speaking engagements, and regularly attend and present at our conferences. What libraries seek is fair pricing in terms of leasing, fair not only to libraries and patrons, but taxpayers as well. In fact, even with changes that are proposed in this bill, publishers would see no reduction in ebook spending. For some, there might actually be an increase. For me, ebooks help mitigate societal hurdles inhibiting access to library services. An ebook collection is 24 hours, safe and accessible. Shift work, home responsibilities, transportation, or avoiding spaces due to health concerns are not impacted do not impact digital borrowing. With this material, either through audio or adjusted font size, sight-impaired patrons can now enjoy books again from the ease of their homes. While ebooks will never replace physical books, and the digital divide and digital literacy gaps do add additional challenges, our ebook collections provide an additional tool for reaching underserved people and eliminated unintended roadblocks to information. Simply put, we are asking for a fair deal, not only for our organizations, but for taxpayers in our municipalities, so that we can continue to provide these formats along with our physical books and other services, creating more accessibility. Thank you for providing me with time to speak.
Thank you for being with us and sharing your testimony. Are there any questions for the committee? Seeing none, appreciate you being here. Next up is Fabrice Baudouin. I see you're there, and you're welcome to begin whenever you're ready.
Yes, okay. So, esteemed members of the Government Administration and Elections Committee, my name is Fabrice Baudouin, and I'm a professor and researcher in the Mathematics Department at the University of Connecticut. I'm here to testify in support of Bill SB 1153. So over the past 2 years, I've been subjected to harassment by a researcher from China. The harassment started with hundreds of threatening or delusional emails. Then the individual filed multiple complaints against me at UConn and used social media to post defamatory content. More recently, the harasser has discovered the ability to weaponize FOIA and has been bombarding UConn with information requests concerning me or my research collaborators. Since July 2022, there have been more than 20 requests for information by about 10 different identities requesting the same information multiple times. The requests have included records of all of my emails over a long period of times, investigation reports from the compliance officer for the complaints against me, requests about research proposals, emails from UConn administrators. As a researcher and a teacher, many aspects of my work require some level of confidentiality. Many emails and communications with colleagues contain research ideas and directions for the years to come, drafts of research papers, and other sensitive information. Many emails and communication with students contain homework assignments, test questions, and personal information about the students. Although, as far as I know, the university has so far protected the release of sensitive information and student work Several requests are still pending. And if a challenge were made to the FOIA Commission, there is uncertainty of the outcome of that agency. It is deeply concerning to me that the FOIA can be used as a legal way to harass. Thank you for the opportunity to speak on this issue today.
Thank you for your testimony, Professor. Are there any questions or comments from the committee? Seeing none, appreciate you being here with us today.
Thank you.
Next up is Jason Casiano, followed by Hassan Avdic, followed by Maria Weingarten. So you are with us remotely, Mr. Casiano. Whenever you're ready, you can begin.
Good morning, distinguished members of the committee. My name is Jason Ayan Casiano. I'm a resident of New Haven City, a released juvenile offender, a university student pursuing my master's degree, MSW, and a current outgoing print and marketing supervisor for Staples Incorporated. I stand in support of House Bill 5702, an act allowing incarcerated individuals to vote. I'm here to explain not only why this bill is important to me, but crucial to us all. I'm going to illustrate that last point by introducing you all to a historic and forward-thinking program comprised of some great staff, Department of Correction workers, and incarcerated folk working in collaboration to usher in rehabilitative models with civic engagement at its core, with data supporting their success. It's called the Cheshire Honor Unit, and it validates all the rationale put into this bill. Every member in the Honor Unit is required to sit on roundtables, committees, and learn policy and diplomacy to employ throughout the Honor Unit community. That's civic engagement 101. And they need you to nourish and support that with real resources that this bill will bring. Approximately a year ago, the people of Connecticut issued a mandate to release me, a juvenile offender. Within a month, while working with an unmatchable voting rights organization, Full Citizens Coalition, I registered and voted months after my release for the first time in my life at 43 years old. I came from the Honor Unit. Please allow those like myself to collaborate with their society meaningfully. For over 96% of offenders will transition back into society. Why do we not want pre-engaged citizens returning? We are a society of pre-approval, pre-register, etc., because we've learned that having information and access and early provides for more ethical and efficient engagement with entities or individuals in our society. Why would we not want that for a historically vulnerable population? I will posit before you that it would be reprehensible both legally and morally in 2023 to not pass this bill. I am supportive of this bill, and I urge you to pass this bill. Lollipop, state candy forever. Thank you.
Thank you. And we'll note that your testimony was on that bill as well.
Thank you.
Appreciate your testimony. I'm seeing no questions or comments from the committee. So thank you again for being here with us today. Next is Hassan Avdic. Is that close?
Good evening.
Good evening.
Dear Senator Flexer, Representative Blumenthal, and members of the Government Administration and Election Committee. My name is Hassan Avdic. I'm a resident of town Wethersfield. I'm testifying in support of SB 1158, specifically in favor of the item 112 in the bill, the Bosnian Genocide Remembrance Day. When war started in my old country, I was 17 years old. For almost a year, my town was surrounded and bombed daily. A lot of dead and injured men, women, and children. In early 1993, Serbian army occupied my town, and a majority of the people fled to neighboring towns. My father ended in Srebrenica, rest of the family in Tuzla. Srebrenica was declared UN safe zone after. In July of 1995, Srebrenica safe zone was overrun by Serbian army. They transported women and children to Tuzla and kept all the men and boys captured. All those men and boys were executed with their hands handcuffed behind their backs. My father was one of them. His remains, with thousands of others, were put in mass graves, then moved from one mass grave to other in an attempt to hide it from inspectors from International Court of Hague. Years later, part of his remains were discovered in multiple mass graves. altogether less than half of the bones. 20 years after he was executed, I went from USA to Bosnia to put his remains to the rest in Srebrenica Memorial Center. In Bosnia and many European countries, July 11th is recognized as Genocide Remembrance Day. Since the ruling of the Hague International Court it was genocide against people of Srebrenica. Bosnian community in Connecticut is approximately 5,000 to 7,000 strong. Hardworking community, true Bosnian and American patriots. Bosnians do remember and observe July 11th as Genocide Remembrance Days every year. We would like you to help us make it official so people can learn from it and help future generations remember this and make sure it does not happen to anyone ever. Every July 11th, we are walking in the name of our executed family members and countrymen and boys. We would like you to join us in this walk in the future. As I mentioned above, on this day, around this day, 8,372 men and boys were executed with their handcuffs on their backs. Among those men was my father, my best friends, my father's brother, my mother's brother, and so on. We Bosnians came to America around the year of 2000. America was and still is light at the end of the tunnel for us. We love our new country with all of our hearts. We also want to remember our old country so our kids, friends, and neighbors can learn who we are and where we are coming from. We will really appreciate your help in supporting this bill passage. I urge you to all support SB 1158 and help it pass this legislative session. God bless you all. God bless America. God bless Bosnia. Thank you very much.
Thank you, sir. Other questions or comments from the committee? Seeing none, thank you for being with us here today and sharing your story. Next up is Maria Weingarten, followed by Evan Mincy and Fulvia Vargas de Leon. Is Maria Weingarten present? Is Evan Mincy present? Takes us to Fulvia Vargas de Leon, and I see you are with us remotely. Whenever you're ready, you may proceed.
Good evening, committee members. My name is Fulvia Vargas de Leon, Senior Counsel at Latino Justice ProDef. The late civil rights advocate John Lewis once said, "To make it hard, to make it difficult, almost impossible for people to cast a vote is not in keeping with the democratic process." Felony disenfranchisement is rooted in a racist history of suppressing the voices and in turn the vote of the most marginalized in our society. It serves no legitimate purpose other than to continue disempowering Latino and Black communities from participating in our democracy. Felony disenfranchisement also has the power to perpetuate a wave of disinformation where justice-impacted individuals believe their constitutional right to vote is lost upon contact with the criminal system, leaving thousands of individuals mistakenly unaware of their ability and right to cast a ballot, a sort of de facto disenfranchisement. Approximately 5.17 million people are disenfranchised due to a felony conviction in this country. While there are inconsistencies with the ethnicity data reported by correctional facilities, the Sentencing Project estimated that at least 506,000 Latinx Americans of the voting eligible population were disenfranchised. In Connecticut, Latinos make up 17.7% of the state's total population, but disproportionately make up over 1/4 or 28% of the currently incarcerated population. In fact, Connecticut also has the third highest incarceration rate of Latino adults. And while the discussion of figures highlights the gravity of the problem, it is even more crucial to understand that even one person disenfranchised is one too many. Individuals convicted of a felony may lose their physical freedom, but there is an inherent understanding that this does not equate to the loss of human and civil rights. Felony disenfranchisement runs afoul to the ideals and principles of a representative democracy, and when a practice exists that excludes an entire population from casting a ballot, it undermines the value of having a government by and all its people. We call on the Connecticut legislature to pass HB 5702 and bring an end to the discriminatory practices that have for decades continuously diluted the voices and votes of marginalized communities. Thank you.
Thank you. Are there questions or comments from the committee? Seeing none, we thank you for being with us this evening and for sharing your testimony. Next up is Henry Rowland, followed by Dominic Frances, followed by Lauren Kurtz. Henry Rowland, there you are. Ms. Rowland, whenever you're ready, you may proceed.
Thank you, distinguished members of the GAE. My name is Henry Rowland from Connecticut Voters First and Veterans for Political Innovation, and I'm here in support of Senate Bill 389, because ranked choice voting fundamentally changes the incentives built into the structures of how we elect our leaders. It changes these incentives for candidates, for voters, for our elected leaders, and prospective candidates. Candidates for office in a ranked choice voting election are encouraged to be more civil and positive and much more inclusive. They now need to reach out to a broader group versus safely neglecting those who they know they won't get a vote from. The plurality system allows them to succeed by neglecting these voters. To succeed in the ranked choice voting election, they can't be divisive and instill fear. They must be collaborative and broadly appeal in the hopes of getting a second or third vote. They're rewarded by pointing out similarities instead of differences. They can succeed by focusing on where they agree with other candidates instead of where they disagree. It changes the tone of elections from negative mudslinging to positive team building. For voters, RCV removes the fear of vote splitting and allows voters to truly express their preferences, even for those candidates who would be considered spoilers in a plurality election. Voters no longer have to worry about wasting their vote or being ignored by those candidates who are from a different party. For elected officials who have won in an RCV election, they now know more about the electorate and what's important to voters. They can see the second and third choices, and they know what those candidates stood for, and therefore can adjust how they behave in office. They will no longer be penalized in the next election for working with members of the other party or any stakeholders on an issue other than their own party. And they can truly be problem solvers and productive leaders. Finally, and I think less often talked about in ranked choice voting, are the pool of prospective candidates. It increases and becomes more diverse because those who would be qualified to run for office often don't want to touch politics. With ranked choice voting, with these more civil elections, that changes and you have a much more diverse group throwing their hat into the ring. So for these reasons, I urge the committee to treat SB 389 favorably and to review the testimony presented by members of the Connecticut Voters First Coalition. Thank you, and I welcome any questions.
Thank you. Are there any questions from the committee? Seeing none, we thank you for your testimony as well as for your service to our country. We'll count your testimony even though it was in the Army.
Thank you for your service as well. No harm done.
Thank you. Next up is Dominic Francesi or Frances. Not seeing Dominic. After Dominic, there's Lauren Kurtz. Is Lauren Kurtz present? Not seeing Lauren Kurtz. Is Michael Bailey present? There he comes.
Hi, I'm sorry.
Oh, sorry.
Zoom
Oh,
fail.
there's Ms. Kurtz. All right, Ms.
I'm
Kurtz
sorry.
came just in time. You
Yes,
have
thank you. Should I kick off?
whenever you're ready.
Great. So as you said, my name is Lauren Kurtz. I'm the Executive Director of the Climate Science Legal Defense Fund. Thank you for the opportunity to testify in support of SB 1153, which would protect higher education records under the State Freedom of Information Act. Open records laws have a vital role, but as previous witnesses have made clear, they can also be dangerously exploited. Since 2011, my organization has assisted dozens of climate and environmental researchers targeted via open records laws. We've also graded the laws of all 50 states and DC. Connecticut's FOIA's laws has consistently gotten a C due to being vulnerable to misuse. As you can see by me testifying remotely, I now live in New York, but I'm a proud graduate of the Connecticut public school system K through 12. Connecticut can do much better than a C. And in fact, many other states in the Northeast and nationwide have had much more protective laws for years. Sometimes with nearly identical language to what SB 1153 proposes, such as with New Jersey, Georgia, Virginia, and South Carolina. Other states like Rhode Island and North Dakota have also recently implemented reforms prompted by the increasing and aggressive targeting of public university professors via open records laws. This is an issue that unfortunately affects all disciplines, climate scientists to cattle researchers, and red and blue states alike. Unfortunately, without safeguards in place, Hostile groups frequently attempt to weaponize open records laws. Most commonly, these laws are manipulated in an attempt to trawl for gotcha emails, potentially containing embarrassing private messages or academic jargon that can be taken out of context in order to confuse and mislead the public. Responding to open records inquiries consumes 10 to hundreds, sometimes thousands of hours of legal review by professors who would universally prefer to be doing research, while their universities simultaneously drown in legal fees that subtract from the public education budget. It's hard to blame the numerous scientists who, following experiences like this, leave public universities for other institutions or exit research altogether. There was a witness who spoke earlier approvingly of the open records laws in Arizona and the relative lack of protections for researchers. I personally do not feel so positively. I know actually of multiple Arizona State University professors who either left the state for another university or retired early following, I kid you not, multi-million-dollar open records lawsuits brought by climate denying groups, lawsuits that soaked up literal years that would have otherwise been spent towards important research. There's no real downside to protecting researchers from open records abuse. Unlike the other sorts of government information generally revealed by public records laws, published scholarly work is already publicly available just by the very dint of being published. Real academic debate should and does involve reviewing and replicating or not publicly reviewed peer research work, or say publicly peer-reviewed published work, and does not need open records laws. Last but not least, this proposed revision also reflects what Connecticut courts have already found, that the public interest in protecting certain academic research records outweighs any benefits from releasing them. I put the citations to those cases in my written testimony. SB 1153 helps safeguard critical scientific research, protect academic freedom, and save real taxpayer money, while still preserving important financial and administrative accountability. That's why I urge the legislature to vote yes on this bill. Thank you for your time.
Thank you. Are there any questions or comments from the committee? Seeing none, we thank you for your testimony and being with us today. Next up is Michael Bailey, followed by Linda D'Alessio and Donald Moody. Oh, excuse me, yes. And Mr. Bailey will be accompanied by Alexis Bodoin. Did I say that? Dudden.
Good evening, co-chairs, Senator Flexa and Representative Blumenthal, esteemed members of the GAE committee, Representative Labriola and Representative Haddad. My name is Michael Bailey, and I am the Executive Director of UConn AAUP, the union that represents the faculty and coaches in collective bargaining at UConn. Thank you for raising Bill SB 1153, and I'm testifying in support of that bill today. UConn AAUP supports open records laws that encourage government transparency and allows for the general public to access copies of administrative and faculty records. When those open records requests are abused and used as a weapon to harass and interfere with faculty research, teaching, and scholarship, or used to threaten or chill faculty from their right to academic freedom and unfettered reporting of research, UConn AAUP must rely on open records laws to protect faculty. SB 1153 increases the level of protection, and we encourage its passage. There are several reasons why I support this amendment to the Connecticut FOI Act. The proposed language gives the university administration the necessary tools to immediately deny malicious requests that only intend to harass, intimidate, or discredit scientists whose research or teaching they simply don't like. The increased use of university email communication that create public records are often sought in public information requests. Discussions between faculty in the early stages of research exploration can be misinterpreted and used to discredit or defame faculty. There is evidence that abusive requests target the most vulnerable and easily intimidated faculty. Those are junior faculty, women, and people of color. There's a potential loss of competitiveness with our peer institutions whose states have better protections for their faculty and it can advance their research without time-consuming, unnecessary delays. In the increased cost for using university resources to defend the university and faculty from frivolous information requests. I'd like to yield my time to Professor Alexis Dudden, who would like to go through some of her experiences with this malicious request.
Thank you, and thank you to the members of the committee. I am Exhibit A. That is to say, I'm not with prepared testimony, but I'm here to support my colleagues who've already presented testimony about how protection is needed because when FOIA is weaponized, it defeats the purpose of what is an excellent idea, freedom of information, which as a historian, I'm a history professor, I support wholeheartedly. The weaponization of it to target specific faculty members doing research for particular gain is public money paying to publicly harass, yielding not just a waste of time and money, but genuine attempts to discredit the truth. So it has the opposite effect. Very, very briefly, it is an incredible honor to listen to the Bosnian community because I study Holocaust denialism of a different brand. I studied the 1930s and 40s sexual slavery of up to 200,000 girls and women by the Japanese military. There are 11 remaining survivors. I work with them. The denialists in Japan would seek to erase their history from the public record. I am their advocate internationally, in the state of Connecticut, in my town on the coast. And therefore, I've become the face to go after. I have had four FOIA requests in 5 years, and I have letters from a variety, 50 legal professors from Harvard and Yale all the way down to University of Connecticut, supporting that.
All the way up.
Go Huskies. But my point is, what I mean by a public waste, this particular final request was harassment pure and simple, but there are no protections to mediate what humanities professors do as research before peer-reviewed publication, which is when I am happy to debate and have published extensively. And that's the public record that is ready for everybody. As I get there, I work with activists in Tokyo whose offices are firebombed. I work with survivors who have denialists sit outside their houses and call them dirty liars. Somebody gives voice to them, I do. This particular instance went all the way through so many repeated requests and harassments of the process that, and I'll submit this ended up as a hearing for the Freedom of Information Commission, and complainant, because he's just a bully, he's a US citizen living in Japan, failed to show. But it took, this most recent request took a year of my scholarly productivity, which we want to talk about a waste of money. I am paid for by all of you, thank you, as a tenured professor. So I thank you for letting me be Exhibit A, saying we don't have sufficient protections to protect the safety of the faculty or the researcher. Certainly believe in the truth. Thank you.
Well, thank you very much for being with us today and sharing your experience. I think probably a lot of us would agree we'd like to work with the Freedom of Information Commission to get the language right, but there's definitely an interest here that needs to be protected. So we appreciate you bringing this to us.
Thank you.
Next up is Linda D'Alessio, who I believe is joined. Nope. Oh, sorry, Professor and Mr. Bailey. We have a question from Representative Master Francesco, who's joining us virtually. Whenever you're ready, Representative.
Thank you, Mr. Chairman. I just had a couple quick questions just for follow-up. How many requests have there been that you feel that were more on the harassment endpoint?
Well, the first requests came in over 10 years ago, and it was a different portal system for the request. The 4 in the past 5 years have all been harassment. And the way one makes it a request through the Yukon portal, it's through the University Communications Department. And so keywords are put in. And so it's been the name comfort women, which is the horrible euphemism for the militarized sex slaves. And also specific names of colleagues with whom I collaborate. This ultimately, so if, for example, a colleague of mine who is at the University of California, Irvine, their first name is Jeff, Jeff. The yield from that name search alone was 3,000 pages because I have a number of colleagues named Jeff, but I had to go through each one and play sort of US occupation official and redact to ensure that no other name was released. In this most recent instance, for example, 391 pages of emails were released to complainant, who then accused the university of shielding me for political work, which actually this person described as an international conspiracy with Nancy Pelosi to bring down the government of Japan. I assure you, I have never worked with Nancy Pelosi, but that wasn't the point of it. It was the fabrication and the targeting of my activity to try to derail my scholarly life while I was continuing to publish with footnotes and evidence. And as this statement of support suggests or states, it serves little public purpose, these targeted, weaponized FOIA requests. Those genuinely interested in any humanities professor's research can simply refer to the footnotes, bibliographies to determine the sources. Then it becomes a public debate. That's what peer review process is. Getting there, working with colleagues around the world, and especially if we think of it in the context of the pandemic, when I couldn't even go to a library, I had to contact colleagues at other institutions, not just Connecticut nationally, but around the world. And then it becomes a question of responsibility in terms of shielding, especially vulnerable colleagues within the context of Japan who are harassed, threatened, intimidated, and lose their jobs.
Thank you. So as far as the FOIA request goes, so I'm assuming in the FOIA request, I'm assuming that there's no intimidation, harassment, or threatening, right? What is that?
If I could follow up, the complainant, first of all, it was a joke at the beginning, which our communications office didn't recognize because they're not specialists. The complainant listed his name. He also listed a name called Park Geun-hye, who was the then imprisoned, impeached former president of South Korea, because this group is also anti-Korean and thought it would be kind of a joke to put that name in. Had I seen that in any stage, this wouldn't have gotten off the ground. But then the complainant continued to harass 3 members of the communications office over the course of a year throughout the pandemic, and also all the way up to Stephanie Wrights, the spokesperson for the university. Then it reached the level of he decided to proceed with charging UConn with malfeasance. And so then I had members of the UConn General Counsel's office. So if you think about that amount of taxpayer money, when all this person was trying to do was harass and intimidate me and try to derail my scholarship, throughout the process, he continued to publish in Japanese in Japan, accusing this. So it was just this targeted name. And throughout all of this, then I get daily death threats on my email or my physical mail.
Right. And I certainly understand that there's obviously some bad actors out there and everything. And trust me, I understand we get abused and threatened quite often as legislators. But I'm just curious. You said there was 4 FOIA requests over the past 5 years or 10 years. So how many total were there requested that you didn't approve of?
Forgive me for not being able to answer specifically. I believe 8 in total since 2012. There have been 4 since 2015. And the same person occasionally working with another American abroad. It used to be that only US citizens could make the request through the UConn portal, but as I've learned from one of my colleagues, now I think that protection is lost as well. And there is a distinction also between the hard sciences and the humanities, because the way we go about talking, and we just heard from one of my colleagues mentioning that we're in the process of coming up with an idea, we're in the process of publishing, and so we bat ideas back and forth to one another over email. So this individual wanted not just a gotcha moment, he wanted to do a document dump and expose anybody just in the open to continue to harass them outside of the university context.
Right. I get it. I understand. Unfortunately, there are some bad actors out there that certainly abuse the system and take advantage, which is unfortunate. Okay, thank you very much for my question. I was just curious about how many there was over the past few years. I appreciate it. Thank you, Mr. Chairman.
Thank you, and thank you both for being with us today and sharing your testimony. Next up is Linda D'Alessio, appearing with us virtually. followed by Donald Moody and Aaron McCool. Ms. Delesio, you can proceed whenever you're ready.
Oh, hi. Dear members of the Government Administration and Election Committee, my name is Linda Delesio and I am a resident of Woolkit, Connecticut. I am also affiliated with a citizens group called Connecticut Voter Integrity Group. I have been involved in election integrity activities for the past 3 years, auditing via computer and in person with a dedicated nonpartisan group of voters and citizens that only request fair and transparent election processes. I oppose House Bill 6824. I write and I testify in opposition to this bill for several reasons. Local jurisdiction should take place locally. There's less corruption that way. I have several complaints with the FOI Commission in Hartford for not releasing federal election audit data that the Secretary of State's office is required to have per federal law. I needed to take the Secretary of State's office to court and file a temporary restraining order to prevent them from destroying data that they are federally required to have. However, they do not have this data. I have submitted a complaint to the SEC in February of this year that will require investigation of many irregularities in our voter rolls. This does not involve 1 or 2 cases of potential corruption of our voter rolls or potential election fraud, but many affidavits in many counties. I have submitted several FOI Commission appeals that involve the lack of release of documentation of required audits of our elections and certification of election equipment that these bodies are federally required to hold as administrators of federal taxpayers' money. One of the most important things that came out of the TRO case I filed was that our central tabulating system, which was bought with federal money in 2006 and is called the Global Election Management System, or GEMS, currently resides at the University of Connecticut. All tabulator results feed into this system along with memory cards that program the ballots. That is clear through testimony that was given by the Secretary of State's attorney. I submitted that testimony transcript to my town legislator, who currently sits on this committee. When reading through Connecticut state statutes, I did not find that the University of Connecticut was an administrator in charge of our elections. I also did not find that the state Supreme Court in Hartford is the final arbitrator of potential election fraud. The potential violations of administrative duties related to the Help America Vote Act.
Excuse me, Ms. Delesio.
Yes.
Your time has elapsed. If you could please wrap up your testimony.
Okay. I would just like to say that the administrative departments are responsible for our elections. And obviously they are not following federal law. That concludes my testimony.
Thank you very much. Are there any questions from the committee? Seeing none, we appreciate you being with us tonight and sharing your testimony with us. Next up is Donald Moody, followed by Aaron McCool, followed by Matthew Hallisey. Is Mr. Moody present? I don't see him on Zoom. Mr. McCool, are you with us? Not seeing him either. Matthew Hallisey, the floor is yours whenever you're ready.
Good evening, Senator Flexer, Representative Blumenthal, and Representative Labriola. And thank you for the opportunity to testify. My name is Matthew Hallisey. I'm here in my own capacity. I'm not representing any clients. And I'm referring to Senate Bill 1158, looking for your support, specifically Constitution Day and Free Enterprise Day. And I've also proposed an amendment, and I hope you will consider that and appreciate your support. And I'm happy to answer any questions you might have.
Now you piqued my interest. What's the amendment you've proposed?
It's online. It's in the, it's posted on the bill homepage, and it's basically to clarify the bill. I think with regard to Free Enterprise Day, it refers to this, the innovative spirit of entrepreneurs. And the idea is that I believe that they are the ones who should be recognized, the entrepreneurs themselves, as opposed to Free Enterprise Day, even though we're recognizing that day specifically. For Constitution Day, I think it should also be tailored to Connecticut. I think we are the Constitution state. We are known as that, and it adds the Connecticut to recognize Connecticut as having the first written constitution of a democratic government.
Well, you filed written testimony, it sounds like.
Yes.
All right. Well, we'll look forward to looking at that, and be sure to be in touch. Don't hesitate to reach out if you want to work with us on that language there. So
thank you so much, and thank you for introducing the bill.
Oh, and don't go anywhere, because Representative Master Francesco has a question for you.
Thank you, Mr. Chairman. Matt, thank you so much for your testimony. I think this is really a great idea to have a Free Enterprise Day and Constitution Day. And I know last year we tried to get this through, and it didn't quite make it. So hopefully we can work on this and get it through this year. I think it's very important, especially for our entrepreneurs. And the point you made about the Constitution Day, putting Connecticut in there, certainly makes a lot of sense. I mean, Connecticut is the Constitution state. So I think it's a good bill, and hopefully we can work on it, and hopefully we can get it passed.
Thanks so much. And it did pass the House last year.
It did.
But it did not pass there. That's correct.
Yes. Thank you. Thank you, Mr. Chairman.
Yeah, that's Senate.
Yeah. We got to work on the Senate.
No disrespect intended, Senator Flexer. It was almost the last, I think it was the last day, maybe.
Yeah. Well, I'm
not sure about that, but
I'm sure there's plenty of fault to go around. All right. Well, thank you for your testimony. It looks like we have no further questions, and we appreciate you being here with us.
Thanks so much. Have a great night.
John Board is next, followed by Carola Kaman, followed by David Pettigrew. Mr. Board, whenever you're ready.
Good evening, members of the committee. Good evening, members of the committee. Chairs Fletcher and Blumenthal, ranking members Sampson and Master and Francesco, members of the GAE committee. My name's John Board. I'm here to speak on the ranked choice voting bills before you this evening. To summarize, I favor Senate 389, 5087, 5133, and House Bill 5701, with a strong preference towards 389 and 5701 against 5712, which is the study bill. Transparency, accountability, problem solving, and electoral competition are fundamental principles that are crucial to good governance in our state and nation. These principles also provide the foundation for why we should adopt ranked choice voting. RCV provides and enhances transparency by providing more data than our current electoral system, which can improve our state's policy-making process. Adopting RCV can foster more of a positive political climate, resulting in a more representative democracy. Passing RCV ensures that electeds are held accountable to the voters they serve, and by having them secure a majority to win, and forcing leaders to focus on problem solving and solutions instead of focusing on narrow constituencies. This improves dialogue during campaigning. And implementing RCV will strengthen electoral competition. When voters have more choices, they pay more attention, and the better outcomes occurs. I would encourage the committee to go even further than the Austin Fong bill to ensure that municipalities have the ability to use RCVs, a single transferable vote, to determine the outcome of elections when there are multi-member office elections. To ensure Connecticut elections in Connecticut are secure, we must upgrade our voting machine tabulators to ensure stronger voter integrity and harden our cyber defenses. Working with Secretary Thomas to ensure that new tabulators can handle RCV and that all voters have the opportunity to be educated on how to use them at no cost to our municipalities. RCV is a fair and democratic way to run elections. It's time for Connecticut to join the ranks of other states that use this system. I encourage this committee to put principles first, pass 389, pass 5701 to give nutmeggers more choice and more voice in our electoral process. And I'm prepared to answer any questions that members of the committee may have. Thank you.
Thank you. Are there any questions from the committee? Seeing none, we thank you for being with us this evening and for sharing your testimony.
Thank you, Senator. Representative.
Comment on whether it's a promotion or demotion. All right. I know I've already tested the interbranch comedy here, or interhouse. All right. Carola, come on. If you're with us, you are up. Not seeing Carola, come on. Next up is David Pettigrew, who I'm seeing is joining us remotely. Whenever you're ready, you may begin.
Thank you. Senator Flexer, Representative Blumenthal, distinguished members of the committee. I'm David Pettigrew, a professor of philosophy at Southern Connecticut State University since 1987, where I also teach a course on Holocaust and genocide studies, a course I created in 2013. Subsequent to Public Act 1824, I've been conducting workshops with Connecticut teachers about the Bosnian genocide. Thank you for the opportunity to speak in favor of Bill 1158, item 112, designating July 11th as Bosnian Genocide Remembrance Day. This bill would support the human right to the truth and memorialization for survivors of the Bosnian genocide and their descendants. Two international courts have judged the atrocities committed in Bosnia to be genocide and other war crimes. The genocide conviction of Radovan Karadzic, for example, found significantly that he was part of a joint criminal enterprise that sought to permanently remove all Bosnian Muslims from Bosnian Serb claimed territory through atrocities that took place in towns across Bosnia, such as Foča, Kalinovic, Prijedor, and Visegrad, places where even today, survivors are discouraged or prohibited from installing memorials for the victims, but where convicted perpetrators are glorified and the atrocities are denied, as Becker Hodzic mentioned earlier today. This bill would provide crucial support for the members of our Bosnian American community in Connecticut as they and we commemorate the genocide and remember their loved ones. For Holocaust survivor Elie Wiesel, such commemorative practices are nothing less than a matter of justice. Historical events seem distant, and the number of victims can seem abstract. As Senator Anwar mentioned, my research brings me to bear witness at execution sites, former concentration camps, and exhumations of mass graves in Bosnia in solidarity with survivors. For example, I witnessed the arrival of trucks bringing the human remains of the victims who have been exhumed from mass graves to the Srebrenica Memorial Cemetery for burial. This takes place each year as new victims. Each year, new victims are still being located, exhumed, and identified. I found myself witnessing family members as they moved hundreds of coffins from the trucks into a warehouse in preparation for burial on July 11th. I realized I could not be a spectator. Somehow I joined the line of men and helped move the coffins into the warehouse. As the coffins came down the line, one by one, we bore the weight of each life that was taken from us and the grief of each family. We were bearing witness to the truth of the genocide as victims finally came home to Srebrenica, to their final resting place, one by one. The same process takes place elsewhere every year in Bosnia, such as in Kozarac Kamičani Cemetery in Prijedor. To conclude, in my research in human rights activism, I've been constantly inspired by young Bosnians who lived through these atrocities, but somehow have kept their hearts open to the hope that telling the truth will lead to justice. You heard from them today. Let us not be spectators. Let us respond in solidarity with that hope for justice by approving this bill to remember each and every victim of the genocide in Bosnia. My sincere thanks to Senator Anwar and student activist Becker Hodzic and others for their exemplary leadership, and to members of our Bosnian American community, Mirzet, Halid, Amina, Erna, Leila, Audits, and Hassan for their informative, moving, and unforgettable testimony today. And thanks to you, committee members, for your time and consideration. Thank you.
Thank you for your testimony, Professor. Are there any questions from the committee? Seeing none, thank you again for being with us this evening and for contributing your testimony. Next up is Tommy Battle, followed by Mary Frances Metrick, followed by Evan Preston. Is Mr. Battle here? Oh, there he is. All right. Whenever you're ready, you may begin. And just make sure your microphone is on. There you go.
To the co-chairs, Senator Flexer, Representative Blumenthal, and the esteemed members of the GAE committee, thank you for allowing me the opportunity to speak about why I immediately support eliminating the unfair practice of felony disenfranchisement for persons incarcerated in the state of Connecticut concerning their democratic right to vote. My name is Tommy Battle. I am the organizer for the Full Citizens Coalition, a Connecticut-based action group focused on undoing the unjust harm caused by felony disenfranchisement and ensuring that every citizen is respected as a full citizen. This bill is a bill that 2 years ago, I probably wouldn't have cared for. I've been released from the Federal Bureau of Prisons and believe that I was well into my reentry. I was working and focused on being a father. However, I then started volunteering for the Full Citizens Coalition, doing community outreach and sitting in on strategy sessions where the very theory of democracy was being discussed and examined and then applied to how and what that could look like in our cities. This changed me. I am a registered Republican, conservative in views. And when I looked at how much further in community building, my understanding of government and rehabilitation I could have been if my rights were never revoked throughout my incarceration, it isn't a party fight. It's a fight of citizenship, a fight to stand on belief and voice it. And the only way our government hears you through your electoral rights. There's a part of your dignity and humanity that prison takes from you. You define yourself through the eyes of your treatment. You leave and return to the community that have opted out of the democratic process. That type of hopelessness is a driving factor in our recidivism rate. I believe that by this one act, our community can begin to heal themselves. We can pick ourselves up, men and women come home ready to contribute with an understanding of how to contribute. I get to show and talk to my 12-year-old daughter about this process in a way that I was never talked to by my parents. Yet, I know how few these conversations are happening because of the work I now do in the community. Connecticut has the opportunity here to once again lead the nation and set the benchmark on democracy. Thank you.
Thank you. Are there any questions from the committee? Seeing none, thank you for being with us this evening and for contributing your testimony. We appreciate it. Thank you, you too. All right, Mary Frances Metrick, are you with us?
Good evening.
Oh, there she is. All right, whenever you're ready, you can proceed.
Thank you. Good evening. Good evening, co-chairs Blumenthal and Flexer and esteemed members of the committee. I am Mary Frances Metrick. I'm a member of the advisory board of Connecticut Voters First. I'm speaking in favor of SB 389. While I support all aspects of the bill, I'll be addressing my comments to the presidential preference primary. As Catherine Gale and Michael Porter noted in their analysis of our political dysfunction, we need systemic change in order to reinvigorate our democracy. Perhaps one of the most important changes we could make is ranked choice voting. Ranked choice voting, or RCV, ensures the candidate receives the majority of votes cast, not just the plurality. This is a problem we saw in the 2016 presidential primaries. With the exception of the American Samoa, Northern Mariana Islands, and a North Dakota convention, the Republican nominee in 2016 did not achieve majority of votes cast until after 36 states, the District of Columbia, Puerto Rico, and 3 territories had voted. There are other significant issues needed addressed with the presidential primary ranked choice voting. As we know, in the presidential primary, candidates tend to drop over time. For early voters and absentee voters, and in particular for our military forces who voted for the candidates who dropped, they're effectively not deprived of their vote. Ranked choice voting fixes that. In presidential primaries with large number of voters, voters sometimes feel the need to vote strategically. For example, to vote for the most viable candidate who's most acceptable to them rather than the candidate of their choice. Ranked choice voting allows a candidate to vote, allows a voter to vote for the candidate they actually prefer without worrying about the wasted vote phenomenon. The legislation that we're suggesting does not mandate the parties to use ranked choice voting in their primaries, but only gives them the option to do so. In addition, the ballot design for a primary, presidential primary, may have less complexity that needs to be addressed than a general election ballot. For these and other reasons, we request the passage of SB 389, and in particular for the presidential preference primary. Thank you.
Thank you. Are there any questions from the committee? Seeing none, I appreciate you being here to share your testimony.
Thank you.
Next up is Evan Preston, followed by Damir Hasanovich, followed by Olivia Scully. I see Mr. Preston is joining us virtually. Whenever you're ready, you may proceed.
Thank you, Chair Blumenthal, Chair Flexer, ranking members, and members of the committee. My name is Evan Preston, and I am a Director of Advocacy for Secure Democracy USA. Thank you for the opportunity to testify today in support of House Bill 5702, House Bill 5714, Senate Resolution 35, and Senate Bill 1150. I've submitted written testimony, so I'll just summarize some of the key points we make there and point of emphasis. But first, Secure Democracy USA is a national, nonpartisan nonprofit working to safeguard our voting systems, strengthen confidence in our elections, and improve voter access throughout the United States. I want to first touch on the efforts of both 5702 and 5714 to take a step forward in helping, as the previous witnesses expressed, keep incarcerated people integrated with their communities. This would be a positive step forward for Connecticut, building off of the work in 2021 with Senate Bill 1202. For Senate Resolution 35, we think that this proposal is a good idea that moves Connecticut in line with other states in New England, such as Maine, Rhode Island, Massachusetts, by offering an opportunity for young people to prepare for the responsibility and the freedom to vote. Finally, Secure Democracy supports Senate Bill 1150, as Secretary Thomas expressed earlier this morning, in developing and implementing the recommendations of the Risk Limiting Audit Working Group. We believe that a risk limiting audit can help build confidence in elections by providing the public with statistical evidence that electronically tabulated results are correct. On behalf of Secure Democracy USA, again, I ask you to support these bills and appreciate the opportunity to submit testimony. Thank you.
Thank you. Are there any questions or comments from the committee? Seeing none, appreciate you being here with this evening to share your testimony with us. Next is Damir Hasanovich, followed by Olivia Scully and Drake Ramke. Mr. Hasanovich, whenever you're ready, you may proceed. And just make sure that your microphone's turned on. There you go.
Good evening, Senator Flexer, Representative Blumenthal.
I'm sorry to interrupt, Danny. If you could just speak into the microphone, we want to make sure that your testimony is recorded.
Good evening, Senator Flexer, Representative Blumenthal, and members of Government Administration and Election Committee. My name is Damir Hasanovich. I'm a resident of Hartford. I'm testifying in support of SB 1158, an act designating various days, weeks, and months, specifically in the favor of item number 112 in the bill, the Bosnian Genocide Remembrance Day. I'm from Srebrenica, small town in eastern part of Bosnia and Herzegovina, located just few miles from Serbian border. I'm here to affirm the Srebrenica genocide because I'm amongst the ones that survived it. On July 11, 1995, Serbian forces occupied my city, forcing tens of thousands of women, children, men, and elderly to flee their homes in panic, contemplating how to save their lives. Majority of population fled to the United Nations Dutch battalion camp in Potocari, believing they would save them, but the camp could only accommodate few. So thousands of unarmed men, women, and children stayed around the base, including my parents, uncles, and many other close family members and friends. I was 22-year-old at the time. I hugged my parents goodbye and fled into the woods with thousands of other people. I never imagined that that would be my last time I hugged my father. Shortly after that, armed Serbian soldiers besieged the area of the Dutch camp, separating all men, including male children, from women, and later executing them, including my father. International Commission on Missing Persons, Bosnia, found some small percentage of my father's remains in secondary mass grave, Kozluk. This means that his body was relocated multiple times from one mass grave to another to hide his remains and any evidence of cruel and inhumane way he was killed. This removal practice is very well documented by the credible international source and proven at the International Hague Tribunal for former Yugoslavia. Same destiny befell many of my male family members and over 8,732 other men, only because they were not ethnic Serbs. Meanwhile, I was together with over 15,000 people, women and children in the mountains who walked 5 days to reach the safe territory in Tuzla. Many died in ambush and minefields. Some died from exhaustion and biochemical weapons which were fired at us. I thank God I managed to survive. Today, I ask of you all, please help us spread the truth about the horrific tragedy and the fight against constant genocide denial which we witness on a daily basis by Serbian officials. I ask Connecticut, my second home, to never forget Srebrenica so that it would never happen again to anyone. Thanks for giving me opportunity to speak.
Thank you for being here with us and for sharing your story.
Thank you.
See no questions from the committee. Next up is Olivia Scully, followed by Drake Ramke, followed by John Warburg. Ms. Scully, whenever you're ready.
Thank you, and good evening, Representative Blumenthal, Senator Flexer, and honorable members of the committee, and thank you for your stamina today. My name is Olivia Scully. I'm a resident of Middletown and librarian, and I'm testifying in support of House Bill 6829. Most of the folks that you've heard from today, the library folks, have been directors, administrators, and I fully agree with my colleagues regarding the impact that this bill will have on libraries to both save money and serve the community. I've worked in Connecticut libraries for almost 12 years, and until recently, I was a librarian working directly with the public, boots on the ground. We might have had 1 or 2 electronic copies of the latest James Patterson novel for our entire consortium to share, with a 6-month hold list to get through to make sure everyone could borrow that ebook. And I can't tell you the number of times I heard from patrons just abject frustration with the current state of digital borrowing. And I can completely relate to that frustration because I'm an avid reader, and more than that, for me, ebooks have been a lifeline. I am autistic. I'm still unpacking exactly what that means for me, but even though I have relatively low support needs, autism affects my everyday life, including something as simple as borrowing a book. For me, being autistic means sometimes it's a huge challenge for me to leave my home, to go borrow a physical book because there is just so much involved in that process. The planning involved, the sensory overload, the promise of social interaction. When I can, I love going to the library, but most of the time it's overwhelming to even think about it. So when I want to borrow a book, my first stop is always to check online. And I check the library because it's free and I'm on a budget. Library ebooks give me access to so much information and enjoyment that I just would not have otherwise. But libraries are also on a budget and they can't always afford to pay for the same breadth of ebook titles that they can put on the shelves. If they don't have a title available as an ebook, I usually just give up, even if a hard copy might be on the shelf or available to interlibrary loan. And if I do find something I want, I might have to wait 6 months before it gets to me. Every now and then I find exactly the title I want and it's available to borrow right now. And it's like striking gold. But normally the limitations of my library's ebook collection mean I can't keep up with the newest releases, the bestsellers, any up-to-the-minute books on current events, or even the latest books written by other adult autistic women that can help me better understand my own experiences. Easily borrowing such titles should not feel like a eureka diamond in the rough moment. And it is frustrating for me that I can't borrow ebooks with the same simplicity and abundance that other patrons have when they're hauling away tote bags full of hardcovers. Having that same level of access would be such a huge benefit for me and for others who face similar kinds of barriers. So I ask you to please support HB 6829 and help libraries to provide access to abundant digital collections for patrons like me. Thank you.
Thank you. Seeing no questions from the committee, we appreciate you being here to share your testimony.
Thank you.
Next up is Drake Ramke, followed by John Warburg, followed by Susan Alksness. We have Drake Ramke. Yep, there he is remotely. Mr. Ramke, whenever you wish, you can begin.
Absolutely. Thank you, co-chairs, vice chairs, ranking members, and esteemed members of the Government Administration and Elections Committee. My name is Drake Ramke. I am a former elections administrator from Colorado. I work nationally now with multiple groups to improve the voting process for all and strengthen our voting infrastructure. I also work with nonpartisan organizations and government entities and policymakers, election officials, and the public to help them understand how ranked choice voting works and why it is a good idea. Before I dive into my testimony, I just want to take a minute and recognize your incredible state and local election officials that continue to serve on the front lines to ensure all voters in Connecticut are enfranchised and have a great voting experience. Election officials are the guardians of our democracy, and ensuring that they have the resources and infrastructure that they need to serve the public is a crucial role as policymakers. I am expressing my support for Senate Bill 389, and the purpose of my testimony is to explain why now is the time to upgrade Connecticut's voting system in tandem with implementing ranked choice voting. And I submitted written testimony as well so that you can all dive into. First, Connecticut has some of the oldest voting equipment in the country. Currently, none of the jurisdictions have RCV capable equipment. Moreover, the current system does not produce records that are needed to effectively perform advanced post-election audits, like a risk limiting audit. Second, most modern systems all have the ability to conduct an RCV election today. So that's a great reason to start updating now. The current system is so old that you have to cannibalize secondhand machines to fix any issues with machinery breaking down. So it's very, very dangerous. Furthermore, I do believe that if the RFP process is completed, funds are allocated before June, and the system is purchased shortly therefore after, I do believe it can be tested and implemented before 2024. A new system will be extremely valuable when you implement early voting in March of 2024, which, as I understand it, is the earliest date on which the presidential preference primary in Connecticut could take place. Similar timelines have been rolled out for a statewide upgrade of voting systems very, very recently. Georgia, Vermont is a good example. So I do believe that we have enough time to get this implemented in the next 12 months. If you have any questions, I'm available for them, and my written testimony is also available. Thank you.
Thank you. Are there any questions from the committee? Seeing none, we thank you for your testimony. Oh, never mind. Representative Santiago, you are recognized.
Thank you. I wasn't quick enough to raise my hand, so thank you, Mr. Chairman. I just have a quick question for Mr. Ramke. I've heard most of the testimony with the ranked choice voting. I'm sorry, let me put my my video on. How do you, I mean, as you know, in the state of Connecticut, we have the Citizens Election Program. If you have ranked choice voting, how do you think that would intertwine with the Citizens Elections Program, especially if you might have 10, 12, 20 people running for a certain seat at the especially at the state level or even at the local level? How do you think that might be able to work with the ranked choice voting?
Well, I can't speak too much on the Citizens First portion that you were speaking on, but as far as the ranked choice voting goes, and please stop me if I'm not answering your question, but if you do have 10, 12, however many candidates, the ballot design is going to be extremely important because you want to be able to rank as many folks as you can. Some voting systems have limits, 3, 4, 5, others go up to 10 plus. So depending on who you pick as your next voting system vendor, I don't foresee any issues with the actual election process as it is. I don't know if that answered your question.
Well, not really. The Citizens Election Program is a program that we have in the state of Connecticut that I, as a candidate, can apply for a grant. If I raise $5,100 and get my 100 signatures from my district, I apply for a grant and I get $32,000 to run a campaign. But and that's what I'm talking about. So we do have that in the state of Connecticut. I am sure that there's not a lot of other states because I've been around the country at different conferences, and not a lot of states have that Citizens Election Program. Yes. So how do you think that might work when you have 10, 15, 20 people running as ranked choice voting and trying to get to that level in order for people to vote for them? I just don't see how that's going to work. Do you have any idea how it might work?
Off the top of my head, I want to say I'm from Denver, and we have a very similar program. So thank you for explaining that, the funds matching. Now, as far as how the election administration portion of this would run based off of the program that you have, I couldn't speak to how that would impact negatively or positively candidates at all, or for that matter, human nature on how people react to ads or anything like that. I strictly am coming at this from an election administration point. Mm-hmm. Any human, what's the word I'm looking for? How folks act and candidates act based on the program that you have is completely up to them. From an administration portion of running the election, there should be no difference at all, whether you have that program in place or not.
Oh, okay. I don't know. I think it might be a problem because if you are spending the funds to try to get elected and then you don't make it up to the first or the second choice, that means it kicks you off. So I don't know how the state, I don't know. I mean, that's one thing that nobody's talked about. And I'm just curious that how that program is going to run. We might have to get rid of it. I don't know. I'm just saying that whether there's going to be enough money there, or do you get 20 grants on one party and then another 20 grants to another party? And how is that going to affect if you don't make it to the first? And I mean, all those rules with the citizens election program are going to have to be changed. But I just thought that you might have an idea because I haven't heard anybody mentioning it, but thank
Right.
you.
Yeah, absolutely. And just the last thing I can say on that, if I do have time, is how the money is from this program is distributed to everybody, whether there's enough, too much, not enough. We'll have, as far as an election administration standpoint comes from, there will be no, it doesn't have any difference on how election administrators design the ballots, send the ballots out, count the ballots, audit the ballots. It just doesn't have any impact on it all.
Well, I tend to differ on that, but that's my opinion. But thank you for testifying today. And I think that's something that people that are supporting this ranked choice voting really got to think about, the citizens election program, and how do we proceed and mingle both for them? And is it going to be worth it whether you still keep it or you get rid of it? So thank you for coming. And I was in Colorado last summer, and I did see how Denver does their citizens elections. And I loved it because from what I saw was the way that you do the mail-in process, and you also have in-person voting. But at least what I learned was that 87% of the state, of citizens of the state, come out to vote. And that's something that really impressed me. And maybe somewhere along the line in the next, maybe, who knows, because Connecticut is always behind when it comes to voting. In the next maybe 15, 20 years might be something that we might emulate from Colorado, because and it took you a long time, I believe since 2006 or something, in the mid 2000s, in order to get that program running. But I think it was very impressive because I did see the citizens election centers and how the whole thing started from the beginning all the way to the voting and the transparency of the whole process. So thank you. Thank you for that.
Thank you very much. We're very proud of what we've done in Colorado. Thank you again.
All right, thank you for your testimony. I believe that's all the questions from the committee. And Representative Santiago, we're trying to turn around that land of steady habits thing. On this committee,
I know. Thank you, Mr. Chair.
All right, next up is John Warburg, followed by Susan Alexness, followed by Sarah Ganong. Mr. Warburg, I see you are joining us virtually. Whenever you're ready, you can proceed.
Thank you, Senator Blumenthal and the other members of the GA committee for hearing this bill. My name is John Warburg, and I live in Fairfield, and I'm testifying in support of HB 5701, or really in principle, any ranked choice voting bill. I know there are many important bills passing through the legislature, but I can't think of another piece of legislation right now that would have an impact as profound and far-reaching as that offered by ranked choice voting. Because until we change the way we elect our representatives, we will never see a meaningful change in the hyperpartisanship that is undermining our politics and government. And without a functional government that is more responsive to voters, it's hard to see how we will ever make significant progress on the broader issues we face. Political dysfunction may not be as bad in Connecticut as it is in Washington and elsewhere, but by adopting RCV in this state, we can not only start to fix our own broken election system, but we can serve as an important example for the rest of the country. Ultimately, the only way to reverse our democracy's decline is if our elected officials start to do the painstaking but critical work of reaching compromise on the issues that divide us. And this will only happen if we elect people who are willing and able to do this work. Unfortunately, our current system produces many election winners who do not truly represent the majority and do more to divide us than bring us together. Ranked choice voting, on the other hand, produces outcomes that are more representative of the true will of the voters. I'm not going to get into the reasons why. They've been spelled out plenty of times in this hearing. Instead, I'd like to just address a few comments made earlier by testifiers opposing RCV. First, the misconception that RCV violates the one person, one vote principle. It doesn't. With ranked choice voting, you can rank your preferences, but only one of them ultimately counts. So it's still one person, one vote. Second, this idea that RCV is too hard for voters to understand is simply not true. Instead of making one choice in a field of 3 candidates or more, how hard is it for people to rank their preferences? They don't have to. They can choose just one candidate if they want. But to suggest that it would be difficult for people to figure out how to express a simple 1, 2, 3 preference is wrong. We're making ranked choices in other aspects of our lives all the time. This is not a hard concept for people to understand. Indeed, most people welcome the opportunity to have a greater say in their elections. Yes, in the back-end processing of votes, RCV is more complicated, and it's harder for people to initially wrap their heads around that. But this is not a reason to dismiss it. We live in a complex world, and sometimes we have to accept a little more complexity in coming up with solutions to our problems. I imagine I'm probably running out of time, so I should probably leave it at that. But I hope this committee advances a ranked choice voting bill, and thank you for listening to my testimony.
Thank you. You're right on time. Appreciate your testimony. Are there any questions or comments from the committee? I'm not seeing any. So we will thank you for your testimony. Appreciate you being with us.
Thank you.
Next is Susan Alksness, and then followed by Sarah Ganong and John Flynn. Ms. Alksness, whenever you're ready, you can proceed.
Senator Flexer, Representative Blumenthal, ranking and distinguished members of the GAE committee. My name is Susan Alksness. I vote in New Haven, and I cast my ballots using an overseas ballot within my guaranteed right as a citizen to vote in federal elections. I'm a supporter of Voter Choice Connecticut, and I'm also an elected volunteer leader in Democrats Abroad, which is one of the 57 Democratic state parties. I'm testifying in favor of HB 5701 for ranked choice voting, and in addition to my written testimony. Election reform is important to me because we need to strengthen democracy now, giving people more faith that their votes matter. Ranked choice voting is a proven mechanism to help ensure candidates win with majority support. I agree with the many strong arguments being shared today in favor of ranked choice voting to strengthen our democracy. I focus my remarks on how ranked choice voting can reduce administrative burdens on local election officials and better enfranchise overseas voters. Every federal election, thousands of Connecticut voters cast their votes by overseas ballot. Any of the 339 different local election officers across the state may have to receive overseas registration and ballot requests from these voters, verify their status, send a ballot, and then receive and verify the ballot, often sent by email, but always sent with a required paper ballot, which overseas voters must send with ample time to arrive before the deadline. For some overseas voters living in locations with unreliable postal systems or limited access to package delivery services, this can mean sending in their ballots significantly earlier than Election Day. When there's an election with more than one candidate, often the case in primaries, which if held in a solid blue or red area, can effectively decide the general election results, early voters, including overseas voters, may have their votes wasted if their chosen candidate drops out before Election Day. When there's a runoff election, overseas voters and local election officials have to repeat the multi-step process to get their votes counted. With ranked choice voting, there wouldn't be runoff elections, saving local election officials and overseas voters from repeating these steps, replaced by a single, simple, easy to understand ballot, which will lead to election results that better reflect the majority of voters and strengthen democracy. In past years, I advocated for a bill to study RCV, and I'm so encouraged that this year 4 bills have been introduced to implement RCV. It's time for this must-have election reform in Connecticut, joining Maine and Alaska and many cities across the country who have successfully implemented RCV. Connecticut can do it too. I support adopting ranked choice voting for federal, state, and local elections in Connecticut and urge you to favorably vote HB 5701 out of the GAE committee. Thank you.
Thank you. Thank you for your testimony this evening. Seeing no questions or comments from members of the committee, thank you again. Next, we will hear from Sarah Ganong, who will be followed by John Flynn, who will be followed by Travis Woodward. Welcome, Sarah. The floor is yours.
Great. Thank you, Senator. Good to be here, and good evening to everyone on Zoom as well. Thanks for having this hearing today. My name is Sarah Ganong. I'm the state director of the Connecticut Working Families Party, have worked for WFP since 2017 and in electoral politics here in Connecticut since 2015. You heard from my colleague Lindsay Farrell earlier today, who articulated some of our organization's concerns around the implementation of ranked choice voting in Connecticut. Would urge you to refer to her written testimony for further details, but I'll speak briefly about ranked choice voting, as well as our support for universal voting and expanding voting rights to incarcerated individuals. As mentioned in previous testimony, WFP has a few serious concerns with the ranked choice voting proposals as laid out before us in these bills today. I want to encourage the committee to consider and address these concerns before moving any bills forward this session, particularly in light of the challenges we face with implementing early voting, hopefully this year, which is obviously an essential modernization of our voting system that really needs to go smoothly to benefit all of our state's voters. That reform was a hard-fought victory in Connecticut. Really couldn't be more excited about the potential for its implementation, but it's important for our state government and our voters to be focusing on that before we introduce new and more confusing concepts such as ranked choice. Obviously, resources spent on educating voters and on our election systems are never wasted, always important, but again, believe at the moment a focus on early voting has got to be the priority. Finally, as a minor party, WFP is also concerned about any ranked choice proposals that would compromise our powerful and effective fusion and cross-endorsement rules, which are pretty unique in the entire country. They encourage coalition building and partnerships among political parties and various constituencies, which is something that we've heard a lot of folks talk about today, and obviously is lacking in our nationwide politics and is a little bit unique in Connecticut. Supporting fusion voting rather than potentially marginalizing minor parties through a ranked choice system is the stronger approach our organization believes. Would remain open to discussion of ranked choice in potentially party primaries, for example, where fusion voting is not in play, but at this point believe that further discussion is needed before any proposals move forward. We are, however, really excited to support universal voting, such as put forward in HB 5717 and 5704. While we'd want to make sure that any fiscal penalties were avoided, as they're likely to be regressive, the rest of the concept is really exciting to be considering for our state. Universal voting could assist in developing an electorate that matches the makeup of our state and country. And obviously, these are initial proposals, but really excited to continue engaging in these conversations. And I think particularly intriguing are sort of other opportunities associated with universal voting for implementation to be successful. For instance, civic education, voter education would be necessary. Finally, we'll just briefly add on to partners supporting regarding the rights of incarcerated individuals to vote. We believe voting is a fundamental right in our democracy, and it should not be revoked due to someone's status, and that the felony disenfranchisement before us at our state now disproportionately harms Black and Brown communities. So encourage support of those bills as well. And thanks for your time on this late night, and happy to take any questions.
Thank you. Thank you for your time and your testimony this evening. Seeing no questions or comments from members of the committee, thank you again. Next, we will hear from John Flynn, who will be followed by Travis Woodward, who will be followed by Michael Savino.
Hello, can you hear me?
Welcome, John. The floor is yours. If you could please turn on your video function to testify, we would appreciate it.
It's on. Can you hear me?
I can hear you. I cannot see you.
Well, I got bumped 5-6 times, so I'd rather just do it without the video if it's okay.
Well, could you just put it on briefly at the beginning and then turn it off?
Put it on briefly at the beginning and then turn it off. Okay, it's on and off. Is that okay?
Just briefly enough so that we could actually see your face, and then you can turn it off if it works. There we go.
Matt knows me. Can you see me now?
No, I cannot.
Okay, sorry. I'm Johnny Flynn. I ran for U.S. Senate recently against Richard Blumenthal, and I am wholeheartedly agreeing with many of the things that you say, but I'd like you to hear me out because I think a lot of it is unrealistic. I think the ranked choice is a great idea, but it favors the working families of the Democratic Party in our case because the independents and the Republicans really don't get along. But if you look on my right here, I'm currently involved in a lawsuit about the 13 candidates who qualified in the last election and were never placed on the absentee ballot. The 13 candidates that qualified that were never placed on the election ballot. For example, I had 57,962 signatures. I brought them to Ada Carini, who spoke earlier. She rejected them on August 3rd. She rejected all of them on August 9th. And August 10th was the last day. What I gathered is that they didn't want me anywhere near the election. And so I initiated a lawsuit. There's 600 defendants. Every town clerk is being sued, every registrar of voters, and the entire staff of the Secretary of State. Why? Because all 13 candidates that were blocked from the ballot qualified through 7WW Executive Order of Lamont, which nobody knows about. And I did work for 4 years on that campaign. I spent a substantial amount of money. So when you're talking about being blocked with access to the ballot, okay, if you follow the rules, which were relaxed due to COVID, the governor signed a bill written by Kohler, who was the temporary Secretary of State. And Mr. Kohler worked for Blumenthal, had a conflict of interest, and Mr. Ted Bromley committed various felonies, which he is being sued for. But when you look at the information on the 2020 election, 20 states outside of Connecticut were hacked by Connecticut. Danbury, Connecticut hacked the state of Pennsylvania. Yes, Shelton hacked Michigan. Yes, these are swing states. Many of these states, Southington hacked Michigan also. Fairfield hacked 2 counties in Georgia. There's a huge database of the hack. We can prove who hacked who, when and where, how many votes were flipped. So we have issues we haven't addressed that, truthfully, I'm all for,
Thank you. I'm sorry for interrupting, but your time has elapsed. Can you please summarize?
Well, I would say if you really want the facts, you need to get on Twitter and follow me. So thanks for your time and effort. But a lot of this stuff you're talking about is completely moot if you can't even get on the ballot.
Thank you. Thank you very much for your time and your testimony this evening.
Very good. Thank you.
Next, we will hear from Travis Woodward, who will be followed by Michael Savino, who will be followed by Luther Weeks. Welcome, Travis.
Hi, good evening. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Master Francesco, and members of the Government Administration and Elections Committee. My name is Travis Woodward. I'm a resident of Hamden and an engineer for the Connecticut Department of Transportation. I'm also president of CSEA, SEIU Local 2001. You have my written testimony, so I'm going to shorten my spoken testimony just for time concerns. I would first like to thank the committee for raising SB 1157. The supervising judicial marshals employed by the judicial branch, the employees of the Disability Determination Services Unit within the Department of Aging and Disability Services, and the employees of the Bureau of Rehabilitation Services within the Department of Aging and Disability Services are members of CSEA. And this is a bill that is very important to them and our whole union family. They do critical work for the people of Connecticut, and I would never want that work to put them, their family, or their coworkers at risk because someone abused the FOIA process. These workers, along with the employees in the Attorney General's office, want to be added to the list of people whose residential address is blocked from release through the FOIA request. Currently, there are people in 13 groups whose residential addresses are exempted. These groups include police officers, firefighters, employees of the Department and Children of Families, members or employees of the Commission on Human Rights and Opportunities, and other people doing important work on behalf of the residents of Connecticut. Their safety and security concerns that lead these groups being exempted are the same for the people working as judicial marshals in the DDS unit, in BRS, and in the Attorney General's office. They are not asking for special treatment or trying to hide from accountability, but like other people whose addresses are exempted from release, they just want to be safe. Regarding Section 2 of the bill, right now in statute, if someone requests to inspect or copy the personnel, medical, or similar files of a state employee, the agency receiving this request, as long as the agency doesn't believe the disclosure of the records would constitute invasion of privacy provides the requested information. And after they do so, they inform the state employee as well as their collective bargaining representative whose information was requested. Section 2 does not block the release of this information, but it does provide state employees with some notice. Whatever the reason for the mass request, state employees deserve to know when their files are being inspected. I would also like to add that the State Employees Bargaining Agent Coalition supports this bill as well. Thank you for hearing my testimony. I urge you to support SB 1157.
Thank you. Thank you very much for your time and your testimony this evening. Seeing no questions or comments from members, thank you again for your time and your patience. Next, we will hear from Michael Savino, who will be followed by Luther Weeks, who will be followed by Kathy Callahan. Welcome, Michael. The floor is yours.
Thank you, Senator, and thanks for your long hours today on this public hearing and for the chance to testify. I'm testifying as president of the Connecticut Council on Freedom of Information, and I'm here to testify on two bills. We are in support of Senate Bill 1155, and we are opposed to Senate Bill 1153. We have submitted written testimony in both bills, so I'll just summarize them here quickly. With 1155, we support these updates to the Freedom of Information Act, particularly updating and modernizing the definition of the handheld scanner. The current definition applies to literally a handheld digital scanner, a device that a lot of people don't really carry on them anymore. Some towns have, on the advice of the FOI Commission, allowed cell phones, but we think that that should be the standard for everybody. Let people use the technology that is in their pocket to make copies of records, and let's bring this act into the 21st century. With 1153, we oppose this bill. We think that there are a lot of exemptions that exist already that can address some of the concerns that have been laid out, particularly around trade secrets, draft records, and other information that there are concerns whether or not that would get out with higher education research. But we think that these are important records that should be available to the public, whether or not the research produces anything, any patents or any other findings that are released publicly. This is research that's being done using public resources and public funds. We think it's important that people see what research is being done, leveraging these resources, the manner in which they're doing it, and also just from an educational standpoint, research is being done that is not finding conclusive results that also can have scientific values in terms of what we think we know and what we don't know. Maybe failures in this research that can lead to breakthroughs later on using different methods. So we think that these records should be public. So we urge you to reject that bill, and I welcome any questions.
Thank you. Thank you for your time and your testimony this evening. Seeing no questions or comments from members of the committee, thank you again for your time and your patience.
Thank you.
Next, we will hear from Luther Weeks, who will be followed by Kathleen Callahan, who will be followed by Kate Sheehan. Welcome, Luther. The floor is yours.
Chairs and members of the committee, my name is Luther Weeks from Glastonbury, a computer scientist, executive director of Connecticut Voters Count and the Connecticut Citizen Election Audit, and convener of the National State Audit Working Group. I am not opposed to the concept of risk limiting audits or ranked choice voting, but I am opposed to all 6 of these bills as they are insufficiently detailed. They also provide no guarantees of transparency. Both of these concepts involve detailed technical and computational issues. Neither are as simple as looking at marks on ballots and simply counting votes. Officials, candidates, and the public and the SCEC need to know exactly what is expected of officials so they can perform as expected and such that all can determine if they are doing what is required uniformly across the state. Just like we need paper ballots to avoid trusting voting machines and software, we need transparency to judge all the counting and calculating required. In both RCV and RLAs, the counting rule details are critical, especially in close contests where the result is dependent on the nuances of the rules. To understand the message used, we need detailed descriptions of the rules. We need to be sure software performs the detailed calculations accurately. For RCV, we need those details to verify the results and for manual recanvases and recounts. This also demands open source or at least disclosed source software. Any software used in calculation should be certified or extensively evaluated independently and rigorously to match rules encoded in law or regulations. Procedures alone are insufficient. To ensure that the calculations and counting are accurate, the public needs disclosure of cast vote records, ballot images, and access to actual ballots. While voting RCV may be understandable to voters, the calculation through rounds are nuanced in ways that must be carefully specified. How are write-ins handled? How are skipped choices handled? Overvoted choices, repeated choices, etc. RLAs and RCVs will be particularly difficult to manage and will likely take several days unless we centralize the counting and the presence of all the ballots in one or less than a handful of highly coordinated locations, like Maine has done. And I'll just mention that in my written testimony, I wrote 1151 when I really meant 1150 for the bill number. And then I'll say what I said 12 days ago here. I hope you'll read, and I hope everyone will read my written testimony, as you'll find it's unique and helpful. Thank you.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments, thanks again for your time and your patience this evening.
Okay.
Next, we will hear from Kathleen Callahan, followed by Kate Sheehan, followed by Susanna Bennett. Kathleen, welcome. The floor is yours.
Good evening, Honorable Chair Flexer and all other distinguished members of the GAE committee. My name is Kathleen Callahan, and I am a resident of Stratford. I'm voicing my strong support for HB 5702, an act allowing incarcerated individuals to vote. I've spoken before the committee over the past 4 years as Connecticut has continued to reform its voting system through changes to our state constitution. I have stated that voting is an inalienable right and that the most important civic duty of our state's residents. Participating in who will represent you at the local, state, and federal level is what makes this nation a democracy. Every individual has a fundamental constitutional right to vote, and I believe Connecticut must transition from restoration upon release to retention upon incarceration. Why is an individual disenfranchised due to incarceration? The punishment for a crime is the conviction, sentence, and incarceration. Basic rights such as due process, freedom of speech, freedom of religion, along with other protected rights remain, and the core right of democracy, the right to vote, should be retained. 2 years ago, we joined 10 other states and ended the practice of prison gerrymandering. When Governor Lamont signed Public Act 2113 into law, he said, quite frankly, that practice was an artificial relic designed to discount, disvalue, and disenfranchise the voices and votes of people of color, whom the criminal justice system has repeatedly failed. This was an important step forward for Connecticut. Incarceration has had devastating impacts on Black and Brown communities, and appropriate representation no doubt helps. We know that racial injustices and inequities persist, though, and that those in our correctional facilities are disproportionately coming from those same communities. The voices and votes of people of color are still discounted, disvalued, and disenfranchised. While someone now has their home residence counted, they still don't have their vote counted. They have no say on things that directly impact their community, and if they are parents, the lives of their children and grandchildren, school funding, public safety, healthcare, housing, policing, and more. They have lost a key connection to the community, the civic engagement that voting brings and could help reduce recidivism. I supported 3 days of virtual trainings last week with another state's correctional system. A correctional officer remarked that we are all just one bad decision away from being the one incarcerated. And remembering that helps him treat people with respect and dignity while maintaining his own. That reminded me of something I said before the Judiciary Committee in 2018, testifying for SB 13, an act concerning fair treatment of incarcerated women. While I have not been incarcerated, I believe that those that are doing my time. And from my view, they are doing the time for many, many people. Connecticut has been a leader in the criminal justice reform. We are moving forward with voting and election reform. This bill helps expand and elevate our priority on the full democratic process. I urge you to overturn the practice of severing the basic right that provides humanity and connection to the community for those inside our correctional facilities and support passage of HB 5702. With respect and gratitude for your time.
Wow, nice timing. Thank you. Thank you very much for your time and your testimony and your patience this evening.
Thank you for all your work.
Next, we will hear from Kate Sheehan, followed by Susanna Bennett, followed by Joseph McDougald. Kate, welcome. The floor is yours.
Hi, thank you. Thank you for everybody for staying and for listening to everybody's testimony. I'm the head of IT at Stratford Library, and I'm a Trumbull resident, and I am here in support of HB 6829. Libraries, as you've heard from all of my colleagues, have always purchased materials in a variety of formats. We've purchased books as hardcover, paperback, on tape, then on CD, playaways, large print. At first, digital books are more of the same. At first blush. However, they are more than just a new format. When we buy physical materials, we do so at a discount from retail pricing from a variety of library vendors. With ebooks, we must purchase a platform for circulation, then buy the ebooks from the vendor that makes the platform. They are less book than software, coming with licensing agreements that preclude true ownership. We can lend them only to those who hold cards in our libraries, in our specific libraries, circumventing the statewide reciprocity that allows Connecticut residents to use libraries throughout. Most distressingly, the prices are significantly higher than retail and the books expire. Management of a physical collection is both science and art. Print books can be repaired, replacements can be managed on a budget based on budget and popularity of a title or subject. Ebooks and e-audiobooks vanish on a predetermined schedule and must be repurchased at the same high price to be kept in the collection. There's no way to build a rich, deep collection for our patrons. The cost is higher for a lower value format. As with any technology, ebooks and e-audiobook pricing has changed over the years. However, unlike any other format, the terms have gotten much worse for libraries. Prices have gone up and publishers have increasingly adopted the expiring ebook ever since HarperCollins pioneered the practice in 2011. We can buy fewer and fewer ebooks for increasingly long wait lists. Ebook use grew steadily in the 2010s and then exploded with the pandemic. Ebooks offer accessibility features like custom fonts or larger print size that are impossible or expensive to replicate in print. Readers who can't hold a hefty large print volume can wield a lightweight tablet or e-reader and get a wider variety of titles. Ebooks are going to continue to be popular, and libraries need a sustainable and equitable way to buy them. I've worked at public libraries throughout Connecticut over the past almost 20 years. 201, my colleagues take their role as stewards of public funds to heart. We support authors who aren't making any more money off of these more expensive ebooks and would make more money if we could buy more of them. And we want our communities to have equitable access to materials in as many formats as possible. We want ebooks for the retirees who devour a book or two a week and are delighted to use their library's ebook collections, for families embarking on road trips who use ebooks to quell backseat complaints, e-audiobooks to quell backseat complaints and bond over favorite stories, and for reluctant readers who use the dyslexic font to read aloud features on tablets to spark a love of the written word. We need your help to meet the needs of our patrons. For the past 10 plus years, librarians have been told we have to demand a seat at the table to negotiate with publishers. I've heard that over and over and over again as I followed this issue. And this is how we're going to do it. The current terms are unfair to libraries, authors, readers, and all Connecticut taxpayers. Please support House Bill 6829. Thank you.
Thank you. Thank you for your time and your testimony. And seeing no comments or questions, thank you again for your time and your patience. Next, we will hear from Susanna Bennett, followed by Joseph McDougald, followed by John Selders. Susanna, welcome. The floor is yours.
Thank you so much, and thank you for hearing my testimony. Members of the GAE committee, I am excited to testify in strong opposition to HB 5704 and 5717, two bills concerning mandatory voting. I'm sure we all agree that 100% voter participation is a wonderful goal, and I certainly agree with that. But a worthy goal does not justify an unworthy means, and it's the means that I'm concerned about. The heart of the issue, as I see it, is that mandatory voting strikes at the core of liberty. Liberty is a gift from God. It's not a gift from the government to the people. Liberty is intrinsic within our nature as human beings who are created by God. Like him, we're free agents with a will to choose. And you cannot force a free citizen to enjoy the blessings of liberty and still call him a free citizen, because to force a free human being to make a particular choice is to remove his ability to choose. I take particular issue with the third clause of HB 5704 that says any elector who did not cast a ballot shall give a valid reason or be fined for not responding. And with all due respect, I say in reply, absolutely not. The fact that I am free is the valid reason not to cast a ballot. Now, we still have the question of how to increase civic engagement, which is the goal that we're trying to achieve. So I'd like to give you a positive example of this, not through coercion, but through inspiration. Years ago, my father heard some lectures and realized that he didn't even know who his elected representatives were. So he started to educate himself because he had caught sight both of the liberty that was his and the carelessness with which he was holding it. So he got involved at a local level, and he raised our family in a culture of exercising both the privileges and responsibilities of freedom. And not only has our own family exercised and valued our own freedoms because of my dad, but we have become leaders in teaching others to do the same. So it's an organic, peer-to-peer and freedom-loving and freedom-honoring way to do that. We have increased the civic engagement of our friends and family, and it literally started with one man, my father. The alternative to coercion is loving and exercising one's own liberty and inspiring others to do the same. Mandatory voting may claim to be for the greater good, but I would argue that liberty itself is the greater good, that we should never pay any price that desecrates the treasure of liberty. Please oppose HB 5704 and 5717. Thank you.
Thank you. Thank you for your time and your testimony. Seeing no questions, thank you again for your time and your patience. Next, we will hear from Joseph McDougall, who will be followed by John Selders, who will be followed by Mubera Besirovic. Joseph, welcome. The floor is yours.
Thank you so much. Thank you, co-chairs, and thank you for staying with us so late so I can help back clean up on this hearing. I'm here to speak in favor of SB 1153. My name is Joe McDougall. In my day job, I'm a professor in residence and executive director for the Center for Energy and Environmental Law at the University of Connecticut School of Law. I'm also a member of CERCA. However, I'm not really even here in any official capacity, but my personal interest in seeing our state support and thrive in a key area, climate science and policy development. Our state and citizens spend a great deal of money on public education research institutions. In return, they expect the graduates of those schools who return to the state in large numbers can address the most controversial and difficult challenges of our time to help Connecticut thrive. Further, we expect that the faculty that we employ to be in a position to engage and offer their expertise back to the state. The legislature has funded and created several ways for in which the university is to assist and support the state to address some of the largest challenges that we face, specifically climate change, sea level rise, and storm preparedness. The areas that earlier testimony have shown have fallen under the attack, under weaponized attack, and have discouraged those STEM faculty through FOIA. I'm also a former elected official in my hometown of Madison. I served as a selectman during Hurricanes Irene and Sandy. At that time, it was widely recognized by this body that to protect Connecticut from climate change and to form responsible climate policy, given the nature of our small towns and no county structure, we needed to mobilize the power and research of the state universities to help us survive. The solution endorsed by this body was to bring our state educational institutions, the towns, and the agencies together to address the crisis. We have groups to prepare our towns for the challenges of sea level rise in Public Act 1882. We have entire sections where UConn professors are assisting with storm preparedness and grid stability. Academics throughout the university work with create issues they bring to towns, working on areas through environmental justice, through climate modeling, through agriculture. The weaponized use of FOIA and other efforts run counter to the intent of having the university engage in public work. As you've heard from Lauren Kurtz, there's a national trend to slow the academic process and to frustrate it, also a trend in states to address this problem. Our state schools offer incredible opportunities to leverage the academic municipal state connection. That work is all done in the public. Academics write and speak and teach in public. Our structure encourages more engagement, more work in public, yet the use of forces to distract or disdain or discourage the public participation run against what this legislature has been putting in place for years. I support this bill as it encourages Connecticut to join states like Rhode Island, Maryland, and New Jersey that have all changed their statutes to try and protect and encourage the investment that we make in public academic research. Thank you.
Thank you. Thank you for your time and your testimony this evening. Seeing no questions or comments, so Representative Parker.
Thank you, Senator.
Or if it was Michael Parker, it's just Parker.
Thank you. I just wanted to thank Joe, one of my constituents, for being here with us and for all the work that you do for our community, but also for the whole state. And we really appreciate your testimony today in terms of supporting the work that academics can do to help life in Connecticut. So thank you. And thank you, Madam Chair, for the opportunity.
Thank you, Representative.
Thank you. All right. Thank you again for your time and your testimony and your patience this evening. Next, we will hear from John Selders, who will be followed by Mubera Bersarovic. And again, if I've said your name wrong, as you've heard all day, please correct me. I apologize. And who will be followed by Donald Doeg. Is John here? John is not here. All right. Mubera, who will be followed by Donald Doeg. Welcome. The floor is yours. Okay, how are you? I'm hungry, if I'm being honest.
Thanks everyone also for hanging in here. So, dear Chair Senator Flexer, Representative Blumenthal, and the other esteemed members of the Government Administration and Elections Committee, many thanks to all of you for your collective bipartisan cognizance and leadership on the many issues being deliberated on today. It really is affirming being in this forum. My name is Mubera Bečirović. I am a voter and resident of the town of Wethersfield, but I spent many of my formative years growing up in Hartford South End, where we were welcomed in the August of 1999, when my family and I, along with them, were admitted to this country as refugees pursuant to Section 207 of the Immigration and Nationality Act. Since then, we have lived, studied, and worked in the state of Connecticut. Today, I will be testifying in support of SB 1158, item number 112, which asks all of you to proclaim July 11th of each year as Bosnian Genocide Remembrance Day to remember the more than 8,000 Bosnian men, boys, and other civilians who were killed for their faith and ethnicity in the municipality of Srebrenica during the war and aggression against the then newly independent country of Bosnia and Herzegovina. We survived to tell the story, we all have, and this forum is playing a role in that telling. I preface this next part of my testimony by assuring you all that it is not my intention to patronize this committee with a history lesson. All of what's been shared today, what I will share, has been lived and published and recognized by international courts, the US Congress, human rights organizations, and dozens of national governments. My intention is simply to remember, articulate, and express as an iteration of bearing witness, to honor the victims, to preserve the historical record, derive some sense of healing if possible, and as well a sense of efficacy. So the war and aggression against Bosnia and Herzegovina lasted from 1992 to 1995, culminating with the Srebrenica genocide that commenced on July 11th of 1995. By death toll, Srebrenica was the most violent episode of genocide perpetrated in the country during the war. Srebrenica was the culmination, as I have already said, of a campaign of genocidal intent, war crimes, crimes against humanity, torture, forcible deportation, mass rape, and other violations of the laws and customs of war. Before Srebrenica, the stated atrocities were perpetrated in municipalities across Bosnia and Herzegovina, including Prijedor, Gorazde, Foča, Višegrad, and the country's capital of Sarajevo, that was besieged and bombarded for 4 years. The longest siege of a city in modern European history, during which nearly 14,000 people were killed by shelling and sniper attacks. Samantha Power, former US ambassador to the United Nations and current administrator of the US Agency on International Development, was in Sarajevo during its siege as a journalist. And she writes extensively about what she saw in her book, A Problem from Hell, America and the Age of Genocide. The International Criminal Tribunal for the former Yugoslavia, as well as the International Court of Justice, determined that genocide was perpetrated in Srebrenica. Srebrenica remains the only perpetration of genocide in Europe since the Holocaust. A perspective or superlative, if you wish, I hesitate to draw, but which is undeniably relevant. And I know my time has elapsed, but if you will bear with me for another minute. I want to draw one final distinction before I move on to the personal details of my testimony. You may hear or read the terms ethnic cleansing or massacre supplanted for the term genocide. I urge you to refute such semantic diversion that amounts to nothing less than gaslighting. Genocide in Srebrenica is an internationally adjudicated case. The case is closed. Let us not be distracted by cynicism so that we may do our real work. To vote in favor of this bill is simply to endorse human rights law, justice, and love for one's neighbor. Thousands of Bosnians live, study, and work in districts throughout the state. Only a small fraction of us are in this room. You all are looking at the members of the second largest diaspora community in the world by share size, behind only Guyana. I know it is common and merited that we appeal to the triumphs of Bosnians who contribute to our state as doctors, pharmacists, teachers, lawyers, and small business owners and engineers. But I want to also affirm.
Hubert, I'm so sorry to interrupt you,
Yeah.
but I have to treat everybody the same. Can
Got
you
you.
please summarize?
I will summarize.
Thank you.
But I also want to lift up all of the blue collar custodians of the schools your children attend and the offices in which you all work, including this very building. So as citizens of this country, we understand the importance of engaging with the legislative process and what an inimitable freedom it is to advocate and engage without fear and harm. This is how we heal through community and advocacy. That is how liberation has always worked. We do not ask for dramatic expressions of moral shock and solidarity. We only ask that you invest the time to read the testimonies that have been submitted, many of which have been submitted by people who are engaging in the process for the very first time. We have faith in the legislative process and we have faith in all of you. Please advance SB 1158. Thank you for your time.
Thank you. Thank you for your time and your testimony and your patience today. Seeing no questions or comments, thank you again. Next, we will hear from Donald Doeg, who will be followed by Jose Gonzalez, who will be followed by James Burrell. Donald, welcome. The floor is yours.
Thank you. Good evening, Senator Flexer, Representative Blumenthal, and distinguished members of the GAE committee. Thank you for the opportunity to address you this evening. My name is Donald Doeg. I am testifying on behalf of the American Council of Engineering Companies of Connecticut, commonly known as ACEC. ACEC is in opposition to the adoption of Raise Bill 6826, an act concerning false and fraudulent claims, which essentially is the State False Claims Act. I know you've heard lots of testimony over the course of today from other members of the construction industry opposing the bill. I've also submitted written testimony about this. And so in the interest of time, I'll just try to summarize a couple of the key issues that I'd like you to consider, and hopefully you can read my testimony as well. As I will elaborate upon in a moment, the bill contemplates a universe in which there are absolutes. An act or submission is either false or it's not. Unfortunately, in the construction industry, that's not always the case and or easily determined. Thus, this proposed bill could cause significant risk to those in the construction industry, even if they've acted in good faith. And that's causes significant angst among them. One of the key issues is the vagaries of the proposed bill. Some of the legal terms and requirements are defined broadly and could be interpreted broadly as well by the courts. I'm an attorney, I've been doing it for 30 years, and I'm looking at some of the language and I can see it being twisted. For instance, while it's a false claims bill, the term false, which is pivotal to the bill, is not defined. Webster's dictionary defines false as not true, which sort of implies there's a bright line between the two terms. In the engineering and construction industry, there are often many issues that are not completely black and white. Experts can differ, and they have different issues about technical or detailed issues, and parties rely upon other experts' good faith opinions. In section 2, just starting off the bill, section 2A1, it says knowingly present or cause to present a false or fraudulent claim for payment or approval. Well, according to the definitions, a claim can be any demand for payment, request for payment, which would be a payment application. Under the language of this bill, it could be interpreted as if somebody submits a payment application that has a math error on it, that would be false. It's not true. And so therefore they're submitting a false claim. I don't think that's what the bill's determined, but that's the way the language right now could be interpreted. In the construction industry, it's often that there are percentage complete is part of the bill. People reasonably differ upon how much of the project's percentage complete. Is it 68%? Is it 71%? Just because there's a submission in good faith, that could be interpreted as a false claim that somebody else decides that it's something different. For change orders, normally there's multiple ways to do a project and there's different costs associated with different ways to do a change order. Just because there's a submission that ultimately the state pays something less than that, does that mean the initial submission, which was higher, is a false claims, even if it's in good faith? It's all a very scary premise for the people doing work in the construction industry. And for that reason, especially given the large damages that could arise between fines and treble damages and cost of attorney's fees, there's a very high risk to those doing business in the state, with the state, for a lot of construction entities, both design professionals and construction entities. And so for that reason, ACEC and many of the construction folks, construction industry entities, request that this bill be rejected. Thank you very much for your time. I think I'm out of time, but I welcome any questions.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from members of the committee, thank you again for your patience and your time today.
Thank you very much.
Next is Jose Gonzalez, who I don't believe has joined us. So then it's James Burrill, who will be followed by Shelby Henderson, who will be followed by Martin Wiosna. James Burrell, welcome. The floor is yours.
Thank you. I'd like to thank Senator Flexer, Representative Blumenthal, Ranking Members Sampson and Master Francesco, and distinguished members of the Government Administration and Elections Committee. I'm sorry I couldn't be there with you today. In fact, I was in the room with you for 6.5 hours today, but I had to run off to a wake for a family friend. So I'm glad I was able to get back in time to offer my testimony via Zoom. I'm here today to oppose House Bill 5702, an act allowing incarcerated individuals to vote. I believe that everyone here today would agree that one of the main goals of and responsibilities of the government is to protect the rights of law-abiding citizens. You know, in my opinion, I believe it's wrong to expand voting rights to convicted criminals who have violated our laws and our Constitution. These individuals have inflicted injury on law-abiding citizens, and as a result of their actions, they may have lost rights to certain freedoms. I know laws are different across the country in different states, but some of these losses of rights could include, you know, losing the ability to serve on a jury or prevent them from being employed in certain fields or being allowed to bear arms or own guns. Also being able to travel freely between states or countries, or being incarcerated, which is the total loss of freedom itself. I believe we should focus less on expanding the rights of convicted felons and concentrate more on the rights of law-abiding citizens 18 years and older when conferring voting rights. So I would ask you to oppose HB 5702, and I thank you for your consideration.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments, thank you again for your time and your
Thank you
patience.
for the opportunity to testify.
Next, we will hear from Shelby Henderson, Martin Wianosa. I don't believe either one of them are here. Aaron Good. Aaron Good. Welcome, Aaron. The floor is yours.
Thank you, Madam Chair and remaining committee members. On SJ 35, pre-registration, my group, New Haven Votes Coalition, goes into all 9 high schools in New Haven to register new voters. Every time we're at Hill House or Wilbur Cross, we end up handing out voter registration forms to juniors and seniors who are very excited to register, but they turn 18 just after Election Day. So we can't do anything but leave them the form and hope maybe they'll remember to send it in after the election, but knowing that they probably won't remember because life is full of distractions. And that's very frustrating for us and a disservice to the students. 15 states allow pre-registration of 16-year-olds. There's no red versus blue partisan tilt about the states that do this, which includes Louisiana, Florida, North Carolina, and Utah. The primary benefit of pre-registration is that students getting their driver's license or state ID at 16 can be entered into the system through AVR, but it goes beyond that. Many students start taking civics classes at 16, and New Haven juniors become eligible to serve as student reps on the Board of Ed at 16. That's when many students start developing a civic awareness and before they start being distracted by going to college or getting a job. 16 to 17 is a sweet spot to get them pre-registered to vote. According to National Civic Center, states that offer pre-registration have twice as many 18-year-olds on the voter rolls as states that don't, and higher 18-year-old turnout as well. On ranked choice voting, I want to address two issues about constitutionality because I think there's confusion even among proponents. The argument that ranked choice violates the one person, one vote doctrine of Baker v. Carr has been tested in federal and state courts, completely rejected in every case going back to Stevenson v. Ann Arbor in 1975. So we have 50 years of precedent on that. More serious concern is that our state constitution does have language in Article 3, Section 7 and Article 4, Section 4 about winners of state contests being determined by the greatest number of votes. Now, there's considerable debate about the legislature's discretion to determine what that means. Some people erroneously want you to believe it means ranked choice is completely incompatible with the Constitution. First of all, that disputed language doesn't apply to local races, federal races, or primaries. And secondly, the only case law on this, if you can even call it that, given that it's an advisory opinion, is from the Maine Supreme Judicial Court, which interpreted similar language about highest or greatest number of votes as a requirement for plurality voting. That interpretation is controversial. Many scholars believe it's unduly restrictive. Our courts are under no obligation to adopt it, and it would only apply to a limited subset of elections anyway. But I'd urge you to look at the article by Professors Pildes and Parsons in the October 2021 California Law Review for a comprehensive and nuanced look at this issue that bears on which RCV bill has the path of least resistance and how broadly RCV can be applied in Connecticut without constitutional amendment. On risk limiting audits, I concur with the testimony of verified voting that 1150 is a step forward, but as written, the data transparency, inspection, and noticing requirements
Excuse me, sir,
could
if you
be
could
strengthened.
just wrap up your testimony, your time has expired.
Yes, of course. More transparency translates to more public buy-in and it costs nothing. And finally, to avoid losing my New Haven street cred, I want to voice support for the pizza bill. Go modern. Thank you and good night.
Wow, bring in the heat, controversial opinions on here. Sir, you better be ready to stick with those opinions because this is public record right here. So I can't make any promises for how people will react to that. Anyway, thank you for your testimony. I do not see any questions from members of the committee. Seeing none, we appreciate you being here and contributing your testimony to our public hearing tonight. Next up is Alma Hurek, followed by James Jeter, followed by Ernest Francis. Ms. Hurek, are you with us? Do not see you. Mr. Jeter, you are up.
Thank you. And thank you to the distinguished members of GAE, to the co-chairs, Rep. Blumenthal and Senator Flexer. I want to start this. I've submitted testimony, so I'm not going to get into that testimony. What I would like to talk about is something that have been framed that make our state great. And one of them is the Great Compromise of 1777. You know, Senator Ellsworth and Senator Sherman brought this nation together, was many believe to save the actual structure of our democracy. But what's not talked about is in that very language, the Black enslaved population of this country was referred to as revenue producers and 3/5 of the population. Those ideologies have been embedded in the structure of our government since. In 1865, Connecticut, having already abolished slavery yet denying the right to vote in 1848, doubled down in a ballot initiative to change our state constitution to include Blacks and change language from whites only voting. All but Windham County voted against the ballot initiative. The New York Times reported that Connecticut, for no other reason, not a reason of morality or intellectual capacity, simply because of the fact that they are Black, has denied the right to vote. This has been an issue that we have doubled down on. This is not a question of the chicken or the egg. This is simply disenfranchisement has preceded all criminal activity. Our communities are comprised. I submitted some mapping, simple mapping that we were able to partner with the Prison Policy Initiative on looking at where people in Connecticut who go to prison come from. And if you look at the density of incarcerated neighborhoods, they also overlap with HUD data on low labor market index, low school proficiencies, high housing burdens, low wealth. These communities but these are policy issues. These are issues of a people. But we make this so often issues of a people without saying it, as if the character and the value of the people remove them from government, remove them from the processes. No, we've been removed from the process. The Citizen Project is documenting the 50th year of mass incarceration. It isn't by coincidence that it comes right on the heels of a Voting Rights Act. We've never had a chance to wrestle with the structure and ideology and theory of democracy. It's been destabilized in our communities to the point now where we are opting out. And it is not a freedom that we opt out by, as Senator Simpson said that he's protecting 50% of people who didn't vote. We don't vote because we don't believe anymore, because our homes have been broken. We heard a young lady testify about how just having her father involved in the process turned her home around. But we know that through mass incarceration, many of fathers are removed from the home. The disjointedness of our communities has led to mass disengagement. Our communities have less than 50% turnouts in many of them. And I'm gonna end just by saying that I know that this is a hard bill, but it's also the right bill. Like, we have to start undoing the embedded racism in our system. It's not about an individual, it's about the processes that created this. Thank you.
Well, thank you, Mr. Jeter. It's always enlightening and impactful when we have you here to testify. And we appreciate you being here and sticking it out till the bitter end.
Thank you.
Any questions from the committee? Yep. Representative Parker.
Just to say thank you, Mr. Jeter. I appreciate what you shared. Your passionate testimony means a lot. Thank you.
Thank you.
All right. Next up is Ernest Francis, followed by Joan Andrews, followed by Faith Ham. Is Mr. Francis with us?
Right here.
Oh, there you go. Sorry. I'm looking at my screen. All right. Whenever you're ready, you can begin.
All right. Good morning, Representative Blumenthal, Senator Flexer, and Representative Parker, and distinguished members of the committee. May it please the board, I'm a member of the Full Citizen Coalition, and I'm here to testify in favor of House Bill 5207. Recently, I was discharged from the Department of Corrections after serving 33 years in prison. I stand today in support of an act allowing incarcerated individuals the right to vote. At the outset, it should be noted that Connecticut was one of the first states in the union to adopt the public defender system to protect the rights of criminal defendants. Yet it falls behind in assuring that these same citizens are given the right to vote in our elections. The right to vote fits squarely within our system of jurisprudence. True rehabilitation requires incarcerated persons to learn how to function politically in our social fabric, to feel what it truly means to be a member of the social contract, contributing side by side in the growth of our society by exercising their civil rights. Failing to give incarcerated persons the right to vote not only disenfranchises an underclass, but isolates and re-victimizes citizens who were unable to benefit in the past from our educational system. Today, there are hundreds of unconvicted citizens housed in correctional facilities like Hartford Correctional Bridgeport Correctional and the Walker Correctional Institution, who have the right to vote but are being denied the opportunity to exercise this right, merely because they're housed behind concrete structures. Think of what this means to the future of Connecticut, the Constitution state. Can we really continue to be touted as a Constitution state where states like Maine and Vermont have consistently facilitated voting from their prisons with absentee ballots? The right to vote is a fundamental right that should be extended to all citizens, especially those that we hope to embrace upon release. It is imperative that we give all of our citizens the tools that they need in order to be contributing members of society. Failure to do so only creates a hardened population dedicated to living outside the Leviathan. So I urge this committee to pass 5207 to give incarcerated persons the right to vote. And I'll take questions if any questions.
Thank you very much. Are there any questions from the committee? Just going to check the Zoom. Seeing none, thank you very much for being with us tonight, Mr. Francis, and for waiting it out, being patient with us. Next up is Joan Andrews, followed by Faith Ham, followed by Ivelisse Correa. So Ms. Andrews, whenever you're ready, you can unmute yourself and begin.
Thank you and good evening, co-chairs, Senator Flexer and Representative Blumenthal and other distinguished committee members. Thank you for still being here. It's after 8 o'clock at night, and I'm sure you've been at it for 9 hours. I am the president of the Association of Connecticut Assistant Attorneys General. We are a union of assistant attorneys general. I have about 180 members, several of whom had submitted written testimony or dropped off during the course of the day because they had other obligations at night. So I will try to sum up some of their stories. We are here in support of Senate Bill 1157, an act concerning revision to the Freedom of Information Act concerning employees of public agencies. We have had similar bills proposed for the last couple of years. We are a group that is the civil litigators for the state. And unfortunately, that sometimes means contentious litigation, and it sometimes means we have had employees who've had grievance complaints, harassment, stalking, unfortunately, death threats, and other things that you would hope somebody wouldn't be faced with for simply doing their job and doing their job effectively. People shouldn't worry for the safety of their family because of what they do for work. Our work representing the state in litigation is exciting, inspiring, challenging, and although it shouldn't be, it is sometimes dangerous because of the reactions it provokes in people. Just as a few examples, we had an assistant attorney general in our child support unit receive a death threat because an obligor who was ordered to pay child support didn't feel that his case was fair. That AG has children and ordered them not to open the door from their home to anyone. That AAG worked side by side with a support enforcement officer who also received a death threat, but whose home address is protected from disclosure because he's an employee of the judicial branch. The distinction that for people that work together really doesn't make sense. We have AAGs in our child protection unit whose addresses would not be protected from disclosure, but their client agencies, the Department of Children and Family, are. We stand in court and represent the folks from these client agencies. Our names go on the pleadings, our work emails, our work addresses, and our phone numbers. So in terms of accountability, it's all there. We're very publicly accountable. We're very publicly named in all of those pleadings. We similarly have assistant attorneys general in the public safety unit who represent the Department of Corrections, represent prosecutors, public defenders, all of whom have their addresses protected by Connecticut General Statutes 1-217. Yet the AAGs who represent them in court, when they are sued,
I'm sorry,
are not.
But your
Did I
time
make
has
3
elapsed.
minutes?
If you could just summarize the remainder of your testimony, please.
Sure, I think you get the idea, but it's as a matter of, it just simply doesn't make sense that the clients that we represent have their addresses protected and we don't. So we are hoping, and I understand there's some commentary that this is, it's an illusory protection, but the voter records, the tax records that are essentially municipal records, our employer doesn't have to point someone who's looking to harass or intimidate an AAG to the municipality where they reside. And we believe that where we live simply has no bearing on the work that we do. Thank you for your time. I'd be happy to answer any questions you might have.
Thank you very much, Ms. Andrews. Are there any questions from the committee? Seeing none, I appreciate you being here to testify and sharing the stories of the AAGs you represent.
Thank you very much.
Next up is Faith Ham, followed by Ivelisse Correa.
Thank you
Oh, there
all.
we go.
Yep,
If you could,
thank you all for allowing me to come
on
back in.
Camera, if possible.
Yes,
Thank you.
sorry. Hope that helps. Anyway, are we good?
Good to go.
Okay, thank you. My name is Faith Ham, and I live in Cheshire, and I'm a Connecticut native, and I speak to you simply as a citizen of the state and a taxpayer. I can sum up my positions on HB, or my single position on HB 5714, 5705, and 5701 in 4 words. Please don't do it. On 5714, HB 5714, and I don't mean to be flippant here, but given the rising crime rates in the state, the prospect of losing one's right to vote appears not to be a top concern for criminals. And I hate to say it. A felon loses many basic rights upon his or her conviction: assembly, speech, the right to bear arms. Are we going to restore any of those rights to the incarcerated? A loss of rights is a consequence of taking an innocent citizen's property, security, health, and in unfortunate cases, their lives. I hope that all prisoners in the state receive the counseling, education, and training needed to restore them to be productive and engaged and voting citizens upon completion of their sentences, but not until then. On HB 5705, to not vote is a vote in itself. One of the lead sponsors of this bill recently argued in CT Mirror that Connecticut makes people pay for taxes. So why shouldn't the state compel citizens to vote? Yes, some voters shirk the responsibility, but others think long and hard about candidates and decide they can't support any of them. It's their choice. It's their right. I find it alarming that legislators supporting this measure don't know the difference between laws and rights. Taxes and jury duty are laws we're expected to abide by, laws that carry penalties when broken. But voting is a right, and last I looked, we still have the option to exercise it any way we choose. In the last presidential election, more than 7 out of 10 voters turned out to cast ballots. The turnout slumped in the most recent election. Perhaps the paucity of fresh candidates and innovative ideas turned off voters. Here's the solution. Let's enact term limits and give the electorate a reason to come out and vote. Finally, 5701, the U.S. is built on the concept of one person, one vote in general elections. If the objective is to increase voter participation, open primaries to allow independents and unaffiliated voters to participate, as a dozen states now do. Every jurisdiction where RCV has become law, and I have family in Maine, and have seen this firsthand, has seen legitimate winners, those garnering the most votes, denied their seats. What's worse, RCV grants to the state the power to disenfranchise all those who cast ballots for the legitimate winners in the first place. HB 5701.
Excuse me, ma'am. Sorry to interrupt, but your time's elapsed. So if you could please briefly summarize the remainder.
I just want to say, this is the system that gave you Bill Clinton, Barack Obama, Ella Grasso, Daniel Malloy, Ned Lamont. Why would you want to change the game now? I urge you to vote no. Thank you very much for your time.
Thank you, Ms. Ham. Are there any questions from the committee? Seeing none, we thank you for bearing with us and for contributing your testimony. Next, we have Ivelisse Correa, and I believe you are the last witness this evening.
Oh, awesome. Thank you very much for letting me back on. I'd like to thank the committee for allowing me to speak. I'll be speaking on a couple bills. First, beginning with you guys can hear me okay, right?
Loud and clear.
All right, perfect. First, starting with 389A, enact right, there we go. Enact concerning ranked choice voting. I'm tired of the same people being elected into office and have concerns that the median age in Connecticut is 41, but most elected officials are over 55. Connecticut has one of the most restrictive processes in Connecticut, or not in Connecticut, in the country for primary elections. And anyone who is pushing back on ranked choice voting should really look at Georgia and their successes, which is, why they hold runoffs. I'm also speaking in favor of 5702. Never mind that 40% of incarcerated inmates aren't convicted and under our Constitution considered innocent. But as long as there are people sitting in prison for nonviolent drug offenses, we're disenfranchising Black and Brown people. Court Support Services Division, also called CSSD, has logs of convictions for cannabis, yet prosecutors falsely claim they cannot find and release everyone convicted despite the statewide requirement to report to CSSD for all programs. I'm also speaking in favor of SB 1158 and feel it's a step in the right direction and stand in support with the Bosnian community. I simply ask that we also designate May 9th in honor of John Brown, who was born in Torrington, Connecticut, in order to tip our hats to the proud history of slavery abolition in the state. As for mandatory voting, the 15th Amendment would actually support mandatory voting, and I'm concerned that so many people have quoted the rights without actually knowing them. While I would not support a financial penalty, I do believe we should offer more of a carrot than a stick by offering incentives for voting, which is offered in other states. Finally, I'm also speaking in favor of SB 390, an act concerning pizza as the state food. I would ask that anyone opposed to this bill go to Bros Dough, Campus Pizza, or George's Pizza in Hartford, Frank Pepe's in New Haven, or Danny's Pizza in Enfield. We just happen to do it better in Connecticut and feel that pizza should be the state food. And if the committee have any questions, I'm happy to answer them.
Thank you very much, Ms. Correa, and we appreciate you ending what looks like ending the public hearing testimony with that high key energy. Are there any questions from the committee? Seeing none and seeing no further witnesses on our list, we appreciate your testimony, and I declare this public hearing of the Government Administration and Elections Committee closed.
You guys have a good night.
You too. One more note before we close. I just wanted to say, I'm sure Senator Flexer may have something to say on this as well, but we just appreciate especially all the personal and emotional testimony we heard today from survivors of the Bosnian genocide. We don't take it lightly, the effort that it took for you all to come here, whether virtually or physically, and share your stories of yourselves and your families. And we appreciate it very much. So thank you to everyone who testified, but especially those people who shared those very personal stories of hardship and trauma. We do appreciate it. Do you want to say? And with that, this public hearing is closed.